Silence.
Fresh matters.
All fresh matters to the court officer.
Fresh matters kodi.
With a lot.
My lord's kind permission.
JMFC matter? No, it's a fresh matter. Give it to the court officer.
Kodi.
If my lords permit.
Yes. Give it to the court officer, all fresh matters, yes.
Fresh matters kodi.
Fresh matter. Yes. 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 Yes, next week. Yes.
Next week.
File the writ petition. When did you file the writ petition? Which month? So it can wait for a week. Yes. You see, simple matters are 120, 130. Whether I'll complete it or not is a question. We will see. We will see, Mr. Counsel. Please give it to the court officer. Yes.
JNCPC matter, my lord.
Huh?
JNCPC matter, my lord. Your appellate court judgment is held up because of the granted by this honorable. This honorable court already cleared that it affect the passing of the judgment. Even then the court is not passing.
So what are we supposed to do now?
My lord, after passing that order, again the interim order was passed by the two orders. Consider, my lord. Next week, immediately can be.
Yes. No, this matter next week, it won't be possible a week thereafter. Yes.
Take of Friday, number 4, my lord, registered. The name of the petitioner, same name, so I challenge the registration of the respondent. So in the name of the petitioner.
If you're mentioning, you have to tell the court first, which year is the writ petition?
Writ petition 25, my lord, notice has issued, served already.
Yes, it will
Election
come,
is
it will come.
February is the election.
It will
my
come
lord.
a
Kindly have
week,
it 27, my lord, kindly have it.
a week thereafter. Yes.
Please.
Yes. Yes.
Which one?
Matter, my lord. JNCPC.
Huh? Yes.
One pending matter, my lords. GM, my lords, religious matter. I'm the, my lords, hereditary trustee of a temple. My lords, the temple is notified under the new act. But under the new act, my lords, there's no power, my lords, vested with the executive officer. Since I'm a hereditary trustee, to appoint, my lords, any other persons as, my lords, the ancillary. My lords, the order was passed on, my lords, June 2025. I filed the petition in the month of July. They were on K-wait. Respondents were on K-wait. My lords, subsequently, 2-3 orders are.
Yes, next.
My lords,
February.
no, my lords, the 25th onwards, the fair, my lords, annual jatra is, my lords, commencing. And, my lords, all sorts of, my lords, obstacles, my lords, have been faced. Pleadings are completed. And, my lords,
Court has no
may I
time to
request,
take. Court has no time. Yes.
no, my lords, the urgency is that, my lords, there is all possibility, my lords, that, my lords, the religious festival which will commence on.
You should have done it much.
No, my lords, the matters were being listed, my lords, regularly. Due to paucity of time, my lords, it could not be heard before the earlier bench.
The same thing will happen in the.
I'll take a chance, my lords. May I request, my lords, either tomorrow or day after tomorrow.
What you want, list this matter on 27th.
Please, my lords, highly obliged.
Two requests for withdrawal, my lord.
What I'm saying is,
Allala.
all of you, every day, this big line of mentions without any purpose, please don't do it. You will be wasting the court's time, nothing else. Because if you make a mention, I'll list the matters. What is the purpose without completing the list? So unless and until it is urgent, please don't make a mention. Once all these urgent matters are done, I will be taking up in a seriatim right from the old matters. So in the pending matters, unless and until there is a dire urgency, please don't mention. Call the list.
My lords, one pending matter, my lords, may kindly permitted to mention.
27th election is the cooperative society. My name is deleted from the provisional final list.
When was your name deleted?
Lordship, just now on 14/2 they have announced Reject 14-2 Lordship.
14?
Sorry, 14-1 Lordship.
Uh,
Now 28th the election is there, cooperative society.
Yes,
Lordship.
tomorrow. Please call the list.
Page wise adjournments. Page number 9.
Orders
From
don't call.
admission.
Please don't call.
From
order,
admission. From admission. Page number 9, serial number 32. Page number 10, serial number 33 to 38.
My lord, serial number 36, my lords.
36.
There is one more matter. Insurance company has also filed appeal, my lords.
My good.
List along with that next week.
My lords, it's a date given 23/1.
Huh?
Company appeal was the date given, my lords, 23/1.
List along with that on the day.
Please, my lords.
Balance serial number 37. Response number 2 is IFCO Tokyo. RR Mane may kindly be directed to take notice and it may refer to Lok Adalati, Your Lordship.
Who is the counsel for IFCO Tokyo?
RR Mane.
So and so is directed to take notice on behalf of R2 Insurance Company
And
at the request
refer
of
to
the
Lok.
counsel of the petitioner. Appellant place this matter before the Lok Adalat. Yes, next.
Please.
Number 11, serial number 39 to 46.
Serial number 39, my lord, I may be permitted to withdraw.
Memo is filed.
Memo.
Please.
Memo ಕೊಡಿ. ಪುಟಮ್ಮ.
Memo is filed seeking to withdraw the writ petition. It is stated that they have questioned the auction which was scheduled to be held on 25/10/2023 and no auction was held. Hence the petition wants to withdraw the petition. Memo is taken on record.
Liberty may
Dismissal
be
withdrawn.
reserved. Liberty may be reserved. In case subsequent.
Liberty is not required there because that auction, in case if the bank issues the society issues a auction notification, the petition is at liberty to assign the same. Yes.
My lord, 42 weeks time may be granted.
Why?
I am not
Yes, sir.
feeling well.
Huh?
I am not feeling.
Does this matter on 18th of February?
18th February.
Yes, at the request of non-counsel, the petition.
Page number 12, serial number 47 to 55.
Serial number 46, my lord. My request on 28, no, other side council is here. My lord. 46.
Arunel Nilopan.
Please. I can't give you a short date. There should be a reason for adjournment.
Yes, 28, my lord.
No, list this matter on 25th of February.
My lordship, there is an urgency, my lordship. I represent the petitioner in this.
Every matter can't come up every day and I can't.
My lordship, it
complete
is
the
very
list
short,
like
but I have asked for allotment of retail outlet to me in my name. It is rejected for
this.
sir.
On 5th of February,
Grateful, my lordship.
at the request of non-counsel, the respondent.
Page number 12, serial number 47 to 55.
My lord,
Yes,
Page number 13, serial number 56 to 64.
my lord, 57, 58, 59, 71, 83 is the issue pertaining to the limitation. Yesterday, the two matters were posted on Monday. We will club it and we will argue the matter.
57,
57.
57, 58, 59, 71, 83.
71 and 83, yes.
83.
Along with so and so, give that number,
No, Monday may be posted, madam.
Monday. It's
Monday,
coming up on Monday.
Monday.
Yes, Monday.
Monday 26. 27.
Yes,
Page number 14, serial number 65 to 72. Page number 15, serial number 73 to 81. Page number 16, serial number 82 to 89.
89, my lord, I appear for the petition, my lord, seek to withdraw the petition, my lord. My colleague is present
Memo.
take that.
Memo ಕೊಡಿ.
with liberty, my lord.
No, why do you want to withdraw? Why do you want to file a fresh petition?
The reason is this, my lord, pursuant to, my lord, the cabinet decision, certain communications have taken place. And now, my lord, if I could be candid, certain petitioners, my lord, want to withdraw the petition because, my lord, there have been oral instructions not to prosecute the case, my lord. Also, I could not mention in the memo, my lord, I'm bringing to lordship's notice. I'm only seeking liberty, my lord. There may be chance, my lord, I may not file a fresh petition, my lord.
Unnecessarily create confusion. Why we are giving liberty? What is this? We will see when this matter reaches. Yes, next. This.
Page number 17, serial number 90 to 95.
Serial number 93, my lords.
90?
93.
Ravi Hegade.
So, counsel on record undergone surgery, my lord. May I request weeks time? in
Dattatreya
this
T.
matter?
Hebbar.
I informed the other side.
Yes, at the request, list this matter after 3 weeks.
3 weeks.
94 my lord.
Hmm.
All annexed in Kannada my lord. Judgment also Kannada my lord. So find a translation.
MC Hukkeri?
2 week time now.
Have you informed the other side?
I am informed.
MC Hukkeri responded.
Don't make a mention without informing the other side. We will see when the matter reaches.
Please.
Yes.
Page number 18, serial number 96 to 100. Page number 19, 101 to 106. Page number 20, 107 to 109. Page number 21, 110 to 112. List number 2.
We will call list number 2.
Perhaps,
List
submission.
number 3, refer to the mediation.
List number 2, serial number 11, my lord. The matter is pertaining for work. The already date was given on 23rd. The same similar matter is given please in 23rd one.
Which one?
Connected 11, serial number 11,
Hmm.
11.1 and 11.2. List 2, my lord.
11 and 12.
No, my lord. 11 and 11.1, 11.2.
Hmm.
Please. On 23rd.
Anna Sahib Salgar.
Connected matters are posted to
23rd.
23rd.
Yes.
This is the matters on 23rd. Yes. Third list, refer to the mediation.
Serial number 1.
Yes.
Quinta Pickles.
Hmm? Which one? In which matter? Oh. Then why they have prepared this list for mediation? No, I think these are all matters pertaining to some RTC or something. In your. Pasappa, son of oh God. Then why did they prepare this list? 1 to 6 delete from the list. Ask Registrar Judicial why this list is prepared without even notice to the respondent. 1 to 6 delete from the list. Remaining matters refer to the Lok Adalat. Defer to the mediation. Yes, call the list.
My lords, one submission, serial number 46 under list number 1. My lords is pleased to give date on 5th of February. Instead of that, may I request on 3rd of February? My lords is pleased to grant time on 5th of February. Instead of that, I am requesting on 3rd of February.
Yes, 3rd of February.
Much obliged.
Serial number 12 and 13 in the third. Serial number 12 and 13 in the
Of which list?
third list, my lord. Third list, referring matters to Lok Adalat, my lord. The exercise was done like 3 times, my lord. It was not settled. The writ petition has to be allowed. I mean, I am for respondent. It may be taken up for hearing, my lord. It has to be allowed. There is a
12 and 13.
12 and 13, my lord.
12 and 13 delete from this list.
12 and 16, my lord. 12 and 16.
This 12.
Yes, yes.
16.
12 and
12
16.
and 13. 12, 13 and 14.
12 and 16, my lord.
12 and 16.
And 16.
16, you are not the petitioner.
Saurabh
I'm for
Hegde
the respondent.
For respondent. Saurabh Hegde for respondent.
Saurabh Hegde. 12 and 16.
Then what about the other matters they can go? 13,
Other matters,
14 and-
I'm not there. I'm not there. I am.
Yes, 12 and 16 delete from the list.
Lord, it may be taken up tomorrow. Writ petition has to be allowed. I am for the respondent.
Court has no time, Mr. Counsel. That's, we can't take up now.
Any date may be given. my
We
lord.
will see. That's only listed for the limited purpose of referring the matters to the mediation. Call the list.
My lord,
List number one?
list number 2, my lord,
What's-
serial number 20. This is little urgency. It may be taken at 2:30, my lord. The list number 2, serial number 20. There's a little urgency. It may be taken at 2:30, my lord. Otherwise, it may not reach, my lord.
No, it will reach. I will not take anything at 2:30. Please call the list.
My lordship, one permission.
Number 1. Serial number 1. Orders matters.
Can't keep on going front, back and all. Yes.
Serial number 1. Orders matters. M. Dharigon.
I prepare the petition.
Give the file.
Yesterday I filed application for dispensation. Yesterday I filed application for dispensation. That is not put up, my lord. In so far order dated 25/10/2024 is concerned. The certified copy of Annex AD is not,
No, first of all, you please argue
Please,
on the
please.
maintainability of the writ.
it is maintainable, my lord, on two reasons. One is Malad, the management of that trust is Malad, the deputy commissioner.
But is he exercising the jurisdiction or passing any orders as as an officer of the endowment department? No. I have already passed an order in another writ petition relegating the parties to the civil court because it is a private trust. Just because the endowment personnel from the endowment is an ex officio member, as per some what is that is passed by some arrangement made, it will not take the character of a public trust.
In so far, two categories, Malad. One is private right, one is Malad public right. Public right, Malad, public right is concerned, Malad, it is maintainable.
What is private right? What is public right?
Malad, in this case, but the trust pass a resolution.
Please understand.
Please.
Whether this comes under Article 12 and then only a writ petition is maintainable.
How?
How it
Please.
will come under Article 12?
Malad, because Malad, management of the deputy commissioner.
Notified by the endowment as a public charitable trust. It is a private trust. Just because the commissioner, the so-and-so from a department is an ex officio member, it will not take the character of a public trust unless it is notified under the Endowment Act. That is settled law. It can't. I have already passed an order. What is that number? Please give him that order that's already uploaded. Give him that number. Afternoon, I'll take up this matter.
He become kind of tomorrow, Malad. I will also search.
Oh, search.
Tomorrow, Malad. Tomorrow, Malad.
How many matters have to come again and again? Please understand the difficulty of the court also. Yes, give him that judgment. Yes,
With respect to 1.1 minute connected matter, I appear for the petitioner in this matter, my lord. My matter is connected to this matter, my lord. My claim is different from the claim of the first petitioner, the first matter, my lord.
Whatever is the claim, if you are seeking anything against the trust,
Please.
then the writ is not maintainable. Please argue in the afternoon. Yes.
May I request for 1 week time in the connected matter?
Number two.
Tomorrow we will.
Yes, from yesterday it has come to today. From today tomorrow, why should we do it? Because court has no time. I'll hear it today. You please argue. Two.
Seal number 2. Gracious Hiremat.
Lord, I appear on behalf of the petitioner, Lord, and applications to bring the legal heirs of respondent number 3. I have 1 to 3 of 20.
Effect of R1.
My lord, R1 3 times notice have been.
Then profile an application for
Please,
substitute service.
and one more submission that my lord, initially there was an order to serve the copy to the counsel who appears before the court. But we have filed a memo that he is not ready to accept and it is refused.
Petitioner shall take appropriate steps, shall come up with an appropriate application in respect of R1. This is matter next week.
My lord, notice has to be.
Matter on 29th of January.
Notice insofar as respondent number 3, I have application to bring legal heirs is filed, my lord. I have one.
We will deal with along with that. Yes, 3.
My lord, one submission. Suit is of the year 2007. Based on the compromise decree which had entered in the 2010, for the first time in the year 2020, an application is filed to recall that compromise which was entered. That applications have been allowed and the present petition is filed.
We'll see. First of all, file a substitute service application.
Please.
Yes, 3.
Seal number 3. Yes.
My lord, the petitioner had filed an application for demarcating the land, my lord.
What is this report complaints?
My lord, they say that the survey numbers have changed and the new survey will be done based on the new number, my lord. So they said that whether we can file an application for 11E map on the basis of the new survey number or the old survey number. That clarification was required to be made by the respondent, my lord.
What are your instructions?
Your Lordship, they will conduct the survey, Your Lordship, but irrespective, as earlier order has been passed by this honorable court.
16/12/2025.
Please, Your
The
Lordship.
submission is the process of carrying out extensive survey is on.
Please, Your Lordship.
The petitioner's application would be considered and appropriate measures will be taken at the earliest. What
It takes some more time, Your Lordship. That is the reason.
My lord, my application is pending from last 2 years.
No, there should be, what is that sometime?
Because it is a huge land, Your Lordship.
You have to get instructions on this. There can't be the submission like this every time the matter comes. If an application is pending from 2 years, you should have done something by this time. Or if not, you have done, when you are going to do, there should be some definite timeline.
Time boundaries.
Get instructions. The land counsel for the petitioner submits that his application is pending from the last 2 years and the respondents have not taken up the survey, Leonard HCGP submits that, it would take some time. The respondents cannot keep the application pending eternally. They should be the learned counsel shall get specific instructions. What is the timeline that is required to complete the survey? Let this matter on 5th of February.
5th February.
Yes.
Seal number 4. P. Sharana Basava.
Please, Your Lordship, we will file the certified copy of judgment and award today itself, Your Lordship.
You filed or you're filing today?
We will file today itself, Your Lordship.
Submitted that the certified copies of the impugned award will be filed in the course of the day.
Please, Your Lordship.
Yes.
Much obliged.
Seal number 5. Srinivas B. Nayak.
Office has raised, Lord, office has raised office
Maintainability.
objection regarding maintainability of the
What is this
Lord.
writ petition about?
Lord, writ petition is filed, Lord, challenging the order passed by the Lord trial court in refusing to register the suit. When the suit is filed, court suo motu, Lord, exercise the jurisdiction under Order 7 Rule 11, and Lord, come to the conclusion that there is since Lord, there is no cause of action and
The suit is not maintainable.
no court suo motu
That's what.
before registration
No,
of the suit itself.
Where it is under Order 7 Rule 11.
Yes.
The court has rejected your claim. Whether that it is legal or not, you have to test it in appeal, not in a writ
No,
petition.
because what happens is, your Lordship may kindly see, before registration of the suit,
No.
before registration of the suit,
Let us assume that it's an illegality committed by the court. But you can test it only in an appeal, not before.
no, my only submission is, your Lordship may kindly see page 24.
Page?
24, operative portion of the order.
Yes. We have to look at what is the consequences of that order.
No, consequences,
Consequence of that order
my
is
submission is,
pending.
my submission would be, Lord, unless until Lord, Lord, suit is registered, Lord, court cannot, Lord, suo motu exercise jurisdiction under 7A.
No, I understand your point.
Yes.
What I'm saying is, if some order is passed, suit is dismissed. Suit is dismissed. Court, without considering whatever it is and without any jurisdiction, without any power, court has dismissed the suit. Will a writ petition lie because that is an illegal
No, that
order?
is why I just want to point out one thing. Your Lordship may kindly see page 24.
24, page number.
Page 24, in the operative portion of the order, the prayer of the plaintiff seeking registration of the suit is hereby rejected.
So the consequences of that order is, your
Yes.
suit is rejected. You should go in appeal. Please come.
I'll just, Lord, convert it to, Lord, may I permit it?
The appeal also lies to this court.
Yes.
The office has raised objection with regard to maintainability, as a petitioner had questioned an order that is passed by the trial court under Order 7 to 11A of the CPC. Then
No.
counsel for
Appeal lies to the district court. I may be permitted.
the CPC. Then counsel appearing for the petitioner submits that even before the case is registered, the court had passed this order suo motu, and the court has no there's no such powers are vested with the court to pass the order. As such, the present writ petition is filed before this court. Next part, this court is not able to appreciate the said submission as when the order is passed by the court under Order 7 Rule 11A and rejected the plaint, the remedy available to the petitioner is to prefer a regular appeal, but not a writ petition under 227 of the Constitution of India. The office objection with regard to maintainability is upheld. The petitioner, the writ petition is disposed of, giving liberty to the petitioner to avail the appropriate remedy within 2 weeks from the date of receipt of the copy of the order.
Section 14 may.
Seal number 6.
Benefit of section 14,
The petitioner will have the benefit of the section 14 of the limitation.
please.
Seal number 6. Preeti Shashank.
My lords. As per court order, my lords, already 50% award amount deposited before the tribunal, my lords. Within 2 days, we file acknowledgement, my lords.
Why you are taking this much of time to file the acknowledgement?
My lords,
It can't be for months. In every MFA, this kind of, the petitioner shall file the acknowledgement having deposited the amount as per the order dated 4/11/2025 by 5th of February, or else the stay granted by this court stands vacated.
My lords,
Seal number 7.
already deposited, my lords, in tribunal, my lords.
You should file a depo. How will we know that you're
My lords,
deposited?
within a 2 days, my lords. During the course, I have filed, my lords.
No, that's why I gave you time till 5th February to file that memo. You didn't understand what the court said. You have time till February 5th to file the memo.
Please,
If you
my lord.
don't file by
Please,
February
please,
5th.
please, my lord.
7.
Seal number 7. Sadiq Kanvi, DL Lord Khan.
My lords, in this case, my lords, there are two Kannada documents are there that need to be filed, updated copy. My lords. Maybe a specific date we can fix, my lords. So the Kannada documents.
Who moved the memo? You moved the memo.
Yes, my lords.
Then having moved the memo, you should also do what is supposed to be
On
done.
23, my lords.
This is matter on 6th of February. Yes.
Please.
Seal number 8. Seal number 8.
In this matter, why a memo is moved in 8? 8, who moved the memo?
Yes, I moved the memo.
What is urgency?
Yes, urgency is this brought on 28th of September, election was conducted.
No, R5 notice is not served so
My
far.
lords,
Yes, personally, I have served as per the order of
may I
this honorable
submit?
court.
I undertake to file wakalat on
On
behalf of
behalf of?
R5.
So and so submits that he has instructions to file wakalat on behalf of R5. You have the writ petition, the copies are served on you?
No, ma'am.
The petition shall serve the copy of the writ petition on the council for R5. List this matter on 29.
29.
Yes, sir.
Seal number 9. PM Party.
Petitioner.
Yes.
I have moved the matter before the court for
Maintainability of
maintainability. I will come to the page number 53, my lord.
What is the order impugned?
It was dismissed for default to lead a evidence of the, my lord, petitioner. On the same day, my lord, dismissed for default, I filed an application, I number 5, for a discharge of guardian, and also, my lord, restoration of the same dismissal. That has been, my lord, the court has rejected. Your lordship, kindly page number 54 and 53 bottom.
You file a miscellaneous appeal against that.
Yes, that is correct. But summary proceedings, my lord, MEC, summary proceeding, it is not under CPC. Summary proceeding, my lord, that can be restored and.
No. Please satisfy the court. How is it?
No, appeal, my lord.
Anything out of MBC?
MEC, my lord.
Let's see where is that impugned order.
My lord, your lordship, kindly typed copy, my lord, 54. 54, my lord. '54 and 53 bottom. 53 bottom. 29/7/25. Case is called out. Petitioner is absent. Already has been posted for evidence for the petitioner as cost. Even the petitioner is not ready to lead evidence. Under these circumstances, prayer of so and so, advocate behalf of the petitioner is already rejected. The petitioner of the petition is hereby dismissed for non-prosecution.
The issue with regard to the maintainability is kept open. Issue notice to the respondent.
Please.
Issue notice. Seal number 10.
Yes.
14 person.
Yes.
Timothy Wani.
Yes. Notice is not yet to be, is not served.
It's served. ma'am.
Mahesham, who appears? Where is the council?
Mahesham.
Today I think they haven't come, ma'am.
Which page number is impugned order?
Impugned order.
Interim order. It's page number 87 of.
87.
Michael here. Michael.
Court had awarded 30,000 per month as interim maintenance.
Yes, my lord. It's actually very insufficient, madam, considering like myself and my son living in a rental house, having no amenities, no
What is the
furnishing.
income of your husband?
He's earning around 70 lakhs per annum. Apart from that, he has multiple fixed deposits, his shares and
Where do you
mutual funds.
get it? Where is it discussed by the court with
Yes,
regard to the income of the husband?
It's in memo dated 15th December.
This
In
order.
page number 2B, ma'am.
Order.
Order in is page number 88.
Paragraph number 9.
So page number 88 of writ petition, their honorable court had mentioned that his earning is 3.5 lakhs per month and having passive source of income of 2 lakhs per month.
To paragraph number 9 of the impugned order.
Yes, ma'am. That is 45 line. Right. Currently, he has changed the company, madam, in October. So he hasn't disclosed his actual employment details. So just this October, I got to know he has changed the company to Global India GSK firm, which I have furnished to court in memo dated 15th December, page 2B.
Where is your statement of assets and liabilities? Your statement.
Mine is. Mine and husband's. Assets. It's respondents' income and assets have been furnished in
Your
mine.
requirement.
Okay, mine.
Where is your requirement?
Where it is. At this page number 254 of writ petition, I have enclosed the SBI bank statements in my ITR documents, page 281.
Is that which page is the impugned order?
Ma'am?
Which page is the impugned order?
Impugned order.
Yes, I've seen it.
It's page 87. My lord, can I just take 2 minutes to brief you my case?
Who appears for the respondent?
Mahesh,
Please come.
Mahesh, come.
Agreed with the order passed and I number 2 in criminal miscellaneous number 383 of 2024 dated 23rd May 2025. The wife is before this court. The parties are referred to as wife and husband for the sake of convenience. The petition herein was who appeared as a party in person before this court had filed a criminal miscellaneous 383 of 2024 seeking maintenance. What you sought is 50,000.
Yes, ma'am. Actually, we had kept a lawyer. So on behalf of him, he has asked me to like put a petition on this for asking for 80,000 starting. But that 80,000 itself was not sufficient, ma'am.
No. Order reads you sought for only 50,000.
No, madam. We are getting 30,000. That too for few months only I got.
No. You say your expenditure is about 80,000.
Yes, ma'am.
You sought for 50,000.
Interior maintenance was, yeah.
What you are
we
entitled is
requested
only
for-
for that, not more than that.
But actually the expenses are more, ma'am.
But who
Just
asked you to
initial-
say 50,000?
Just initial approximate we had given, ma'am. But after coming here,
At least have you filed any other petition, any other affidavit or anything to say to enhance that my expense? I don't want 50, I want more.
yes, ma'am. I actually requested the honorable court there in family court. She told me that it's not possible here itself because she herself has given the orders. So while consulting a lawyer, they told me that I
Here,
need.
before this court.
Yes, ma'am. But before coming here, the lawyer told me to file a writ petition in the High Court for the enhancement. Enhancement will not happen in family court. I was told that.
The difficulty of the court is you asked for 50,000. Your
Just as interim,
your
yes.
expenditure according to you are about 80,000. The court cannot grant you 80,000, but it would be more, it can't be more than 50,000 because that's what you want. Beyond your prayer, why should we grant?
Yes, ma'am. Just like with the lawyer itself, what he suggested, I had,
But all that we will not consider what the lawyer suggested, what you did, because you are educated, you have done your
Yes,
BE computers.
BE computer science,
Then you
correct,
know
ma'am.
what is that, what are the implications of like saying that I want only 50,000. Having asked for 50,000, court will not grant you 80,000.
No, interim it was, yeah, interim it was asked for 50,000, but even that wasn't granted, ma'am.
No, that I will grant, not 80,000 as you are seeking.
No, ma'am.
If there was such a request, then we would have.
Actually, ma'am, considering the expenses, even 80,000, I feel less, ma'am. I have shared the expenses.
No, it is not for the court to say, it is for you to ask.
Yes, ma'am, I'm requesting the honorable court to grant, ma'am. Just at least, please.
I can't grant it. The petitioner has filed IA number 2 and IA number 2 seeking interim maintenance of an amount of rupees 50,000 per month.
Actually, ma'am, I was working earlier. My entire earnings, including PF and gratuity, has been taken away by my husband.
The 125 CRPC proceedings are filed seeking maintenance of an amount of rupees 81,400, and the IA is filed seeking maintenance of 50,000 per month. It is a case that the husband had willfully and deliberately neglected her and her child. When she was at the matrimonial home, she was subjected to mental and physical cruelty. According to her, he was working as an engineer in a multinational company and earning 3,50,000 per month, and also having passive source of income up to 2 lakh per month and capable to pay the maintenance amount.
Madam, right now we are staying in rental house from past 1.5 years,
Please
ma'am.
understand, that's why you require an advocate. Now, we can't grant anything beyond what you have. Now it is, you are questioning an order that is passed by the court.
Yes, ma'am.
Where you sought 50,000. Court has granted 30,000. I can grant you 50,000, but not above.
Ma'am, 50,000 itself is very less, ma'am, considering the expenses.
Why did you ask?
Because later on I was told that I can get for the enhancement.
Where is that application?
Application is not there, but orally I asked the honorable court. She told.
Legally permissible, please understand and don't waste the court's time. What did you write? Huh? Any multinational company and that is done. The respondent has filed his objection. And he stated that he never refused or neglected to maintain the wife.
Madam, I can provide an application, ma'am, for the enhancement. Please, please.
Not before this court on that enhancement. You are not coming directly to the court. You are questioning before the court an order that is passed by the family
ma'am.
court. So that is only the
So
scope
their
of this.
enhancement was not possible, ma'am. So I have asked.
I'll give you that liberty. I'll give you that liberty. He never refused or neglected to maintain his wife and child.
Ma'am, actually request is to quash the earlier order and to provide the enhanced maintenance from the date of filing.
Ask that.
Ma'am, that 30 is highly insufficient, ma'am, considering this rental
If you say I
house.
can't pass any order, I'll exempt this matter.
Please,
That's the
ma'am.
only thing. Do whatever you want to do. Yes, this is matter after 2 weeks.
2 weeks.
Yes. Next.
Seal number 11.
Ma'am, please, ma'am. Also, my MC case is pending in family court. Please keep it for abeyance, ma'am.
What? Everything should be done now by this
No,
court.
I'm just requesting the prayer, ma'am.
Please understand, all these things can't be done by the court. If you want maintenance.
Please, my lord. I appear for petitioner seeking a mandamus
11.
mandamus to pass consent award as per the government order. Yesterday, your lordship heard at length.
Yesterday, matter was heard by this honorable court and the date was
The-
fixed on 2nd February. Matter is posted on 2nd February, your lordship.
This is the farmers are seeking a enhancement.
This is along with, in this matter also, the AHE shall get instructions.
Please, your lordship.
And also,
It's along
see,
with, give that number. List
please,
along with so and
please,
so.
my lord. Please, my lord. Then your lordship kindly 104, same list, my lord, 104, same matter, identical matter.
104 also on the day.
Please, I'll furnish the number.
Yes. Yes, well.
2nd February. Seal number 12.
Madam, can you please put the date for next 27th?
But what is going to happen on 27th? You will not get any relief from this court except that 50,000 which you are seeking, I can grant. Nothing else can be done here.
So I need to request there itself, ma'am.
Yes. That's why you engage an advocate. You will not know what are the, the implications of anything.
Actually, after consulting advocate itself, just as he said, I'm just following his advices.
So what I do is I'll grant you 50,000 as maintenance. I will set aside that order and grant you 50,000 and will give you liberty to seek any enhancement if required.
In the lower court.
In the lower court. That can't be done here. And staying the MC and all will not happen in this. You file a judgment.
Yes, ma'am, it's your
Yes, my
judgment,
judgment
yes,
only.
ma'am.
But in that, the facts are different. It can be stayed provided he is not paying you the maintenance.
Yes, ma'am, so many months maintenance he hasn't paid.
It is not, you have to move that application before the trial court. Under 151 saying that he is not paying, so stall the proceedings. MC proceedings shall be stalled. So that can't be done by this court. If the court doesn't do, then you can come here.
Okay, because
You want the court to pass that order of 50,000?
Okay, ma'am. At least from the starting of filing of the application.
It will be from that day only.
Can it be made to 80,000 at least? Not possible. Because I have taken.
It can't happen. Let's not have any discussion on that now. What did you write? Yeah. And the wife. You can open it. You open it. The husband and the wife under the influence of one such proclaimed godman, astrologer, and believing his ill advice of her father, without understanding the reality of life in 2016, causing untold strain in the marital relationship. It is stated that flats at Srirama Smriti Apartments was purchased in joint names, and entire sale consideration and expenses and bank's EMI are paid by him. The wife has suppressed several true facts and filed false petition and not approached the court with clean hands. As such, she is not entitled for maintenance. The family court, by order impugned, had granted maintenance of an amount of rupees 30,000. While granting the maintenance, the court has observed that there is no dispute regarding the relationship between the petitioner and the respondent, and out of the wedlock, one son was born, and now it is, and the qualification of the petitioner is BE Computers. She has stated her requirement per month is about 81,400. Child is 10 years old. Respondent qualification is BE Electrical and his earning is shown as rupees 45 lakhs per annum. The petitioner has not produced any bank statement. And the respondent has filed the assets and liabilities. He has shown his general monthly expenses rupees 2,35,547 and also shown the liability of EMI of rupees 64,000 per month. His mother is housewife and father is pensioner, and he has given details regarding payment of his rent to the house and other expenses. And he has also shown the medical insurance policy in the name of his wife and son, paying 66,870. And also about the ill health of his father and mother. It is also stated that he is voluntarily paying 12,000 per month for the education of the child. And also filed the salary certificate that he is earning 3,89,000. The court has observed that both parents or both parties were highly qualified and educated person, and they have to look after the welfare of the child as per their status and provide education in reputed school. It's a duty of both the parents. You work?
No, ma'am. It's been almost 6.5 years. I had to quit the job because of his harassment.
Both the parents to take care of the child as well as its welfare. The petition number 1 is taking care of the child and giving moral support to the child. At this stage, the welfare and interest of the child has to be looked into. Therefore, considering the qualification of the respondent, minimum requirement has to be fulfilled to the child being a father. Therefore, the court had awarded 30,000 per month. Agreed thereby, the wife is before this court. Next para. The party in person, wife submits that when the husband, earlier the husband's income is 4 lakhs per month. Now it is?
Now it is around 70 lakhs per year.
40 lakhs per month. Now it is?
70 lakhs per year.
It is 40 lakhs per annum earlier. Now it is 70 lakhs per annum. It is submitted that at the advice of though her expenses are 80,000 and odd, at the advice of the advocate, it is stated that she sought for interim maintenance of 50,000. It is submitted that when the husband is earning sufficiently and he has a responsibility to take care of the child and the wife, it is submitted that the husband is not regular in paying the maintenance because of her family responsibilities. Though she did her BE Computers 6.5 years ago, she had she could not continue. She quit her job. She is living in a rented premises. and she has to take care of the responsibility of the child. She has to take care of the child and herself. When the husband is getting the salary of an amount of rupees 4 lakh per annum, 40 lakhs per annum as on the date the application is filed, the court had granted 30,000 as maintenance. What are the school expenses of the child?
It's more than 1 lakh per year, ma'am.
1 lakh?
Per year. Fees itself is 70,000.
It is submitted that the expenses.
And apart
of the
from
child,
that, bus and
1 lakh
other
per annum.
charges.
And as in spite of the fact the fact that the expenses are 1 lakh, as the advocate has mentioned it as 50,000. And now, as she is not getting the proper legal advice, she is appearing before the court as party in person. It is submitted that as per her statement of assets and liabilities, the expenditure as stated as 80,000 may be granted by this court. Next para. Though wakalat is filed on behalf of the respondent, there is no representation on behalf of the respondent. Having heard the next para, having heard the party in person, peruse the entire material on record. Even according to the husband, he is earning 3 lakh 80. His salary is 3,89,329 as on that day, and according to him, his monthly expenses of 2,35,547 and the EMI of rupees 64,300. Now certain material is placed before this court by the wife that his salary is increased to 70 lakh per annum. Now at this stage, this court is not going into that aspect. When the respondent's father is a pensioner and he has no responsibility and is earning more than 3,75,000 per month, granting an amount of rupees 30,000 per month to the wife by the family court was not a well considered order. When the wife has stated before the court that her monthly requirement is about 81,400 and the interim application is filed seeking 50,000, that itself strengthens the submission of the party in person that the advocate, though she has stated that her requirement is 81,400, in the petition has stated the same as 50,000. Considering though the wife is educated, she is not employed from the last 6.5 years. The age of the child is?
11 years, ma'am.
The age of the child is 11 years. And as she has been taken care of. Now the education, just because the wife is educated, that cannot be a ground to deny the maintenance to her. In the facts and circumstances where as on 2024, the husband's salary is 70 lakhs, 40 lakhs per annum and around 3,75,000 per month. This court deems it appropriate to grant maintenance of an amount of rupees 81,400 as sought for by the wife. It is submitted that the husband is not regularly paying the maintenance. MC is filed by whom?
By husband.
It is submitted that the husband is not paying the maintenance monthly, and it is submitted that there may be a direction. This court may pass an order staying all further proceedings till he pays the maintenance. This court cannot pass such an order if the husband is not regularly paying the maintenance as per the order passed by the court. The wife is at liberty to file an appropriate application before the family court under section 155 CPC seeking to stay all further proceedings till the maintenance is paid to her. Accordingly, this court is passing the following order. The order dated so-and-so, passed by so-and-so, is set aside, and the amount of maintenance is enhanced from 30,000 to 81,400. That's from the date of the application for interim maintenance.
Thank you, ma'am.
Yes. Call the next part.
Seal number 11. Seal number 12. Seal number 12.
List after service of notice.
It's awaiting service of notice.
List after service of
Please,
notice.
interim orders.
All interim orders, wherever they are there, they will be.
Interim orders.
Yes, next 30.
Seal number 13.
No, so I pay for the petition.
Suraj,
no,
just
sir.
stop.
Filed an affidavit, my lords, as per the directives of this honorable court.
Please, my lords.
Undertaking to pay the entire amount, my lords.
After my lords is one of the borrower, my lords. He has not been served.
Notice to him.
So I apply for the respondent number 1 and 2 bank, my lords.
Notice to R3 be dispensed with, my lords. So he is a surety.
No, have you filed a memo for that?
I'll file it today in the office, my lords.
Yes.
And I've filed an affidavit,
is it?
my lords, as per the directions.
What is this affidavit?
My lords, they are challenging the section 14 order, my lords.
Amount, my lords, within a period of 4 months.
Therein, my lords.
From para 6, my lords, have
Outstanding amount.
Para number 8, my lords.
What is outstanding as on today?
4.3 crores.
25 lakhs 72,000 minutes.
Whatever they say is the amount.
Please, my lords. Agreed amount is 4.25, my lords. But thereafter, unapplied interest and other charges.
And you can, whatever is the amount,
Please, my
you
lords.
please communicate it to him within 2-3 days. Whatever is the amount within 4 weeks, that 4 months, as undertaken before this court, has to be paid.
Please.
My lords, the reason is that, my lords, some of the portion of the loan proceeds were given, my lords, for purchasing of the machineries, which has not been done, my lords. So, along with the machine sellers and these persons, my lords, even though the necessary payment is made, my lords, the machineries have not been delivered and installed, my lords. So there is a
My
loss of
instructions,
security
my
to
lords,
that effect, my lords.
To my instructions, my lords, machineries have been delivered.
Land,
a part of machinery, my lords, which is
So, my
20%
lords,
of.
at least, my lords, if it is reduced to 2 months, my lords, so let them make necessary arrangements, my lords. Because, my lords,
As you say, 4.3 is the outstanding. How can they pay in 1 month, 2 months? When this petition is filed?
December, my
Month
lords.
of December month during the vacations I have filed it.
Already 2 months' time is over, almost.
I will leave it to the court.
Understand.
Some reasonable time, my lords, not the time which has been asked by the
But
petition.
this much of money, 4 months is, the present petition is filed.
And in the absence of the same, my lords, let them hand over the properties, my lords,
Please.
on their own.
I have undertaken.
With that direction, my lords.
The present petition is filed, seeking the following prayer. The on 7/1/2026, a submission is made before this court that the petitions are ready to pay the entire outstanding amount. In that regard, they'll file an undertaking affidavit before this court. Today, the undertaking affidavit is placed before the court. According to the petitioner, the outstanding amount as on today is 4,25,72,000, and within a period of 4 months, they will 4 months from today, they will pay the amount. Failing which, the respondent bank is at liberty to initiate the appropriate proceedings. According to the learned counsel appearing for the bank, the outstanding as on today is 4 lakh.
4.3 crores, nearly about 4.3 crores.
Then we leave it there, whatever amount you can.
Please, my lords,
This is
plus the outstanding, entire outstanding, my lords, it may be taken.
The entire, the land council appearing for the respondent fine submits that the outstanding amount is around 4 crore 30 lakhs. 4 crore 30 lakhs. It is submitted that if the petitioner fails to pay the amount, they shall voluntarily give possession of the property or possession of the secured asset. Land council for the petitioner submits that in case the petitioner fails to pay, they will hand over the fiscal portion pursuant to, as already an order under section 14 of the Surface Act is passed. Next, having had the land councils on either side and considering the affidavit that is filed before this court is passing the following order. The petitioner shall pay an amount of rupees 4 crore 25 lakhs 72,000 oblique entire outstanding amount within 4 weeks or 4 months from today. Number 2, if the petitioner fails to pay the amount, the bank is at liberty to take further steps. Number 3, if the petitioner fails to pay the amount within 4 months from today, he shall voluntarily hand over the possession of the secured asset to the respondent bank accordingly disposed.
Secured assets, movable and immovable, both. Secured assets.
Secured assets, it could be anything. Yes.
Thereafter, my lords, they should not take the advantage that, my lords, only immovable properties are.
I'm not even disputing my liability, my lords, fairly I'm submitting.
Mobile and,
Please.
So we don't have to clarify that. Yes, 14?
Great.
It is submitted that the respondent number 3 is a guarantor.
Guarantor.
And as guarantor, and he is not he is not a necessary party to this petition. He is a formal party. Yes, next. 14.
14. Lord, in this case, the petitioner filed the Lord writ petition challenging annexure L, my Lord.
Who is respondent number 2? Is it necessary or not?
Not necessary.
He is not
He is a JD. Third party application 2197 is under hearing.
So let's see what's the writ petition
I-
about.
Please, may I request the court to pass allow the writ petition with fixing the time, Lord, because they sought for time for evidence. It was rejected and then the order is passed.
Page number 75, my Lord, of annexure L, my Lord.
Raise it further. Raise it further. Furthermore. Page number?
75.
75.
75.
Raise the order.
On perusal of the order sheet, it is noticed to the court that the last opportunity has been granted to the third party on inquiry on I number 2, though they never turned up. Hence, the application is hereby rejected and inquiry on I number 2 is taken as nil, my Lord. My Lord, in this case, the petitioner is a age-old person, my Lord. Hence, the petitioner is a age-old person, third party person, my Lord.
What is this? What is the, where it is arising in execution?
Execution, my Lord.
You are a third party.
Please, my Lord. I filed the application for obstruction, my Lord. In obstruction, my Lord, I filed I number 2 for seeking an adjournment for 15 days, my Lord. As the petitioner is.
So, in execution, when did you file your IA? When did you enter the appearance?
That is on.
28/7/25.
28/7/2025, my Lord.
28/7/2025.
My Lord.
Then?
On 15/11/2025, my Lord,
Hmm.
I filed application under Order 17 Rule 1 for seeking an adjournment, my Lord.
Hmm.
Then, my Lord, this honorable court has, my Lord, rejected the application, my Lord.
What do you say?
Maybe allowed it by fixing some time, my Lord.
What is the time? 1 month?
1 month.
Please.
The agreed by the order dated 15/4/2025. 25, whereby the court had rejected the I rejected I number
15/11/2025.
15/11/2025.
15/11/25, whereby the court had rejected I number 11, I number 2. I number 2 is?
I number 2.
2 is?
2 for us.
2197, 2199.
I number 2, that's filed under order 21/97. The third party is before this court. And counsel for the petitioner, objector submits that when he has filed an IA number 2 under order 21/97, and due to the personal inconvenience, he has filed an application under order 17/1 seeking adjournment for a period of 15 days. The court, without considering any of the grounds that are raised, only on the ground that the DHR has objected for this adjournment, had rejected the request for adjournment, and also had dismissed the IA number as rejected I number 2. It is submitted that the petitioner third party is aged about
84 years.
4 years. And if this application is rejected and the case of the petitioner is not considered, it would cause lot of hardship to the petitioner. Learned counsel appearing for the respondent decree holder submits that the court had given enough opportunity to the petitioner, as the petitioner has not turned up before the court, having left with no other alternative. Court had dismissed the IA number 2. Next para. Having heard the counsels on either side, there is a material on record. The petitioner had filed an application, IA number 2 under order 21/96. And he has come up with an application under order 17/1 seeking adjournment for a period of 15 days. And that itself cannot be a ground for the court to reject the IA number 2, as the rights of the parties have to be determined by the court. The petitioner, having come up with such an application, ought to have proceeded with the matter, balancing the interest of both the parties. This court deems it appropriate to set aside the order dated 15/11/2025 and 25, and the petitioner is given a month's time to complete the court shall dispose of the IA within a period of 1 month from the date of receipt of the copy of the order. The petitioner shall cooperate with the same, or else the court is at liberty to pass appropriate orders.
Please.
And the court shall consider this IA number 2 expedition.
Dispose.
Yes.
Hearing on IA, seal number 15. Yeah, Gachin Bhatt, MB Kanvi.
Petitioner, my lords, is a Ayurvedic college.
Yesterday's matter.
Yesterday's matter, my lords, or announcement of results, my lords. In fact, the petitioner's college, my lords, is being run from 1992.
WP of 2021.
Yes, my lords.
What is impugned in this?
My lords, impugned order is, my lords, the petitioner's college, my lords, is being run from 1992. Right from.
What?
It's a college, my lords. It's being run, my lords, from 1992. My lords, every year, my lords, they are supposed to obtain the permission from the NCISM, my lords, for admitting the students. My lords, they check, my lords, whether all the parameters are met with or not.
College running, what are the courses?
Please, my lords.
What are the courses?
Ayurvedic courses, Ayush course. Then, my lords, from 1992, my lords, till 2020, my lords, they have been consistently given permissions. Earlier, my lords, there were only 30 students, my lords, which were given, and later on, my lords, it was increased to 60, my lords, way back in the year 2013-14. For 21-22, my lords, it was a COVID period, and 22-23, my lords, for 2 years, my lords, they denied the permission. For which, my lords, I approached this honorable court, my lords, there was an interim order of stay, my lords, that was granted, and I was permitted to admit the students.
So, from 21 to 25, on court's permission, you are running the college.
Only for
Whether
2
you
years.
comply with
No,
the
24-25, my lords, again, they got the permission for me. 24-25, I got the permission. 25-26 also, my lord, this year also I got.
What remains to be done?
Only for 2 years, my lords, I could.
Please come to your prayer.
Lord's prayer, my lords, is to set aside the impugned order my lords, to quash the impugned order, my lords, and then to permit the mandamus, my lords, directing to admit the students for 21-22.
That has become infructuous.
Please.
That has become infructuous. You were running the college. You are running the college. for
Running the
21 to
college.
22. So what is to be decided in this?
No, my lords, now, my lords, they, whenever, my lords, the examination comes, my lords, from 21-22, my lords, there was a permission, my lords, for me to admit the students, I admitted. And my lords, they said that, my lords, I need the court's permission, my lords, for them to take up the examination. Then, my lords, that was permitted. The students wrote.
The whole difficulty, why the courts are running the colleges?
Please, my lords.
Why the courts are running the colleges? Now, if there are certain criteria for them to satisfy, if you satisfy.
I have satisfied.
They will permit.
Yes.
There should be an order for that, in the facts and circumstances. But how can it be 21 give permission, 20, then again end of the year, even for writing the exams, court will grant permission.
For announcement of results. Now, my lords, the students have written the examination. For announcement of results, my lords, the IA is filed.
Now, having permitted them to write and having ever let them study in the college, why do you require the court permission for that?
For announcement of results.
It is respond number 5, my lord. I appear for respond number 2 and 3, my lord.
NCSM, respond number 5, my lords, has to answer.
No, come here, court officer. Where is the main writ petition? I'm not able to find. And where is the prayer?
52.
Annexure C, ಅಲ್ಲ sir? Annexure C is impugned order. C is impugned order.
Yes, yes. For subsequent years, my lords, again, the permission is granted to me.
But how can you run the college like this?
My lords, it's only for
court interfere.
that
No,
academic year, my lords,
you have
21-22.
No, there should have been an inquiry,
Please.
whether you're fulfilling it or not. Just like that, why should the court direct them to, give you permission to take the
Yes, I
children?
submitted, my lords, all the records and the necessary details. Now that students, my lords, have written the examinations, my lords, results needs to be announced, my lords, and then they should be permitted to take up the supplementary examinations for the students.
That's what the Supreme Court is deprecating, this practice of these kind of orders from the High Court. Now, if some order is passed by the court, neither the children are here, and the students are neither here nor there. Unless, without even deciding whether you're fulfilling the criteria fixed by
Not
the.
fulfilled, my lords.
How, where is it decided that whether you are fulfilled? Without that, you have been granted permission to take the children.
The only contention is that, my lord, there was some teachers' unique code was not given. There were certain minor, my lords,
But I'm saying
discrepancies.
that has to be clarified,
Yes.
and an order needs to be passed.
Yes.
Rest of it, they will take care.
Please.
So like this, like the court has to decide right from 21 to 25. No, the whole 4 years they have completed.
Completed. One more year, my lords, they will complete the course itself.
Even for their employment also, any order to be passed?
Please, ma'am.
For their employment also, any order to be passed? If you file an IA, for that also we'll pass another order.
This college, my lords, is in existence from 1992, and my lords, every year.
It is, whatever it is, that's
Please.
not the business of the High Court to interfere.
Please.
Now, when you say there is any infirmity, let them look into it and it's for them. Ultimately, there is an authority constituted to look into the affairs of the education. That's how the standards of education are like this now.
Please. That's in fact, my lords, the impugned order, my lords, the hearing authority is somebody else, my lords, and
But it is beyond the relief that we sought. Why you have questioned something in 21 and we have been passing orders till 26, one after the other.
Every time, my lords, the examination comes, my lords, they raise.
You are coming, that's the way, that's the modus operandi. Yes, what do you say?
For announcement of results, my lords, they should.
It has to be done. What else?
By virtue of interim order, they were permitted to write exam.
No, for everything, by virtue of the interim order, you took the children, he is permitted to take the children. By virtue of the interim order, they will pay the college fees. By virtue of the interim order, they will pay they will write the exam. No, by virtue of this final order, you declare their results. Why from 4 years, they are studying? They're studying in the college.
They're studying, my lords, they're studying.
These kind of orders and now what is the present stage now of the college?
Yes. Permission has been given for the next academic year.
Next academic year, we have permissions.
So for this.
Only for this particular year, my lords, there was.
21 to 25, without any permission.
No. Only for the academic year 2021-25. These are the students of the academic year.
What I am saying.
Yes.
Without the
25, without a permission, you will run the college. You will, the students will study in your college.
Only for that particular year.
That particular, it is sufficient.
And my lords, subsequent year, my lords, I have completed all the parameters, the permission is granted.
Very unfortunate. The present writ petition is filed, seeking the following prayer. A coordinate bench of this court.
What is my lord disposing my lord's petition itself?
Huh?
Disposing the petition itself.
Itself, why should we keep it pending?
Lords, then my lords, the.
Then what remains? It is more of an academic, students you have taken. Everything
yes.
is over.
Please.
What is this post permission now?
Please.
You left them to run the college, isn't it? By virtue of the interim orders. Now what is the effect of it?
Lord, the annexure C that Lord, the NCSM has
Now
passed.
we will say the
Please.
court, they have they can't, no permit, they are not eligible for the permission. What are the consequences of that order now?
Lord, we'll shift them, Lord.
Students will suffer.
Lord, their career will not be, Lord.
Completed. They've come. Where will you shift them?
Another 1 more year to go.
The penalty may be imposed, my lord, the division bench of, my lord, in the principal bench. Penalty has been imposed, my lord, 75 lakhs, my lord, based upon this. My lord,
Let's see that. I'll hear it. I'll not pass
I will,
in between.
my lord, I will produce the order copy, my lord, at least on Monday, my lord.
Yes.
On 28th, my lord.
Now,
List the matter on
results, my lords.
28th.
28th.
Lords, let them, at least, my lords, results may be announced. I will let the matter be heard. But
No, they will
because, my
announce
lords,
the results. How does it
the
matter?
notification has come, my lords, in the last date, my lords, for the examination fees.
28th they will
Please,
do it.
please.
That day, along with all this, I'll pass order.
Oblige, great.
Because, my lords, ultimately, my lords, the notification is issued, wherein, my lords, the last date for payment of examination results, my lords, would end up on, with fine, my lords, I am supposed to pay the examination fees by, my lords, 22nd.
That is, 22nd is Thursday. We'll take it up on Thursday. Or tomorrow, get that
But
judgment.
on 22nd, my lord.
Yes, 22nd.
22nd.
Oblige.
Tomorrow is the matter tomorrow.
My lord, my lord, tomorrow, my lord, I will not be, I have some, my lord, inconvenience at home, my lord.
Lord, since all these years, my lords, the examination results are
By
announced.
all this, you are facilitating him to have an order.
No, my lord. I am ready, my lord, on 23rd or 22nd.
Let these results, my lords, be announced and matter be taken up next week. my
I
lords.
don't want to be part of this kind of orders. I don't want to pass that kind of an order. I want to dispose of the writ petition.
22nd, my lord,
Yes.
without, oblige.
It's 22nd, my lords, half day. If my matter doesn't reach, then it will be difficult. It will last day. Therefore, my lords, tomorrow I request.
What were you doing till now?
My lords, the moment the examination notification is issued,
When was the notification came?
notification, my lords, was issued. My lords, very recently, my lords, the examination.
How recently it is?
22nd, I will address.
Yes.
26. Seal number 16. Sanjay S. Katgiri, AGA.
Lordship, in
During
this matter,
pendency
I
of the
need-
writ petition, the management has passed resolution to withdraw the writ petition. Regarding re-audit, my lord, it was challenged. I filed the application, my lord, with resolution.
Lordship, kindly have it next week, Your Lordship.
He wants to withdraw the writ.
You want to withdraw it? Re-audit that has been
Re-auditing, they have
challenged.
challenged, Your Lordship.
I filed the annexure N, my lord. It was stated to withdraw. It is in Kannada, my lord. Yes.
What are the reasons stated?
That the matter has been re-audited is not necessary. Whatever the,
Petition is,
yes,
the letter by the petition society, resolution of the petition society.
yes,
Dated 6/1/2026 is placed before the court where it is resolved that they'll not proceed with the writ petition and they want to withdraw
Yes.
the same.
Actually, Your Lordship, he himself has filed a complaint for misappropriation. When we have taken the decision for another auditing, Your Lordship.
So in that case, I will adjourn this matter if you want to submit anything on the merits of it.
they are going to, it is, my society was affected.
So I should know.
The
when-
state is nowhere to.
Not, and at the same time, it is not for you to blow hot and cold at the same time.
No, no, the audit was re-audited. There was some misappropriation in the ICICI Bank, which I have deposited, my lord. Now they have refunded it.
You want to get any instructions or?
They
you
don't
want
have
to-
anything to say
Kindly
about
pass
it,
over,
sir.
Your Lordship.
Yes, pass over.
I'll have it on tomorrow, my lord. Nothing is, let the seek. No, no, my writ petition is there. I passed a resolution. I don't know what the government.
20%.
Yes.
Seal number 17. GN Raichu.
My lord, I am for the appellant. There is a condonation of delay, my lord, about
I number 1 of 2 of 24 is filed to condemn the delay of 4 days.
4 days.
The reason stated, admit final hearing TCR. Yes, 18.
Admit TCR. Finally. Seal number 18.
Lords,
Fourth.
recalling order, my lords, there is a delay of 13 days.
What does this recall?
My lords, dismissed for non-prosecution
Why you were not present?
for non-compliance of officer's objection.
I number 1 of 2025. Have you complied with the office objections at least today?
With
By-
permission, my lords, I will comply.
Pending consideration of IA, the petition shall comply with the office objections. List this matter next week.
Please, ma'am.
19.
Seal number 19. GB Shastri Chetan Munwali. Harsh Desai. AGA.
My lord, this petition rule was issued, I mean, said notice regarding rule was issued in 2024. My lord, I am ready to argue the matter on merit, my lord. It's a-
Your Lordship,
Before that, there is an alternate remedy,
Remedies.
my lord. Last week, this submission was made across the bar.
Yes.
On that ground, my lord,
Yes.
My lord, there is no alternative remedy here. Kindly see the order passed under 136 to let me clarify.
Let's see
Passing on the
the
translated copy of annexure impugned order, my lord. And that
quashing the order dated 24/8/2023 passed by respondent number 2. Who is
yes,
respondent
24,
number
yeah,
2?
this is the order, my lord. I am giving you the English translated copy, my lord.
Deputy Director of
Yes,
Land Records.
that is
cum
passed
technical
under
assistant.
section 132 of the Karnataka Land Revenue Act. Kindly see the Karnataka Land Revenue Act 136(2), my lord. I'm giving the translated copy, my lord, only because the entire file need not be translated. So this is an order passed under 136(2). Now kindly see 136(2). Any order passed under 136(2) is final, my lord. There is no question of any alternative remedy.
Let's see.
Kindly see I'll just read out that 136(2). It's the finality. And I have filed an appeal. That was the alternative remedy I filed, and then I have come here 2 years ago, my lord. Kindly see 136(2), my lord. The 2 in the end, my lord. And his decision shall be final. Where is the question of alternative remedy?
You're reading 136?
2.
Any person?
Yes, my lord. Let me read. Any person affected by an order made under subsection 4 of an entry certified under section 6 of section 129 may within a period of 60 days from the date of communication of the order of the knowledge of the certified entry appeal to such officer as may be prescribed by the state government in this behalf, and his decision shall be final. Thereafter, I filed a writ petition. My lord, even otherwise, by way of 44th Amendment to the Constitution of India, article, alternative remedy from 226 was removed. I'm not on that. But this, my lord, is not a bar to come under article 226 when the order is final.
Yes, what do you say?
And let me argue on merits, I'm ready.
What do you say on that?
Lord, as against this, my lord, there is an appeal to the Joint Director of Land Records.
Under?
Lord, under 136 itself.
No, this order itself is passed by 136.
Lord, any person affected by an order made under subsection 4 of the entry certified under subsection 6.
So this order is passed under which section?
136(2).
Lord, your lordships may kindly turn to the operative portion, my lord, of the English translation now handed over.
Kindly note the preamble, page 2, my lord, internal page 2 of the order. Request your lordship to turn to the next page, my lord, preamble portion under which provision? Yes, preamble. Your lordship get that, my lord?
Yes.
Questioning the mutation. Let me start from there, my lord. So mutation is made under 129 pursuant to a Supreme Court order. Is committing contempt. I do not know what is the reason he could have passed this order, and that too without.
This is an appeal under
136(2).
Yes, even the last page it is reflected so that it is under 136.
Yes.
Well, let me start, my lord, on merits, my lord. Now what has happened, your lordship may kindly see. I'll give the synopsis, brief synopsis, though I'll not take your lordship to the whole thing because it's quite voluminous. I'll just come to the gist of the point and I'll come back. Synopsis. I'll just pass on the synopsis for quick reference, my lord. And wherever it is necessary, your lordship may stop me, my lord, and I will kindly see, my lord. Who is the petitioner, my lord? Petitioner is a trust registered under the Bombay Public Trust Act. My lord, let me make one clarification because your lordship may not be aware. This area came under Bombay Karnataka till 1/11/1956, reorganization of states. 1/11/1956 was the reorganization of states. My lord, Mangalore and other South Karnataka came under Madras jurisdiction. Madras Endowments Act was applicable, my lord. And Bijapur, Gulbarga was under Hyderabad. Because, my lord, it all split in 1/11/1956. So, and after reorganization, till recently, my lord, Bombay Public Trust Act was applicable. Then Hindu Charitable Endowments Act came into.
Can we take it up at 2:30 so that I'll complete?
Highly obliged, my lord. I will be here. I'll come for this. I'll finish it and yes. I do not want any adjournment, my lord. I'll argue.
Yes, 2:30 will come.
Yes, yes, because it's quite an interesting point also. Because in my opinion, the officer has committed contempt of Supreme Court order. So it's quite a serious matter because Supreme Court has passed the order after hearing him also. A simple question is this, my lord, 2:30, I'll come only one sentence. There is a public trust, 7 trustees. All of them are dead. Once all of them are dead, fresh trustees are appointed, challenged by him. Supreme Court dismisses his SLP and says all 7 trustees have to come. Someone has to run the trust. It is not an adjudication of any adversarial rights here. It's an administrative act. Once the new trustees come, their names. It is like Order 22, Rule 10, not Order 22, Rule 3, where you have to decide who are the LR. It's the administrative act. So, in view of the Supreme Court, he writes the Supreme Court order. These are the trustees as held by Supreme Court. I enter the name. It is the question of setting aside that order, my lord. In 2018.
Lord, I am sorry, my lord.
No, I will argue.
That is not the case at all. That is not the case at all, my lord. Petitioner is trying to take advantage of similarity of names. My lord, it has got nothing to do with the properties in question. My lord, I will also argue, my lord.
With due responsibility, I am making this submission at the bar and I'll substantiate by the order. That's why I have given the synopsis. 2:30, I'll be present, highly obliged.
Yes, 20.
The question of alternative remedy will not arise at all.
Yes. Yes. Password. Next.
Seal number 20. Seal number 20. Tamoy Katigi.
In this case, in cross appeal, your lordship, not the Venkatesh Karvi. You have to take notes in cross appeal, your lordships.
Yes. So and so, in 20.1, Mr. MY category is directed to take notice
For R2.
for R2. What does this matter?
I challenge the liability.
LCRs are required, Your Lordship. LCR may be called for.
Yes. Admit course of hard hearing, call for the TCR.
Lordship, Lord, the Venkatesh Karvi is direct to take notice. Respondent number 1, Venkatesh Karvi.
Respondent number 1.
Mr. Venkatesh Karvi is directed to take notice, Your Lord.
Yes, Venkatesh Kavi for respondent number 1. This crop be served on him.
I will serve, Your Lordship.
Yes. Anyone?
Serial number 21. Srikanti Patil, Sanjay Katigeri.
Tomorrow, my lord. Annexure challenge this petition annexure G. It is in the Kannada language, my lord.
To file an expedite petition, you seek for time.
No, my lord. Annexure G challenge this petition.
This matter after 2 weeks.
2 weeks.
No, my lord. It's annexure G. Annexure challenge this Kannada language, my lord. I'll file it in the.
No, it is.
Annexure G is the order, my lord. Order passed by
Kannada.
Kannada.
No, it is in, the endorsement is in Kannada. My lord, there was
filed a translation.
I filed a suit for partition, separate. Subsequently, some immovable property vehicles.
What do you want?
I request, my lord, day after tomorrow, will file a translation copy.
Day after tomorrow, not possible. List this matter after 2 weeks. 2 weeks. Yes. 22.
Any date, my lord, next week, my lord, any date.
They will give up 2 weeks. Yes, 22. 22.
Clements appeal for enhancement.
In this case, my lord, I undertake to file wakalat for respondent number 2 insurance company, my lord.
So and so.
Nagaraj C. Kollur.
His instructions to file wakalat. Serve the copies on him. I number 1 of 2025 is filed to condone the delay of 104 days. Condone on condition.
Refer to Lok Adalat. It may be referred, my lord.
Lok Adalat?
Please, ma'am.
Refer this matter, place this matter before the Lok Adalat.
Please.
23.
23. Surabhi, Kulkarni.
Petitioner in connected. Well, I'm agreeing for the petitioner in serial number 23, my lords. Today morning, I have served the vacating stay application in connected matter. I want to file objection, Lord. I need 3-4 days time. Lords, in the connected matter, they have filed contempt, which is coming up on Friday. In fact, yesterday the contempt was.
I'll record that they have not pressed for the contempt on Friday. If you're seeking time.
2 days, my lords, I will not object. Any day before Friday, my lords, I will not object.
Oh, if you want adjournment, then you shouldn't press for the contempt on Friday.
But I will argue on this.
Huh?
I will argue on vacating. Because
Yes.
the interim order is passed 5 months before. They have not even complied that. Despite giving
Yes,
permission
let's see.
So the first matter, my lords, one submission before my learned friend starts. In the first matter, my lords, both first and second matter, my lords, pertain to transfer matters. The first matter, he has already, my lords, joined to the place where he has been transferred in May 2025 itself. So the first, in view of his joining, my lords, the first petition, my lords, become infructuous. Yes, my lords, your lordships may kindly peruse, my lord, the order dated 4/11/2025, my lords. This honorable court has recorded, my lord, the finding in light of the fact that petitioner has joined the transfer post and working since then. However, it would remain subject to the result of the writ petition. Lord, my subsequent, my lord, joining to the transfer post is subject to the result of the writ petition.
Let's see why the transfer is back.
Please.
Where are you working?
Well, currently, my lord, I'm working as a driver cum conductor. My lord, in the.
You're transferred from where to where?
My lord, from Chikkodi division, my lord, to Khanapur division.
Chikkodi to Khanapur.
Khanapur.
Now you're working in Khanapur division.
Now he is working in Khanapur division.
When was the date of transfer?
Date of transfer, my lord, is annexure, my lords, dated, my lords, 30/11/2024.
30/11/2024. When did you join?
30/11/2024, my lord, it is a transfer order.
When did you join?
Lords, that relieving order, my lord, again, annexure B, my lord, the relieving order is at annexure C 2/1/2025, my lords.
2/1/2025, you have joined.
Thereafter, my lords.
Why this action of the respondent is contrary to what?
Lord, it is contrary, my lord, in the sense, my lord, on 2 preliminary grounds. The first ground, my lord, is that there are no transfer guidelines, my lord, in respect of class 4 division-wise post, my lords. The petitioner is holding, my lord, class 4 division-wise post. My lord, only regulation, my lord, which regulates the transfer of class 4 post in case RTC, my lord, is at ink page 61. That is the only regulation, my lord, C&R regulations. Ink page 61.
Yes, what it says.
My lord, it reads, my lords, at point number C. Normally, the employees holding division-wise post will be considered for promotion under these regulations in respect of promotional vacancies in a division-wise post in respect of divisions only.
The promotion has to be given effect in the respective divisions only.
Yes.
In respect of the employees who are transferred from one division to another division on administrative grounds, the entire service rendered by them in division from which they are transferred shall count for seniority in the division to which they are transferred. However, such transfer shall be resorted to sparingly. The word, my lord, which is used here is sparing, my lord, in only in extraordinary circumstance. They have to resort, my lord, to the.
This is not a transfer. Transfer on promotion.
No, my lord, this is a transfer on administrative grounds
Yes.
from Chikkodi to Khanapur division, my lord, without providing, my lord, any reasons, my lord, why they are transferring me, my lord, from the Chikkodi division, my lord, to Khanapur division. It is not, my lord, class 1 or class 2 post. It's a driver cum conductor post, my lord. There's no administrative exigency, my lord, for class 4 post.
One ground. Next.
Second ground, my lord, there are no transfer guidelines, my lord, to regulate, my lord, transfer of the class 4 employees.
Yes. We'll ask him.
Please.
Yes.
My lords, there is a circular, my lords, which, my lords, regulates, my lords, the transfer. And there is no prohibition, my lords, from.
Let's see. Because everything, whatever action by the
Yes,
respondent,
yes.
there should be some rule for that.
Please, my lords, I'll produce that circular, my lords. Circular, my lords, which, my lords, has that basis.
You should have done it. When
No,
that is
because
now.
no, this objection, my lords, is raised now. Because earlier, my lords, I was on the
raised
ground.
in earlier proceedings as well.
In the writ petition, I have raised the grounds.
I've raised in writ petition, my lord. That is my preliminary contention.
Let's see. Where are your grounds?
My lord, my grounds, my lord, I think starts, my lord, from ink page 8.
Ink page?
8, my lords. My lord, I've stated at ground number 12, my lords. My lord, I've stated, my lord, that they have transferred me, my lord, only upon the regulation of 13(4)(c).
Lords, that circular, my lords, is annexed, my lords, with the connected petition. There, my lords.
We'll see that.
Please.
Do the next
No.
petition. Do the next petition.
Next, point 1. Next. Yes,
Next writ petition. Where is it?
My lords, at page 23, my lords, the typed copy.
Page number?
23, my lords, the typed copy.
23 of the writ petition.
Writ petition, please. Annexure E.
Yes.
The typed copy, my lords, is at page 23. My lords, may I, my lords, request my lords to kindly see, my lords, page 24. Employees holding division-wise posts will be considered for promotion in respect of promotional vacancies in division-wise post in their parent duty unit only. In respect of such of the employees who are transferred from their parent division to other units.
The same regulation which I read out, my lord, at ink page
Other
61.
units. On.
It is not like.
No, my lords, there is no prohibition, my lords, for even though they are class 4 employees, my lords, there is no prohibition. We have been doing this, my lords, here, and it's not that, my lords.
What is exactly meant by the transfer guidelines?
My lords,
Should we have a transfer guidelines? There is no prohibition for you to do anything.
no, there are, my lords, I'll produce that. Now, the question is this, my lords. Now, he came before this court, my lords, saying that this transfer is bad. We said, my lords, that this is on administrative grounds, and now having he, my lords, joined.
You being an employee, you
Please.
have to be fair in your whatever action you
Please,
are
please,
taking, and you have
please,
to
please.
substantiate it by way of circular, by way of some.
There are, my lords.
So unless without placing it, how can you file a vacate petition in this?
But I may a day's accommodation, my lords, I will produce it.
This is matter after.
My lords.
We can't help you. You are the other day you have submitted and I have accommodated this. You didn't come up with the. This is matter.
Well, this matter was coming up before my lord for the first time.
No, it has come up the other day. You asked for time.
No. This is coming up before my lord for the first
Same
time.
question was posed by the previous bench, my lord, to the corporation regarding that circular. My lord, they took a time, my lord, to produce a circular. My lord, till today they have not produced any circular.
But there are.
This is matter on Monday.
Please, my lords, may I request, my lords, on Thursday, my lords, because Friday.
So many matters.
Lords, as far as the connected matter is concerned,
You should have been ready by this time if you are so keen on arguing on your vacate petition.
my lords, in the connected case, my lords, the connected writ petition. Since, my lords, contempt, my lords, is
23. Do the 23.
Interim order
Your
may kindly-
matter on Tuesday.
Please.
Not Tuesday, on Thursday.
Please.
Yes.
Interim order may kindly be extended.
Your matter I am going to hear. His matter I am saying.
Yes.
23.1 I'll hear.
Please.
Yes. And in this case also same issue will come.
same issue will come, my lords. That's why.
May I
And
make
here,
one
my lords, he has been working in the Bagel Court division for 18 years. Thereafter, my lords, we have passed an administrative.
Then a person working in 18 years in a particular division shows that there is no policy of transfer.
Yes. No, I will, my lords. My lords, I get what my lords.
Transferred him.
No, my lords, I go down to what my lords says. I'll produce that, my lords. May I have it on Thursday, my lords, both the matters, my lords.
May I make one submission in my matter? Kindly see the memo, my lord, which I filed.
Matter tomorrow. Yes, both the matters.
Grateful.
Intermod order granted is extended till then. And I will not take.
No, Lord, I'll not give that opportunity.
Time to convince the court on the circular, nothing
Please,
else.
please.
Or else I'll allow their return.
No, I'm not. I'll
Yes.
produce all the documents.
Please.
Yes,
Yesterday's matter, only pay and recover order has to be.
where are you? This is pay and recover?
And as per conventional head, my lords, 40,
My lord.
what my lords are.
Delay may be condoned. That post operation Kaikmat wife is seriously been infected. He was taking care of his wife. He was requested for the week's time to accommodate. Then we come.
IN number 1 of 2025 is filed to condone the delay of 18 days. Condone, no, condone. Admit final hearing, PCR 25.
My lords, both are.
Please, he is not.
No, I am not pressing. For admission, my lords, any date maybe. I am requesting.
Every matter can't be kept in.
No, it is a short, since death case, my lords,
List
till
the
now.
matter on 23rd of February.
Please.
Yes, 25. 25 also same, 26. 26.
My lordship, I will file withdraw application, my lordship, kindly. I will file withdraw application, my lordship.
Give it.
I will file,
When will you file?
kindly 1 week time may be granted. my lordship.
Wednesday, the petitioner wants to withdraw, appellant wants to withdraw the writ petition, withdraw the appeal. Yes,
Yes,
and they'll come up with an appropriate application. Yes.
Please.
This is with regards to setting up of the mobile tower. There is a settled position of law already.
What is
The objection by the municipal corporation for rejection laws is on the ground of emission.
My lord, please, I am appearing for on behalf of the respondent, on behalf of the Bhushan Kulkarni, my lord. He is in out of station, my lord. Kindly have it next. His father is.
For station, he should make his alternative arrangements. On request of petitioner, matters won't be listed, and on request of respondent,
Today,
matters will not
please,
be.
please. Today his father is undergone the operation today morning, my lord. He informed me. Kindly have it next week.
Not
Please.
some short accommodation.
On 3rd of February.
Please.
Any short accommodation because.
Not possible. Next week, I am not. Next week, the court is not sitting for 2 days. I have a larger bench in Bangalore. So what will I do with the next
What has
week
happened in
matters?
this, Milords?
Yes, next.
40 lakh equipments are
Yes.
still in the property itself, Milords.
Can't help it, Mr. Counsel. Yes, 28.
Milords, in this seeking a writ of certiorari, Milords, questioning the annexure A. Annexure A is the notification issued by respondent number.
Let's please come to your prayer.
Yes, Milords.
Quashing the endorsement dated 18/12/2025.
Yes, Milords.
Issued by whom?
Issued by respondent number 1, Milords.
Respondent?
Number 1, Milords.
Who is
Respondent, sorry, Milords, respondent number 2. Hubli Dharwad Development Authority, Milords.
Respondent number 2 or 7?
Yes, Milords. Respondent number 2.
Dharwad Urban Development Authority.
Yes, Milords.
What is this endorsement?
Milords, these are the endorsements submitted by the
But
bidders,
please for
Milords.
that.
R.H. Changdi.
My lords, R.H. Changdi, sir, my lords. I'm a proxy counsel, my lords. His name was not shown in the cost title as such.
So and so is directed to take notice
Please, ma'am.
on behalf of the second respondent.
Yes, my lord, second respondent.
Petition should have the copy of the writ petition. List this matter on Friday.
My lords, interim order, my lords.
Is already granted.
No, my lords.
We'll grant it. We'll hear him and grant on Friday.
No, my lords. Since, my lords, if interim order is not granted, my lords, if allotment letters are issued, the very filing of writ petition becomes infractious, my lords.
But it is pending from 25. Nothing has become infractious.
No, my lords, because, my lords, they are planning to
Friday
issue
is
now, my
when,
lords.
Mr. Counsel?
My lords.
Friday is when? Today is Tuesday.
Yes, ma'am.
Wednesday, Thursday, Friday. What is waiting from 3 months? Can't it wait for another 2 days? Yes, 2 days. On list on Friday.
Please, my lords.
Please, my lords.
This I seek 10 days time, your lordship.
My lord, meanwhile, they will issue work order, my lord. Challenging annexure A, my lord, tender notification, my lord.
On what ground you are questioning the tender notification?
My lord, as per, my lord, I have produced the judgment, my lord.
With respect to selection of manpower agency,
Yes, my lord.
providing outsourcing services for Taluka of Haveri, so and so.
Yes, my lord.
So what is wrong with the tender notification?
My lord, condition is, my lord, the timeline has been discussed in a judgment, my lord. I have produced annexure J, my lord. Relevant page is 113, my lord. The timeline from last date of submission of tender, my lord. Within 90 days, the tender proceeding must complete, my lord. And the last date for submission of tender is, my lord, 30/9/2025, my lord.
Government has their own circulars for that.
My lord, it is, yes, my lord.
Courts will not run the tenders how they have to be. Now, come to the tender schedule.
Yes, my lord.
If this is the way the court starts interfering with the tender process, no tender, no work can be done. Come to the tender notification.
Yes, my lord.
What are the conditions in the tender?
My lord, eligibility criteria, my lord. Eligibility criteria has been discussed, my lord, at page number.
You are agreed by what?
My lord.
You are agreed by what? What is which
Agreed by the tender notification conditions, my lord, as well as, my lord, they have mentioned 3 years experience, my lord, at page number 19, my lord. Page number 19, last line, my lord.
Even for a moment, your lordship.
Let him submit. Yes.
Last line, my lord, Roman 3, my lord. That bidder agency, that is company for proprietorship concern, should have minimum 3 years of experience in supplying manpower in the relevant fields. That is providing personnel. My lord. But, my lord, annexure F, my lord. Annexure F.
Who is it? Yes.
My lord, annexure F, my lord. One of the bidder is
yes.
Annexure F, my lord. One of the bidder company is registered on 16th May 2023, my lord. He has completed only 2 years, my lord. Even though he has been technically he has been eligible, my lord.
No, why should we decide all this at this stage? Why should the court go into all those aspects? No, the tender process is not completed.
My lord, if work
tender process is completed, once it is clear that so and so person doesn't
my lord, it will lead multiplication of proceedings, my lord.
Huh?
If respond number 3 has
So why should we go into a tender process even before it has been finalized? Why should we assume things?
I have given a
Why should we go into that aspect? Now, even after they finalize the process, that time also we can see if a person who is not fulfilling the eligibility criteria has been shortlisted, then it's a ground.
Yes, my lord. As per annexure F, my lord, his company is registered in the year 2023, my lord. He has completed only 2 years, my lord. But as per the conditions incorporated in the annexure A, my lord, tender notification, he must be experience of minimum 3 years, my lord. Minimum 3 years. But he has completed only 2 years of the registration of this company, my lord.
How will you know?
Lord, I have produced the document, my lord, annexure F.
How you can have all those documents pertaining to that person?
My lord, it is available in the website, my lord. Lord,
So what is the stage now?
My lord, work order is not yet issued, my lord.
You know that he has been shortlisted?
Yes, my lord. I have produced annexure E, my lord, page number 103, my lord. 103, my lord.
One?
103, my lord. 103. Fifth bidder, my lord. Santosh Kumar RK, that is BKR Services Private Limited. His company is registered in the year 2023.
No, apart from that, there are other 1, 2, 3, 4 persons. Why should we stall the proceeding?
My lord, as per annexure J, my lord, the judgment of this honorable court, my lord, It is strictly, timeline has been discussed, my lord, and it is mandatory, my lord. Within 90 days, they have to issue work order to any one of the bidder.
You are not going to be affected by this because you are not shortlisted.
My lord, I am
And
also
how are
short.
you,
Yes, my
where
lord.
is your name?
Page number 103, my lord. Serial number 4, my lord. Mega Services Private Limited, my lord.
What is that?
Mega Services Private Limited. Serial number 4, my lord.
Hmm.
My lord, 90 days time limited is
No,
mandatory, my lord.
your submissions I'm not able to understand. One thing you say that so and so is not fulfilling the eligibility criteria. Number two, you say that they have to issue the work order by this so and so time. And the other way they say if this interim order is not granted, they will finalize, they'll go ahead with the process. If they go ahead with the process, what is the difficulty to you?
It will lead to multiplication of proceedings, my lord. If
No,
they
what happens now if they go ahead with the process? So you are sure that you are going to be,
No, my lord.
You're.
My lord, I have given a representation also, my lord. As per Annexure G, my lord. That that BKR services is not eligible for in technical bid, my lord. Even though they have made eligible him.
When was your representation?
18/10/2025, my lord. Page number 105, my lord. Annexure G. 18/10/2025.
No, in the light of the judgment of this court, in
Yes,
this
ma'am.
writ petition number so and so.
Yes,
No, the tender itself has to be, the process also has to be set aside.
Yes, my lord. It is mandatory, my lord. Page number 113, my lord. Paragraph number 3, my lord. Any relaxation in the about
Advantage you will get out of this. No, there should be something.
fresh tender should be issued, my lord.
So, no, what is the advantage you will get if this tender process is set aside?
My lord, ineligible candidate bidders will be removed, my lord.
Why they will not participate?
My lord, they are not eligible, my lord. As per their tender notification
They are not
condition.
eligible, that aspect we will consider, that we'll ask them. Why should the entire tender process be set aside? How many times they will call for the tender? And you are a shortlisted candidate.
No, my lord. It is not only me, my lord.
That's why you want it to be set aside.
My lord, their tender conditions has been violated, my lord. It is their condition, my lord. Annexure A, my lord, at page.
Yes, what
3
happened
years,
to that? Is it that?
My first point that your lordship, he has made the allegation that your lordship won against BKR Service Private Limited, but he has not implemented him as the party in the present petition.
No work order is.
Yes.
Because when it is specific allegation that your lordship has not completed 3 years like that, but unless he makes them as the parties, he cannot get the orders from this honorable court. He is the affected party. My first point that.
Why you are not adhered to the schedule as fixed?
And your lordship, at the beginning, your lordship, I make a submission that I sought for 10 days time. Because lordship, I would like to take notice last time. I have not received any instructions, your lordship. I sought time, lordship. But my learner friend started argument, your lordship.
But you are supposed to, after taking notice, you are supposed to get instructions.
Yes.
And they are supposed to give. In tender matters, your client can't take his
But
sweet
it will
time.
not affect your lordship, his rights, your lordship, because your lordship.
That's a secondary
Yes.
aspect. Your duty is to get the
Yes.
instructions.
Yes.
That your client has to give you instructions.
Yes,
If
in
they're
Jilla
not-
Panchayat, your lordship, I am appearing for Jilla Panchayat. That your lordship, I have to get instruction. It may taken after 1 week, your lordship, I will get. Unless your lordship, another, you have to implement the party, your lordship.
Petition submits that one of the person whose name is shortlisted is not is not meeting up the eligibility criteria. Land counsel appearing for the respondent submits that against whom he is making allegation is not made a party to the present writ petition. In the considered opinion of this court, against whom the petition is making allegations and has given a representation to the respondents on
18/10/2025.
on
18/10/2025.
18/10/2025 is a proper and necessary party to this writ petition. Petitioner shall implead him as a respondent to this writ petition. Then counsel appearing for the respondent number
Respondent number 3, your lordship.
3 shall get instructions. List this matter on 11th of February.
Please.
Appearing for the appellants, My lord, the appeal is for enhancement of compensation. Is an injury case. My lord, the
Admit, post of final hearing, call for the TCR. Yes, 31. Yes, admit. Admit final hearing.
Lord, I'm withdrawing the appeal, Your Lordship. It's the appeal filed by the owner challenging the liability. During the pendency of the appeal, my Lord, it is, my Lord, settled before the, my Lord,
Memo is
executing
filed.
court.
During the pendency of the appeal, the matter is settled out of the court. Hence, the petitioner wants to withdraw. Dismissed as withdrawn. The petition is at liberty, the appellant is at liberty to withdraw the amount in deposit.
Please.
Yes, 32.
Yes, ma'am. I'm filing the memo not pressing the appeal. Maybe dismissed or not pressed. And the amount in deposit may be transmitted to the MSCT.
It's appealed by the owner. So corporation. The moment is for seeking to withdraw the appeal. Dismissed as withdrawn. The appellant is at liberty to withdraw the deposited amount. Yes, 33.
Obliged.
Short accommodation. Short accommodation.
What is that?
Kaikmat, sir. Urgent.
Admit final hearing TCR 34. Same, admit final hearing TCR 35. Notice to the respondent.
My lords, claimant's appeal, my lordship,
Notice
seeking
to the
for enhancement. Please, my lords.
Yes, 38.
My lord, it's a suit for specific performance, my lord, against the development and non-alienation. An injunction order is granted.
Ready?
Kindly pass over, my lordship. Yes.
Yes. No representation list after 3 weeks. 41.
Writ of mandamus, Your Lordship. Page number 41 may be seen, Your Lordship. The complaint has been filed before the Vidyanagar police station, Your Lordship. The Vidyanagar police station, till today, they have not filed a FIR or any action has been taken. For a moment, Your Lordship, page number 26 may be seen. Typed copy of the complaint, wherein he is the GP, the petitioner is the GP holder of the residents of.
No, I don't know how the other coordinate benches are passed on.
Yes, yes.
As far as this code is concerned, if the complaint is not registered, you have to give a representation to the higher ups, number one. Number two, the alternative remedy is to file a private complaint.
Yes, sir.
But not filing a writ petition.
For a moment, Your Lordship, the complaint may be seen, Your Lordship. Wherein the other.
What are the orders passed by the?
Your Lordship, in coordinate benches, Your Lordship, directed to file a FIR or get instructions whether why FIR is not filed, Your Lordship. In the present case, Your Lordship,
The
as a-
judgment of the Honorable Apex Court, the procedure is that
Yes.
you have to give representation to the higher ups, number
please.
one. Thereafter, the other one is to file a private
If they have
complaint.
not entertained, then private complaint.
We should entertain a writ petition. Yes.
Yes, for a moment, Your Lordship, page number 26 may be seen. The complaint, Your Lordship. 26, typed copy. May I read, Your Lordship?
Yes.
Complaint against Venkata Kireswar of Unkal for intentional fraud, cheating, illegal sale of property of DS Kirby and his legal heirs. I, EP Emmanuel Dayal, veteran of the Indian Army. I am representing the legal heirs of Mr. DS Kirby. Earlier, a resident of Keshapur, Hubli, during his lifetime, he acquired a lot of property in many areas of Hubli. The largest portion of the property was purchased in an armed Unkal village. He passed away on interstate on 4 June 1977 at Keshapur, Hubli. There are totally 4 numbers shareholders.
How can you seek the police assistance to recover the encroached property?
No, there is a threat, Your Lordship. They are coming to our position. Yes, yes, sir. There are totally 4 numbers shareholders. That is 1 son and 3 daughters.
No, seven. Since we legal heads of DK Kirby have filed,
Yes.
impleaded into other writ petitions in the justice. and
I would like to
private
draw your
court.
special attention both facts that the seller on the part, paragraph number 5, Your Lordship. I am reading from there, Your Lordship. That the seller on the part 1 is Venkata Kireswar. As the GPA earlier, he was making the cheating, Your Lordship. Mr. Anson Committee, A6 shown as Dr. D.S. Kirby, the original owner of the said property. What is utterly shocking, glaring beyond belief and common sense.
You are questioning a document which is registered in the year 2008.
Yes, that is, suit is also pending, Your Lordship. And yesterday also the order has been passed. I have filed an impleading application wherein this petitioner herein, he has not been made as a party. I have filed a petition.
Civil in nature.
We will not ask the police to register a
No, no,
complaint.
yesterday also we met the police also, Your Lordship.
It is civil in nature.
They are saying, Your Lordship.
Civil in nature.
No,
it
no,
cannot.
apart from that, it is for them to act. If they're
Yes,
not
Your Lordship.
acting
No,
upon,
no, no.
go and file a private complaint.
We have filed a complaint. The private complaint we have not filed, Your Lordship. So far as we have met the police officer, Your Lordship. He told that you bring the order from the court.
Court will not grant the order.
So I have told him that the petition is pending before the High Court. So I moved this memo, Your Lordship.
The present petition is filed, seeking a mandamus to the
But
respondent.
till today, they are not taking any action. Even though we filed a private complaint, also there is a political motive is there, Your Lordship.
Towards the complaint lodged before the Vidyanagara police station by the petitioner dated 1/3/2023. 1/3/2023.
Yes, Your
You
Lordship.
want a mandamus now?
No, twice it has come, Your Lordship.
And equity. The facts of the case are the one D.S. Kirby, earlier a resident of Keshapur, Hubli, during his lifetime, he acquired a lot of property in many areas of Hubli. The largest portion of the property was purchased in Unkal village. He passed away intestate on 4/6/1977. After the death of D.S. Kirby, his legal representatives, one son and three daughters, who are married and have their children and have settled in Malaysia. Petitioners have received the GPA from the legal heirs of D.S. Kirby on
D.S. Kirby.
17/10/2022. It is stated that they have filed a complaint before the Vidyanagara police station, Hubli, on 1/3/2023 for cheating, illegal sale of property, and the police have not registered a complaint, which made him to file this writ petition. Land counsel appearing for the petitioner has drawn the attention of the court to the complaint. As per the complaint, they found a registered sale deed document number 7910 executed on 15th December 2008. According to them, the Kirby passed away on 5th July 2003. Vincent Kirby passed away on 15 July 2003 in Malaysia. How this document has come into force. And the police are supposed to, ought to have registered the complaint. Hence, they're seeking a mandamus to the police. The petitioner has already filed a civil suit. Now, this complaint is filed in the year 2023. If the police are not registering, petitioner has a remedy to file a private complaint, which he has not availed till now. If he can file a private complaint as well, he can make a representation to the higher ups why his complaint is not registered. Without understanding what are the contents, this court cannot direct the police to register a complaint and that too in the facts and circumstances. The complaint is of the year 2023. Accordingly, this court is passing the following order. The petition is disposed of, giving liberty to the petitioner to avail the appropriate remedies.
Much more.
There's one submission, my lord.
Yes, next.
Serial number 40, my lord. It is covered by the judgment of this honorable court, my lord, where
You give it. What is that?
my lord, the petitioner had filed an application for conversion of the land.
Take that.
Please, Your Lordship.
My lord,
If it is
612/3.
Issue writ of surreptitious requires the impugned NOC dated.
Yes.
Issued by respondent number 1, Deputy Commissioner, Belgavi District.
Yes. My lord, in this case, my lord, 3 applications were filed by the family members. The application relating to survey number 612/3 was allowed, and the application relating to 612/2 and 612/5 was rejected on the ground that they were not present.
Please come to this 28/3/2024.
Yes, ma'am. My lord, in the same ground on which it has been rejected, he is saying that we have not produced records.
See that, where is it? 28/3.
3/2024.
Where is it?
Page 21, my lord.
Page
21.
What it says?
It says that you have not produced the records and you are not present for spot inspection. My lord, as far as the same survey number, out of the same survey number belonging to other family member, they have allowed the application and they have passed an order for conversion. They have not asked for us to produce any records. So by taking into consideration this aspect, my lord.
Present petition is filed seeking the following prayer. When counsel appearing for the petitioner submits that in a similar set of facts, a writ petition number 107989 of 2024 is disposed of by the coordinate bench of this court by setting aside the impugn order, and the matter was remitted to the Deputy Commissioner to take appropriate action on the application filed by the petitioner for conversion after issuing notice to produce relevant records. The court also observed that the petitioner's land therein is similar with the land bearing survey number 612/3. The similar order be passed in respect of survey number 612/3, otherwise eligible in all other aspects. And the exercise shall be completed within 2 months from the date of receipt of the copy of the order. What is your survey number?
My lord, 612/2. My lord, in the
Sharing 21 task, it is
operative portion, my lord.
I'm looking at operative portion.
Operative portion, subclause 4. My lord, it should be, instead of 612/3, it should be 612/2. Because in the case of 612/3, already order is passed. And my property is 612/2.
So the same order in this where the 612/3 is mentioned, it should be 612/2.
My lord, in the first line, it should be 612.
612/3, second one is 612/2. Yes, disposed of.
Like.
This next.
Respondent number 3 may kindly be ordered, my lord. Because
respondent number 3.
G.I. Gachin.
Sachin.
On number 1, I'll take.
So insert accepts notice.
1 for HCGP.
1 2.
Respond number 1, HCGP, Lordship.
Respondent number 1, HCGP is director, is accepts notice. Yes.
Lord, this order passed by respondent number 2 and 3 under section 64A of the Karnataka Forest Act is impugned before this honorable court. Lord, petitioner is a company registered under Indian Companies Act. Lord, in the 1956, 76 acres of land was granted in favor of petitioner company on lease to construct a factory. And after obtaining permission from the then Bombay Presidency, it was a Bombay province then, plywood manufacturing company was built and it functioned.
Have instructions?
First time matter, Your Lordship, today. Notice has to, I'll take notice, Your Lordship, and it is their contention, Your Lordship, for all the respondents.
All the respondents?
Please, Your Lordship, all respond. Forest Department.
1 to 5. It's a SCGP takes notice. When will you get instructions?
My lord, for interim of sort for stay of the
What we can do is we can dispose of the matter itself.
order for eviction is passed.
Matter on
Order dated 2020, Your Lordship, and
2020.
Well, in fact,
and
we,
24.
before appellate authority, we submitted a memo as per Annexure B saying that we will hand over the possession. We are willing to hand over the vacant possession.
Without notice to respondents.
Okay.
5th of February.
Please.
Instruction.
Please.
By the time the instruction shall be placed on record. Yes. Yes.
Yes.
Yes.
Worship, in this, we are challenging the IA for temporary injunction that has been dismissed. Petitioner filed the suit for declaration, seeking, my lords, the respond number 1. Respond number made a sale deed in favor of respond number 2. Petitioner seeks, my lords, to register the sale deed in favor of the petitioner as a preferential right, my lords.
My lords, the plaintiff is claiming a preferential rights against dependent number 1. I am the purchaser, dependent number 2, my lords. But she is not a class 1 legal heir. Fine. The same has been considered by the trial court, rejected the I number.
Let's read. Suit for declaration.
Declaration, lords.
And
Let's read the impugnement.
in the similar matter, my lords, they have filed 2 suits. In the one suit, this honorable court already given a negative finding. They have no case, and the writ petition is dismissed, my lords.
Take that.
Para number 2, my lords.
Same order.
Same, please.
The present writ petition is filed. Agreed with the orders passed in I number 1 invoice number 399 of 2024, dated 28th November 2024, whereby the court had dismissed I number 1 under order 39, rule 1 and 2 CPC. When the matter came up for hearing, then counsel appearing for the respondent submits that the petitioners have filed another suit, that is OS number 397 of 2024. In that, a similar application is filed, and the court has rejected the application for injunction. And against that, they filed WP number 101652 of 2025. And that came to be dismissed on by order dated 3rd November 2025. And the court has observed that, a coordinate bench of this court has observed that, since the plaintiff is claiming the right of preemption, the court is of the view that both courts are justified in dismissing the application seeking injunction. The sued property, in case if sold during the pendency of the suit, the purchaser will acquire right to the property subject to the result of the injunction proceedings. Under the circumstances, the court does not find any reason to interfere with the concurrent finding of the courts. Next paragraph. It is in the light of the order that is passed in WP number 101652 of 2025. This court is not inclined to interfere with the order impugned before this court. And in case if the property is sold during the pendency of the suit, the purchaser will acquire right to the property subject to the result of the proceedings. Accordingly, a writ petition is disposed of. Yes.
Please. Grateful.
Petitioner is, my lord, the Education Society registered under, my lord, the Karnataka Society Registration Act. My lord, there was a dispute, my lord, in respect of rival groups in respect of the society. My lord, as per the Annexure A, my lord, the respondent, my lord, has directed, my lord, the parties to approach the civil court, my lord, to resolve the dispute. Accordingly, my lord, Annexure B may kindly be seen. Immediately, my lord, after
Issued by the respondent number 1, page number?
My lord, page number 15, my lord, Annexure B.
No.
Please.
Where is the endorsement?
Endorsement, my lord, Annexure A, page number 13.
What it says?
My lord, your lordship may kindly see, my lord, on the last paragraph of the said endorsement.
Yes.
My lord, when there is a dispute in respect of, my lord, the group regarding, my lord, submission of, my lord, the final accounts and, my lord, financial yearly, as per section 13 of the Act. My lord, for a moment I will read, my lord.
The requirement contained in section 13 is only for filing with the registrar, a list of names, address and occupations of the governing body. The decision taken by the registrar does not become final and the party may take up the matter before the competent court. My lord, as per this endorsement, since there is a rival groups in respect of fighting, my lord, against each other in respect of the same society. My lord, as per this endorsement, my lord, the direction has been issued by the respondent. You approach the civil court and resolve the dispute and submit the your accounts, my lord, as per section 13. Accordingly, my lord, annexure B, your lordship may kindly see. After receiving that endorsement, we have filed a suit in the year 2017. That is OS number 246 of 2017. And this suit came to be decreed. And your lordship may kindly see the operative portion, my lord, at page number 28. Suit of the plaintiff is hereby decreed. It is hereby declared that the managing committee of plaintiff number 2 and other members and are the genuine members of the plaintiff number 1 society. Further, by way of permanent injunction, defendants are hereby restrained from obstructing day-to-day activities of the plaintiff number 1 society through plaintiff number 2 and her members. So now, my lord, by virtue of this decree from the civil court, again, my lord, we have approached the respondent authorities. And my lord, we try to submit, my lord, our
Injunction from the civil court.
sorry, my lord.
You got an injunction from the civil court.
I got a decree from the court, declaration that, my lord, our group is, my lord, it is a genuine members of the said society. Based on this decree, my lord, we have approached, my lord, the respondents. And we have submitted, my lord, the book of accounts as well as, my lord, all the auditing, my lord, in respect of, my lord, the regarding this petitioner society. Now, my lord, as per annexure F, they issue endorsement saying that as per section 13 of the said act.
Let's see.
Your lordship, as per section 13 of the said act, your lordship, they are supposed to give every year their audit report, your lordship.
Section 13.
Please. May I read, my lord? Section 13, balance of sheet and annual list of governing body to be filed with registrar. On or before the 14th day of succeeding day on which the annual general body meeting of the society is held, there shall be filed with the registrar a list of names, addresses and occupations of the members of the governing body then entrusted with the management of the affairs of the society, and copy of the balance sheet and income and expenditure accounted audited by a person for who under the section 226 of the Companies Act I can act as an auditor of the company registered in the proviso clause, my lord. May I read, my lord? Provided that if any of the sufficient reason a society has not filed the list of members of governing body and a copy of balance sheet and income and expenditure account on or before the 14th day of annual general body meeting of the society, it may take an application to the registrar to condone the delay and permit to file the records, and register may, if he is satisfied that there are sufficient reasons for the delay in filing such records, condone the delay and permit the society to file such records subject to payment of fine as may be prescribed, and where no sufficient reasons are shown, he may after giving an opportunity of being heard to the society, reject the application and return such records to the society. Now, my lord, immediately after passing of the decree by the civil court, we have approached, my lord, with in respect of, my lord, all the consecutive years where, my lord, as per section 30 we have not filed the accounts. Now, my lord, by annexure F, page number 41, they say that consecutively for a period of 5 years, you have not submitted the financial accounts and the list of name members of the society. So we cannot consider it and we are rejecting it. Now, my lord, as per the endorsement issued by the respondent themselves, when there is a rival group fighting, please.
That is, one aspect is with regard to the dispute inter se between the parties.
Please.
Now, when it comes to this particular section 13, you have to fulfill all that.
My lord.
You have to fulfill the requirement under section 13.
Lord, that is there, my lord, but the rival group, my lord, they are not allowing, my lord, to do the accounting and submit the members.
And what is in those circumstances, what should the registrar do?
My lord.
What should the registrar do in those circumstances?
Lord, if any sufficient reasons are mentioned for condoning why you have not submitted complied the section 13, that can be condoned. But now, my lord, the point for consideration is neither have been heard nor have been given.
In the same order itself, your lordship, further they have stated also, if they have not submitted 5 years, what is the requirements, your lordship, they should get a order from the government for renovation, your lordship. That is also they have stated.
At least I should be given an opportunity of hearing to say my reasons. That has not been done. Neither I have been given right of hearing.
Please find the translated copy of that order.
Please,
So that
please.
I'll pass final order.
Please, please.
Yes. The petition.
May I
shall file
request
a
next week,
translated-
Lord, I'll submit the translated copy of this.
Translated copy of the order. This is the matter on 9 February. Yes.
Please, Oblate.
My lord, the petitioner is a sister of the respondent number 225, my lord. My lord, the land shown in the suit property merely ancestral property. The self-acquired property of the father of the present petitioner, my lord. Without give any share, my lord, the obtain the decree, my lord. The petitioner is challenging that order.
So this is dated 24/4/2019.
19. As per the agreement, as per the compromise, as per the compromise, suit for partition and separate
You're
position.
not a party to the proceedings.
He was a party.
Then-
As per the agreement, my lord, the respondent number 225 pay the 50,000 rupees each to the petitioner. Till today, they have not paid.
They have not paid. What is the remedy available to you?
Then, my lord, another contention, my lord, exhibit, kindly annexure D, kindly see, my lord.
Page number.
Page number 42, annexure D. Survey number 55/9. The Bhimappa is the proprietor. The two property are not included in the suit. 55/9,
Have you signed the
55/1.
Have you signed the compromise decree or not?
As for the in the compromise decree,
Have you raised any of the grounds at that point of time?
as per the compromise decree, the respondent number, defendant number 1, 2, 3 here in before the trial court, my lord, agreed that each defendant number 1, 2, 3 pay the 50,000 rupees to the
That I
5 to 7.
understand. If they are not complying with any of the conditions of the compromise decree, the
No,
remedy
no.
available to you is.
No,
to
as per
execute
the compromise, as per the compromise decree, they have not paid the amount. Now we are not issued that amount. You shot for the partition that suit property.
ground to set aside a compromise decree, that's what I'm asking. Is it a ground non-complying, if any of the party has failed to comply the compromise decree, is it a ground to set aside it?
Please, my lord, as per the Supreme Court judgment, my lord,
Please show the Supreme Court.
please, my lord. The High Court has rejected the compromise petition, my lord. The petition appellant is approached the Supreme Court. Kindly first para, my lord. The present appeal arising from the judgment and decree dated 6/11/2023 passed by the division bench of the High Court, Madhya Pradesh, Jaipur, in the writ appeal so and so judgment. The division bench aforesaid the order dated 27/2/2023 passed by the learned single judge in the writ petition so and so.
According to the appellant, he became aware of the decree and the execution proceedings only when the police authorities visited the property for the purpose of executing the warrants of possession.
Please.
When you are not a party, some compromise decree is obtained by way of fraud or collusion or other things. Those are the grounds to set aside.
No, as per the compromise petition, my lord, defendant number 1, 2, 3 not pay the amount. Now we are not issued the amount. We are.
I understand. Yes, you can rely on the judgment. Yes, which paragraph?
This page number para 60, last para 20, my lord.
Yes.
Sorry, 19. It is made clear that you have next exam and expect no option to update relevant contention on the fraud, collusion with the limitation title and other factual is arising the compromise local award for
Where are you reading? Paragraph?
19, my lord.
19. It is made clear that.
Please, my lord. It is made clear that we have not examined and expressed the opinion upon the relevant contention on the fraud, collusion, limited title, and any other factual issue arising out of the compromise Lok Adalat, Award 14/5/2022. The concerned decree, the sale deed dated 22/7/2022, or execution of the proceeding, all such questions, including the alleged collusion and abuse of process, are left open to the considered by the High Court. The set aside both the order and remand back to the High Court.
Yes.
In the several case, my lord, this honorable court also set aside a compromising decree, my lord. I'll produce that.
Not about, I'm not saying that this court is powerless to pass such an order. Court will pass an order. Under what circumstances the court will pass order is the question.
As per the compromising decree, they have not paid the 1,50,000 rupees to the petitioner.
On that ground, it cannot be.
My
On that
lord,
ground, it can't be.
one side, my lord, other ground, my lord, the ancestral property, two ancestral property not included in the suit property. The suit is not, itself is not maintainable. In the plaint, they have shown in the RS number 82, 83/1, 83/2, self-acquired property of the father of the petitioner. Kindly see page number 15, my lord. The uncle of the Shankar, uncle of the petitioner has filed a suit. They have not tried to file a suit before the trial court. The document, in the suit, the RS number shown in the suit, my lord, they have not the self-acquired property of the father of the petitioner. They have no right to file a.
Then why did you enter into a compromise?
My lord, the January he filed a suit. February he referred to the Lok Adalat.
But you were there, you signed it. It's not your case that you are made to do something
My lord,
contrary to your
illiterate lady, my lord, illiterate lady, they have not know any proceeding, my lord. The suit filed by the plaintiff itself is not maintainable. All those suit property was not included. 55/90, 54/1, 55/9, 3 acre 90 gunta, 2 acre 20 gunta. They have not included the suit property. The suit property is ancestral property.
Please come. The present petition is filed, seeking the following prayer. The facts of the case are: the petitioner and respondent number 2 and 8 are members of the Hindu undivided family. There is no partition between the petitioners and respondent number 2 to 5 herein. The respondent number 1, 6, 7, 8 are nowhere consented to sue scheduled properties.
The suit involved in the property is not an ancestral property, self-acquired property of the petitioner father.
It is stated that the defendant number 1 to 4, sons and wife, defendant number 5 to 7 are the daughters of Devappa, Bhimappa, Vadiyar. The plaintiff and defendant number 8, 9 and 10 are no way concerned with the suit scheduled properties. The plaintiff has not included the ancestral property of Bhimappa, Vadiyar. The plaintiffs and defendants without knowledge, without given share to the petitioners, colluded with each other and obtained a decree. It is stated that the suit properties are the self-acquired property of Remappa, Bhimappa, Vadiyar. Without allotting share to the petitioner, they obtained decree illegally and arbitrarily and against the principles of natural justice. It is stated that when the property is a self-acquired property, the plaintiff and the respondent number 1 herein filed suit for partition and separate portion, that is OS number 49 of 2019, before the senior civil judge at Raibagh and got compromised in Lok Adalat dated 24/4/2019 without giving share to the petitioners. It is stated that the respondent number 1 and 2 to 8 have filed the compromise petition under Order 3903 dated 24/4/2019 without issue notice to the defendants in the suit. Refer the matter to the Lok Adalat. Petitioner and respondent number 1 to 8 are present. As per the compromise petition, the respondents have compromised a dispute before the Lok Adalat and the suit is decreed in terms of the compromise. It is stated that the trial court, without giving proper opportunity to the petitioner, had referred the matter to the Lok Adalat. The matter is taken up at Lok Adalat. The parties are present along with their counsels. On conciliation, parties have settled their disputes and have filed a compromise petition and joint memo. It is stated that respondents number 2 to 5 have given assurance to the petitioner that after the compromise, the respondent 2 to 5 orally agreed that they have given rupees 3 lakh each to the present petitioner till today, and they have not given till today, and they have not given, and they will not give any amount. Land counsel appearing for the petitioner submits that the compromise decree needs to be set aside on the ground that, as agreed upon, the respondent plaintiff has not paid the amount of 50,000 each to the petitioners.
Please.
Further, the self-acquired properties are shown as the joint family properties. Correct?
And also, my lord, survey number, ancestral property, survey number 55/9.
And the ancestral properties are not included.
Included survey number 55/9 and 55/1.
59/1 and
59/9.
59/9 were not included as such.
The two property are ancestral property.
Ancestral properties were not included in the partition. As such, the compromise decree dated so and so needs to be set aside. The learned counsel had relied on the judgment of the apex court in case of Dilip Mehta versus Rakesh Gupta and others arising out of SLPC number 27806 of 2023. He relied on paragraph number 19. It is submitted that in several matters, this court had set aside the compromise decree, and as such, in this matter also, the compromise decree needs to be set aside and the notice may be ordered to the respondent. Having heard the learned counsel for the petitioner, that is the material on record. The petitioner wants a compromise decree to be set aside. It is not his case that he was not a signatory to the compromise decree. He was not present before the court while the compromise talks were going on or at the time of passing of the compromise decree. It is not even his case that there was any fraud or coercion on the part of the respondents. The two contentions that are raised are that the properties which are not the self-acquired properties, which are self-acquired properties are included. The properties which are the ancestral properties are not included, and that as promised, the amounts are not paid to the petitioner.
Petitioners.
None of these grounds which are raised by the petitioner can be the grounds to set aside a compromise decree. The grounds to set aside a compromise decree are on a limited ground, and the grounds that are raised by this court cannot be the ground on which this court can set aside the compromise decree. The judgment which the petitioner is relying on is a case where the person who is questioning the compromise decree was not a party to the compromise proceedings. That is clear from 3.9 of the order that is passed by the apex court, that according to the appellant, he became aware of the decree and the execution proceedings only when the police authorities visited the property for the purpose of executing the warrants of possession. The same ground is not available to a person who is a party to the compromise decree. Hence, none of the grounds that are raised by the petitioner are the grounds to set aside a compromise decree. If there is any violation
on the part of the respondents in complying with the compromise decree. It is an executable decree, and the petitioner is always at liberty to execute the same. Hence, this court is passing the following order. The writ petition is disposed, the compromise decree, the petitioner is not able to make out any grounds to set aside the compromise decree. Number two, the writ petition is disposed of, giving liberty to the petitioner to avail the appropriate remedy in case the compromise decree, the terms of the compromise decree are not honored.
Please,
Accordingly disposed of.
please.
Please, Your Ladyship.
I appeal.
Petitioners, before your ladyship, my lords, seeking, my lords, issuance of mandamus against, my lords, the second respondent. Now, my lords, second respondent, my lords, is a.
Come to your prayer.
Please, the prayer, my lords, is at page number 14, my lords.
To execute a
Cancellation deed, my lords, insofar as.
development agreement. Who are the respondents?
Please. Second respondent, my lords, is the Urban Development Authority. The cost settlements, page 6, my lords. Respondent number 2 is Hospet Urban Development Authority, which is, my lords, statutory authority under, my lords, the Urban Development Act. Now, my lords, the second respondent, my lords, induces me, saying that I am, my lords, the petitioners before your ladyships are, my lords, the owners of, my lords, lands totally measuring, my lords, somewhere around 24 acres. The second respondent, a statutory authority, induces me that I will develop your land into a residential layout, hand over you, you the developed land within a period of 3 years, if not 3 years, within an extended period of another 6 months. So they induce me, my lords, to enter into a joint development agreement on the pretext that within 3.5 years, the second respondent, which is a statutory authority, will develop the land into a residential layout and, my lords, share the developed portion of the property on 50-50 ratio each. Agreement is entered in the year 2025. Now, my lords, in the year 2026, not an inch of the land is being developed.
What is the time?
3 years.
3 years.
3 years from 2015.
Why should we pass it now?
3 years from 2015, your lordship, your ladyship, may kindly.
5 is the agreement.
2015, your ladyship. 2015 is the agreement.
2015.
2015. May I invite a lordship's attention.
What do you say?
Lords, I have filed a statement of objections. Now, my lords, we have issued a paper publication calling for tender of development, and that has been finalized, and now we have sent it to the government. This is the latest, my lords, development which I am placing it before this honorable court. And my lords, insofar as this agreement is concerned, of course 3 years time was fixed, but your lordship may kindly peruse, lords, in page 30, there is a clause in the agreement itself regarding, my lords, referring the matter to the arbitration if any party fails to, my lords, obey the, my lords, conditions, follow the conditions of the agreement. Then provision for arbitration, referring the matter to arbitration is there. They have not, my lords, approached the arbitrator. They have not sought for that any relief for the arbitrator. And now they have filed this writ petition seeking, my lords, quashing of this. Lords, in case of that non-obliging that condition or non-obeying that condition, my lords, that provision is there. Otherwise, civil court, they can approach the civil court also seeking, my lords, enforcement of this, that condition or cancellation of that agreement. Writ petition is itself is not maintainable. Now we have taken a, my lords, specific, we have taken initiative for development of the land.
But so far as, my lords, maintainability of writ petition. Now, my lords, as per the statement of objections and, my lords, the submissions of my learned friend.
Of the contracting party is the state, that will not give you a right to come to file a writ petition.
No, my lords. In fact, my lords, the Honorable Apex Court is, my lords, of a contrary view when it comes, my lords, to a contract entered with the public authority. And, my lords, if I may pass on, my lords, my apologies, I had compiled along with a memo, but inadvertently I left
No,
it.
when there is a clause for arbitration, why should you not?
That will not preclude your lordship, your ladyship, my lords, from exercising the inherent powers vested under 226. When
Is it, did the Supreme Court say that in each and every case, that's how the court will?
not each and every case, in the cases, my lords, the Supreme Court has classified. Please, your ladyship. My lords, the first judgment is, my lords, between, my lords,
But there are
the
several judgments on the other way also.
yes, my lords, indeed. But my lords, in my humble submission, I fall along the under the category where, my lords, the writ jurisdiction, my lords, by your leaderships could be exercised. The first judgment relied by me, your leadership, is of the year 2011, Union of India versus Tantia Constructions Private Limited. May I invite your leadership's attention to head note C of the judgment.
It all depends upon the facts of the case. The court, in a particular facts and circumstances, that come to paragraph number 18.
18, your leadership.
Yes.
Please. Please.
Yes.
Mr. Chakraborty submitted that.
No, paragraph 18 starts as, it may be true that in a given case.
Please. Please, your lordship. It may be true that in a given case, when an action of the party is dehors the terms and conditions contained in an agreement, as also beyond the scope and ambit of the domestic forum created therefore, the writ petition may be held to be maintainable, but indisputably, therefore, such a case has to be made out. It may also be true, as has been held by the court in Amritsar Gas Service and Venkat Krishna, that the arbitrator may not have the requisite jurisdiction to direct restoration of the distributorship, having regard to the provision contained under section 14 of the specific relief act. But while entertaining a writ petition, even in such a case, the court may not lose sight of the fact that if a serious disputed question of fact is involved arising out of a contract, quo contract, ordinarily a writ petition would not be entertained. A writ petition, however, will be entertained when it involves a public law character or involves a question arising of public law functions on the part of the respondent. But in a case of this nature, while exercising a plenary jurisdiction, we must take the supervening circumstances into consideration. The parties, admittedly, in this case, my lords, the parties had, parties admittedly invoked the arbitration agreement before the arbitrator. They entered into a settlement. Pursuant to or in furtherance of the said settlement, the appellant herein was to pay a sum of rupees so and so unto the respondent in 5 installments with interest. The appellant herein, for violation of the terms of the contract, presumably prayed for award of damages, but no reference thereto has been made in the award. In any event, such a claim of damages could have been made before the arbitrator on the ground of alleged breach of contract. We are further of the opinion that in the matter, no case has been made out for grant of relief of restoration of the dealership. The contract suit terminated on the death of the appellant's partner. No case of novation of contracts has been made out. It is also not the case of the parties that any other or further agreement between the parties came into being. The arrangement was an ad hoc one. The appellant did not derive, my lords. May I invite the leadership's attention to another judgment also, my lords, where, my lords, the Honorable Apex Court, taking note of, my lords, the earlier decision in ABL case, was pleased to observe as in what circumstances could a writ petition be entertained. Here, admittedly, in my humble submission, my lords, the respondents are not disputing the execution of the joint development agreement. Neither are they disputing that they have not complied with the terms of the agreement.
No, you have an arbitration clause. Why should you not have that? Why should you not invoke it?
But lords, the arbitration.
There is no such law that you can't. In this case, the parties have already availed the arbitration.
The parties had.
So
But lords, in the other case that has been relied upon by me for a minute, if I may pursue your lordship.
Which paragraph?
Paragraph head note C, your ladyship, 2011 5 SCC.
Yes.
Existence, availability of arbitration clause in agreement. Well, lords, this is Union of India versus Tantia Constructions. Held arbitration clause is not a bar for invocation of writ jurisdiction when injustice is caused and rule of law violated. Constitutional powers vested in the High Court or Supreme Court cannot be fettered by any alternative remedy.
That is a general rule. That is a
General rule. I fall within this general rule, my lords, for the reason that since 2015, my land has been kept idle. My lords, there's gross injustice on me. I have not been,
Why did you enter into, for any public purpose, both of you have entered into an agreement?
my lords,
For your interest.
my interest, but my lords, the respondent,
Interest,
my lords,
like any other third party, like
Certainly,
any other,
certainly.
you know, contracting party.
Please, my
They have
lords.
entered into an agreement, they said we will do it. They have not done it.
Done it.
There is an arbitration clause, you invoke it. Now that much water has flown, 15 plus 3 is 18. Now we are in 26. Already
Please.
so many years have lapsed. by.
Lapse, no development. That in, my lords,
You would have filed a suit.
Lords,
You had the remedy
my
of.
lords, my humble submission is, I have already underwent, my lords, such an injustice, my lords, at the hands of second
What were you
respondent.
doing? Which year is this writ petition?
Last year, my
Why did you
lords.
keep quiet for the last 10 years?
Lords, I have been persistently persuading them. They have been,
Legal remedies you have not availed.
lords, but that cannot, my lords, in my humble submission, would preclude your leadership from exercising this. Here, my lords, it's not at all disputed by them that they have entered into the agreement, nor they.
So if there is no dispute, all contractual obligations, court will interfere.
If there is, my lords, injustice,
It's not
if
the
there
law.
is
That's
injustice,
not the law. These two judgments does not lay down any such law. These are all on facts and circumstances and all general rule. So first you tell why you shouldn't go avail the remedy of arbitration.
one more judgment, my lords, of the Supreme Court.
Take that.
2004, my lords. As early as 2004, my lords, the Honorable Apex Court, since para 8 onwards, my lords, if I may invite your lordship's attention to. Para 8, my lords.
Yes.
As could be seen from the arguments addressed in this appeal and also from the divergent views of the two courts below, one of the questions that falls for our consideration is whether writ petition under 226 is maintainable to enforce contractual obligation of the state or its instrumentality by an aggrieved party. In our opinion, this question is no more res integra and is settled by a large number of judicial pronouncements of this court in Kane Guruswamy, at this court at para 20 held as under. The next question is whether the appellant can complain of this by way of a writ. In our opinion, he could have done so in an ordinary case. The appellant is interested in these contracts and has a right under the laws of the state to receive the same treatment and be given the same chance as anybody else. We would therefore in the ordinary course have given the appellant the writ he seeks, but owing to the time which the matter has taken to reach us, a consequence for which the appellant is in no way to blame, for he has done all he could have done an earlier hearing. There is barely a fortnight of the contract left to go. A writ would therefore be ineffective, and as it is not our practice to issue meaningless writs, must be dismissal the appellant leave the appellant with an enunciation of the law. It is clear from the above observations of this court, the said case, though a writ was not issued on the facts of the case, this court has held that on a given set of facts, if a state acts in an arbitrary manner, even in the matter of a contract, an aggrieved party.
Precisely what I am saying is at para 13.
Para
13.
Please. We do not think this court in the above case has in any manner departed from the view expressed in the earlier judgments in the cases cited herein above. The court in the case of LIC of India proceeded on the facts of that case and held that a relief by way of writ petition may ordinarily be an appropriate remedy. This judgment does not lay down as a rule in matters of contract the court's jurisdiction under 226 of the Constitution is ousted. On the contrary, the use of the words courts may not ordinarily examine it unless the action has
Public law character attached to it.
here also, my lords, there is a public law character. My lords, the land, my land, my lords, for a decade has been, my lords, kept idle.
No, it's not about that.
For the purpose.
While you are entering into an agreement.
Please, my lords.
For your benefit, you have entered into a contract for development of the land like any other party.
Well, my lords, the second respondent would get, my lords, the authority to enter into an agreement only under, my lords, the law, the Urban Development, my lords, Act. Without dehorse that, my lords, that in itself is, my lords, exercise of, my lords.
Already we are using the jurisdiction under 226 for each and everything that goes around. Now, when you have a contract, when parties, just because the state is a contracting party, that itself will not be a ground.
So true, my lords. I bought
Whatever the nature of the contract between you and
Please,
them is to develop the land. They are not doing. You want to contract to be set aside. For
Please.
that, you have two remedies. One is to invoke the arbitration clause, or as the specific performance of that agreement was not done by them, within no time that can be set aside, that the decree would be passed. Why should we interfere in a 226?
My lords, may kindly consider that second respondent is in statutory authority formed under an act. Could, my lords, my lords, be acting as some other, my lords, like a private party?
No,
It
when
has
he has
to.
entered into a contract, he entered as any other, that contractual obligation is like any other private party. Not that, no, he is developing. From his work, you are also benefited. It's only a benefit between the parties.
True, my lord,
In
but
the process of, for some public purpose, that contract is not entered between you and him.
But, my lords, in my humble submission, this, my lords, inaction on part of, my lords, the second respondent in not developing the land for more than a decade would amount to,
He
my
has
lords,
his own reasons, whether those factual reasons are correct or not. We can't decide.
that is arbitrary, my lords, and violative of Article 14 is my humble submission. So, in that event, your lordships can,
No, where in the contract, where from Article 14 has come?
my lords, it does, my lords, if I may,
Yes.
that's what, my lords, the Honorable Apex Court has said, my lords, even in contractual
If you
matters.
want, I can pass orders considering all those judgments you are relying on. Or if you want me to adjourn the matter, I'll adjourn the matter.
Please.
Yes, this is matter in the month of March.
Obliged.
Yes, 49.
May I make a mention, my lords, lordships?
Please,
May I
Madam
make a
The
Parvati.
memo is moved for this matter.
Sorry, my lordship. Sorry, my lordship.
No, that's what is everybody is doing. Why the memos are moved, I'm not able to understand for the matter.
I need to.
It's like that because the court is granting,
Sorry.
memos are moved. Yes, what is the urgency in this matter?
So, my lordship, I need to file necessary documents for bailiff reports, my lordship.
Huh?
Bailiff reports I wanted to file, my lordship.
What is that?
Bailiff reports, my lordship.
Huh.
I wanted to file
Then
before.
why did you move the memo?
Sorry, my lordship.
This is matter in the month of June.
Bless.
Yes.
Seal number 50. Tony SM.
The matter pertains to arising under the Payment of Gratuity Act, both of the controlling authority and appellate authority. Appellate authority is rejection on the ground of delay. Delay is not condoned. And only on that ground the appeal is rejected. Both the orders are in Kannada, if I may pursue.
Provision to condone the delay.
There is no absolute, but the 7.7 says only,
Give that. What is the act?
please. Merits, pursue your lordship to section 7, subclause 7, madam.
Seven, subclause 7.
Subclause 7. Am I permitted to read?
Payment of Gratuity Act.
Please.
7,
Subclause 7. Any person aggrieved by an order under subsection 4.
Yes, any person.
Any person aggrieved by an order under subsection 4 may, within 60 days from the date of receipt of the order, prefer an appeal to the appropriate government or such other authority as may be prescribed by the appropriate government in this behalf. The proviso, my lord. Provided that the appropriate government or the appellate authority, as the case may be, if it is satisfied that the appellant was prevented by sufficient cause from preferring the appeal within the said period of 60 days, extend the said period by further.
20 days.
Please, my lord. The appeal was filed post 120 days with application under section 5.
Where is that? But it is, that is.
No,
limited to only
my lord, my submission being the proviso didn't end up with telling that no, not thereafter. So when there is no express exclusion of section 29 of the Limitation Act.
When it is very clear.
Please, ma'am.
The proviso is very clear. It says.
Please.
60 days extendable to another 60
Another
days.
60 days.
When it says extendable to 60 days.
Please,
No, if it stops here without the proviso says may, the court, the so and so may.
My submission being, my lord, being a beneficial legislation as such,
But the
number one.
The similar thing is employed in the Motor Vehicles Act. in other provisions also.
Please, ma'am.
Then where there it is, and particularly to the authorities, they will not have any power under section 5.
My lord, my humble submission is there is no express exclusion of Limitation Act.
Clear. File your objections.
Please.
So and so takes notice on behalf of the respondents. They'll file their objections.
My lord,
Yes.
one submission. Contesting respondent number 4 is there. She is a private party. 1 to 4 is government.
1 to 3 is.
1 to 3 is the government, my lord.
SCGP takes notice. 4, no, issue notice.
Much of.
Number 51. And order is passed by whom?
By the appellate authority.
So that they have to file their counter.
I'll take
Being a quasi judicial, please.
Yes.
Please.
Yes, next.
Seal number 51.
Lordship, wherein this, the mutation entry, we are seeking to mutate the.
Switch on the phone, mic. You can be little louder, I'm not able to hear anything. Yes.
Please, my lord, may I make submission? Please, my lord, the petitioner have challenged the notification, my lord. Therein, after petitioner have filed a suit against the Waqf board, my lord, suit for declaration, and the same was decreed, my lord.
What is the notification?
My lord,
Declaring them as the properties of the Waqf.
please, my lord. And that,
What is the remedy if a property is declared as a Waqf property?
my lord, we have challenged that as well, my lord, and civil suit also was pending before against the Waqf, my lord, and that was decreed in favor of the petitioner. And that was challenged by the Waqf board, and the RA is also dismissed, and OS judgment is confirmed, my lord. Based on that degree, our name is to be entered in the revenue records, removing the name of the Waqf, my lord.
Who is for the respondent?
My lord.
State Board of Work, who represents?
Mohammed.
So and so is directed to take notice on behalf of the first respondent. Second?
Same.
Same, 1 and 2,
Please.
he takes notice.
Please.
1 and 2, so and so. Petitions as the copy of the writ petition on the council. List this matter on 17th of February.
Please, ma'am.
Yes, 52.
This matter, my lords. The petitioner is the elder sister of the respondent, my lords. She was issueless and houseless lady. She having some one site, my lords. When she is old age, she trying to get the house by the house construction by the government. His own her own brother, my lords, falsely misguided her to get the house benefit. He took her to sub-registrar office and get the registration as
No,
the.
this is CPC matter.
Please, my lords.
What is the suit for?
Suit for declaration. He filed a suit for declaration and injunction saying that.
Owner of the property.
My lord,
He's the owner of the property.
he is the owner of the property.
What
I
is
filed an
the
application for the application is not maintained because AC and the authorities AC and DC have passed an order saying that this matter is particularly comes under the definition of Senior Citizens Act. That is the reason I filed an application for the application before the learned trial court seeking that dismiss the suit as not maintainable. The
Why any suit against a senior citizen is not maintainable?
because misguiding her, he obtained a sale deed. That is the reason. The act itself clearly says that not
No, let's see the act. I don't
benefit.
think so. Let's see the act.
Section 23 of the act.
So any suit is not maintainable against a senior citizen?
No, not at, by saying not at this marks. My contention is that not
No, that has to be independently adjudicated by the court.
because Marx falsely misguiding her, he obtained a registered sale deed. That is
How one will know?
because she is the senior citizen. She is the elder sister of the petitioner respondent. That is the reason the matter is coming under the definition of Senior Citizenship Act.
That means it says that all proceedings,
Not-
all proceedings against them are
Not
barred by any other law.
Because of that reason.
Will you say
Section 23 it clearly says that.
Let's see. What did the court say? Please.
Court
come to
says
the-
that section 23. The court says that here the petitioner is not a daughter, father or mother. She is the sister.
Maintenance and welfare of senior citizens.
Also.
Conditional transfer made by the senior citizens are the only matters governed under the act.
Please.
So here is a case that he himself is the owner of the property.
That is the reason by misguiding her, my lords, the
All the
sale deed
issues
came
to
to
be decided. How
that
can
is-
we, how can you presume that the property
she
belongs to her?
80
and
years
it has-
old woman. That is the reason only I am before your lordships, my lords.
Let's read the order. Come to paragraph number
Last paragraph, my lords.
7.
Para number 10, my lords.
Reasoning part, please read.
Para number 10, Learned Counsel for Defendants cited so and so. In the said case, mother had transferred her share in favor of the son and under bona fide belief that he will take care of her in her old age. But transferee did not fulfill the obligation. As such, Assistant Commissioner exercised his power under Section 23 of the Act, which has held as justified by the Honorable High Court of Karnataka, considering the fact that condition attached to transfer was violated by the transferee. But in
Please
the
come to the plaint. Let's see the plaint.
Please,
What did he say?
please, madam.
Plaint is in Kannada.
It is in Kannada, my lord. That is all documents.
What he says? Did he say that the property belongs to her and she transferred it to him?
That is the contention of the plaintiff before the trial.
Where is it? Read. Which paragraph he said?
My lords, he filed a suit. Prayer is, my lords, lordship. Para number 5 onwards, my lords. ಪ್ರತಿವಾದಿಯು ಸಾಕಷ್ಟು ಶ್ರೀಮಂತವಾಗಿದ್ದು ಅವರ ಸಹೋದರಿ ಮತ್ತು ಶ್ರೀಮತಿ ರತ್ನಮ್ಮ ಇವರ ಜೊತೆ ವಾಸವಾಗಿರುತ್ತಾರೆ. He contended that defendant who is none other than petitioner herein was very rich and he is residing with him and his wife. She has falsely stated that she sold out the property. She executed a registered sale deed in favor of him. On that ground only, my lord, ಇವರ ಜೊತೆ ವಾಸವಾಗಿರ್ತಾರೆ. ಒಂದು ವೇಳೆ ಪ್ರತಿವಾದಿ ಈ ವಾದಿಯ ಜೊತೆ ಜೀವನ ನಡೆಸಲು
referring to section 23,
my lords.
Let's see.
Here it's very clear, my lords. ಇಚ್ಛೆ ಪಟ್ಟಲ್ಲಿ ವಾದಿ ಪ್ರತಿವಾದಿಯನ್ನು ಸಹ ತಮ್ಮ ಜೊತೆ ಇಟ್ಟುಕೊಳ್ಳಲು ಈಗಲೂ ವಾದಿ ಸಿದ್ಧವಾಗಿರುತ್ತಾರೆ.
Where any senior citizen who after the commencement of this act has transferred by way of gift or otherwise his property, subject to the condition that the transferee shall provide the basic amenities and basic physical needs to the transferor, and such transferee refuses or fails to provide such amenities and physical needs, the said transfer of property shall be deemed to have been made by fraud or coercion or under undue influence. That's what it is. So how does this case fall under this 23?
Because there is no terms in the very sale deed, my lord. That is the reason only I am saying.
That's why it will not fall under.
She is aged about 80 years, my lord. She no other issues, even though issues houseless. And when she is trying to get the house construction, he misguided her to get the construction the house.
Let all these issues be decided by the court.
That is the reason I am before lords.
A number 3 is filed.
13, my lords.
Agreed with orders passed in I number 3.
Sorry, please.
In OS number 56 of 2020. Dated orders passed in I number 1, I number 3 in OS number 56 of 2020 dated 19 June 2025. The defendant is before this court. The respondent herein has filed a suit for declaration. In that, an IA number 3 is filed under order 7 to 11 to reject the plaint. It is a case of the defendant. That defendant is a senior citizen and this suit falls within the domain of the Senior Citizens Act. As such, a suit is not maintainable. The court by order impugned had dismissed the said IA. While dismissing the said IA, the court has observed that the present suit is filed for declaration of title, which is outside the domain of Senior Citizens Act, and as could be seen from the plaint, amendments, no condition is attached to the sale deed said to have been executed by defendant with regard to the welfare of the senior citizen. Thus viewed from any angle, it is not possible to hold the defendant has made out grounds to reject the plaint. Next parallel, and counsel appearing for the petitioner defendant submits that the court ought to have rejected the plaint as the defendant is a senior citizen and the plaintiff is none other than the brother of the senior citizen. In fact, he has induced her and got the sale deed.
Please.
Got the sale deed. It is submitted that in view of the bar under the senior, and this falls under the Maintenance and Welfare of the Parents and Senior Citizens Act 2007, and a suit is not maintainable. Court has failed to consider the same. Next para.
Having heard the learned counsel for the petitioner, peruse the entire material on record. The the contention that is raised by the petitioner that the present suit is barred in the light of section 23 of the Senior Citizens Act 2007. This court finds no force in the said submission. Section 23 of the Act reads thus. Please extract it. Section 23. A bare reading of section 23 makes it clear that in the if there is a promise in the sale deed or in any transfer that's made by the senior citizen, then section 23 is attracted. This is not one such case. However, that is it is the contention of the defendant. Contention of the defendant cannot be taken into consideration while considering an application under Order 7 to 11. While considering the application under Order 7 to 11, court can only consider the plaint and the document that are filed along with the same. In that view of the matter, this court do not find any reasons to interfere. Accordingly dismissed.
But this order is itself not
This order, the court has not expressed anything on the merits of the matter, and this order will not, the court, uninfluenced by any of the observations of this court, shall consider the suit on the merits of it.
Please.
Yes.
My senior is sitting in VC. He's requesting serial number 100 minutes. So Lordship may have it on 29th minutes.
Lord, I am coming there personally.
That day,
It requires personal hearing. I'm sorry, Lord. Would it
That
be
day
29th?
personally
Lord, I'm coming there. Personally.
petition,
number
petition
100.
carving.
He has moved the memo. Is it
Somewhere
informed
put
to
the
them?
memo. Some difficulty was, my Lord, and I'm not able to be there. My
I
Lord,
informed him.
Are you informed?
Already I informed.
This is matter on 9th
29th.
February.
29th minutes.
29th.
He's coming. Personally, he's coming. Minutes.
Not
Personally, I have
possible
to be
9th. No, that's why please come on 9th. Yes. Next matter.
Please.
This 54?
Number 54.
Yes, 55?
55.
53.
53.
53?
Yes. My Lord, the petitioner is seeking a writ of mandamus, my Lord. The land bearing survey number 225/5 was granted to three brothers, Kallappa, Arjun and Monappa.
Now let's see, what is the mandamus?
Yes.
Prayer, where is your prayer?
My Lord, to enter the name of the petitioners are the legal heirs of one Kallappa and Arjun, my Lord. Earlier, Kallappa, Arjun and Monappa had filed writ petition.
Now let me look at your prayer.
Yes.
Respondent to consider the representation dated 5/8/2025. What is the representation?
To enter the names of the present petitioners, because earlier their father and uncle, they had approached this honorable court. This honorable court allowed the writ petition and issued a mandamus to enter their names. But that mandamus was given to the assistant commissioner. In fact, under the provisions of the Karnataka land reforms, Karnataka Revenue KLR Act, my Lord, it is the Tahsildar who has got the jurisdiction to enter the name. And therefore, the mandamus was not implemented. And during COVID period, the Kallappa and Arjun, they died. And the present petitioners are the legal heirs of Kallappa and Arjun, and also Monappa, who was the petitioner number 3.
Your Lordship, as the representation dated 5/8/25, Your Lordship, if sufficient opportunity is given, Your Lordship will consider. If at all, Your Lordship, if at all it is not considered, then.
It is not yet considered.
Because
I don't understand, what is that?
If at all this.
This is 5/8/2025.
25, Your
Considered
Lordship.
within a period of 8
Please.
weeks.
Please,
If you have considered, fine, not considered, considered within 8 weeks.
that may be passed.
The present, the writ petition is filed seeking the following prayer. They submitted that the petition has given a representation dated 5/8/2025 and the respondent have not considered the same. Hence, this court is passing the following order. The respondent shall consider the representation dated 5/8/2025 in accordance with law within a period of 8 weeks from the date of receipt of the copy of the order, accordingly disposed of.
Dispose.
Yes.
54.
that matter, that afternoon matter, where is it? We'll take it up at 3:30.
I'm sorry, ma'am.
We'll take it up at 3:30.
3:30.
Your
ma'am.
matter.
Please.
Because like there is list is still, so that we'll complete, because it'll take some more time.
Please, my lords.
Lords, kindly, my lords. Serial number 15, my lords, may I request for 22nd, my lords, please to post it, my lords. Instead of 22nd, can I request for 29th, my lords? Some instructions, 29th. Students matter, my lords.
29th, yes,
Because, my lords,
29th.
please, grateful.
One submission. List number 2, serial number 20, but at least end of the day, my lord, because I am coming from Bangalore at least, an opportunity of being had.
Yes,
Yes, sir.
that matter, end of the list.
20, list number 2, second list. G. Shankar.
56. Yashodhar?
Minutes, I appear minutes for the petition minutes.
Yes.
Minutes, Mandam is seeking minutes a direction. Minutes will find the prayer minutes at page number 18 of the writ petition. Minutes, what has happened is minutes of show cause notice was issued to me minutes stating that the rule 3 minutes of the KCSR rules was violated. The allegation that minutes, the then in charge minister minutes of the district had called me and I had misbehaved with him. On that basis minutes, I was suspended for 6 months. No pay was given to me. After the suspension got over minutes, I wrote and I requested for a DE to be conducted, departmental inquiry, which was not done. Minutes, this was in 2022. Minutes in 2024 minutes, they come to issue a show cause notice to me. Minutes, charges were framed as against me. I have responded to that. Despite that minutes, they have not conducted or concluded the departmental inquiry minutes, and minutes, my difficulty is that minutes, there is some blemish on my reputation now. All I'm seeking is minutes, let my representation be considered. Let them conclude the inquiry minutes. Whatever happens outcome minutes, I will.
Where is the government?
Is it?
HCTP takes notice.
One and two minutes.
Respondents 1 and 2.
JM Anil Kumar for 3 minutes.
2 for 3.
JM Anil Kumar.
So and so is directed to take notice on behalf of respondent number 3. Then consider the petitions to serve the copy of the writ petition. List this matter on 5th of February. By the time the respondent shall get instructions, or else appropriate orders will be passed.
They request for the 6th incident. Some difficulty on the 5th minutes, but request for the 6th.
Yes, 6th of February.
I'm sorry, Lordship.
Minutes.
Get instructions. Yes.
Please, Lordship.
Number 57 to 59, urgent number 60.
I'm so sorry, minutes. May I only make 1 second, minutes? Minutes, in 50 minutes, I made an interim prayer minutes for release of the 6 months of the salary which has been withheld. I understand minutes, it's not something I would.
Without getting any instructions from the other side, we can't pass any order.
I board on minutes. I board
That day
on.
we
I'm
will
ready. Please, minutes, please.
60.
I board on.
Play, Lordship. This thing is for general paralyzed concern, Lordship.
Give that police. Who needs to pass the order in this?
Please, Lordship.
The state of, that is the first respondent, the second respondent or the first respondent?
Second
Third
respondent. Second respondent passed the order, Your Lordship, usually. But in the,
Second respondent needs to pass the order.
please, Your Lordship.
Then what is this prayer? To quash the report submitted by the respondent number 4. Where is the order of the concern?
The page number 21, Lordship, annex D.
21, passed by whom?
4, Lordship.
4 is a police
4 is
inspector. How is he concerned? Who has to pass the order?
No, Lord, 3, Lordship, instead of 3. 3, Lordship.
Chief Superintendent Central Prison will pass the order.
Please, Lordship.
Against that, appeal lies to whom?
No appeal is there, Lordship, in this case. No,
Government will not consider in this case.
no appeal,
No,
Lordship.
Your Lordship. Usually, what happens, Your Lordship, they'll give a representation for parole, Your Lordship. Then they will consider, or they will refer it to the local police, Your Lordship, to give a report.
So
On
third
that report, Your
respondent-
Lordship,
Third respondent will grant.
please, Your Lordship.
Where is
Third
the
res-
order of the third respondent rejecting his case?
21, Lordship.
21.
That is annex D, Lordship. No space. You know what happens in this case, Lordship, no separate order is passed, Lordship. Only what is the report is submitted to this person, Lordship, depend to, the only that copy will provide, Lordship. No separate,
What is the, why is so?
no order is passed, Lordship.
They give,
When a particular authority is supposed to grant parole, if he is not granting parole, there need not be any order.
Your Lordship, they'll pass a order. They will get a report from the officer, Your Lordship.
So something should follow after that.
Please.
No, a report is placed.
Please,
Looking at the report, whether he is entitled for parole or not,
an order needs to be passed by the
Pass,
concerned.
please,
That
Your
is the third respondent.
ಹೌದು.
If he says that he is not entitled for parole, then this court will consider.
Please, Your
Why
Lordship.
should the court is looking at an report of a police superintendent, I
That-
mean, the inspector and
that-
passing orders?
That only I have already told them, Your Lordship, because mandamus, Your Lordship, they are seeking for mandamus to consider that and pass the order.
Why
And
should,
please,
when
Your Lordship.
you can come to the High Court only basing on a order passed by the third respondent,
Please, Lordship.
rejecting your request for parole.
Please, Lordship.
So far, nobody has rejected your request for
No,
parole.
that copy is issued, that is the deemed rejected, Lordship. That is a D, Lordship. Last, there is sentence, Lordship. Last sentence.
Sir, we'll pass, Your Lordship,
Parole
but
ರಜೆ
in
ಮೇಲೆ
this-
ಬಿಡುಗಡೆ ಮಾಡಬಾರದಾಗ ಅಭಿಪ್ರಾಯ ವರದಿಯನ್ನು ಸಲ್ಲಿಸಲಾಗಿದೆ. That copy to certified and give, Lordship. They will not separate order is not passed in every case, Lordship.
To do it.
Yes, that do, Lordship. They will not pass any order in every case, Lordship. Not only in this
They
case,
will
in every
pass, Your
case,
Lordship.
Lordship.
They will pass.
There is
In
no-
one of the
there is
matter is there, Your Lordship, wherein the order has been passed. He is not entitled for the parole and that has been, endorsement has been issued, Your Lordship.
No, this, whatever this in Kannada,
Please,
what he is relying on at page 19 is the proceedings of which officer?
That is respond for, Lordship. That is the report is out from this officer, Lordship. Report is out from this officer, Lordship, superintendent. He will give the, he will submit the report to the respondent to 3, Lordship.
Then what 3 did?
3 will not pass any order, Lordship. In every case,
Supposed to do?
no, he will only give that certificate copy, Lordship. That's all. Give that what is the report is submitted by the respondent, that will supply.
That is the understanding between the petitioner and the fourth respondent. We can't help it. Because as per the act, third respondent needs to apply his mind.
Please,
and
Lordship.
basing on the report of the fourth respondent, whether you are entitled for parole or not. Once if it is that, if that is decided, then this court will consider it. Why should we consider the report of the fourth respondent?
Not pass any, Lordship. Separate order is not passed, Lordship.
Let them pass. Please come.
Similar, Lordship.
The writ petition is filed. Questioning the
Lordship, in-
writ petition is filed seeking the following
Lordship,
prayer.
kindly pass on this.
Which are the provisions? I have seen, but that orders will not bind the court when they are
No,
contrary to the law. Contrary to law, contrary to the police manual. As per the, do you agree or not that the third respondent required to pass an order?
Please, Lordship.
He has not passed an order.
He will not pass the
Why
order.
this court is interfering in a report of the fourth respondent? Is he not duty bound to pass?
Please, Lordship.
If he is not passing, we'll ask them to do it. Because somebody is not doing it, High Court will not take up the activity and do all the work of the inspector of police and constable of police.
Even also not rejected, Lordship.
Huh?
Only even
Ask them to do it. Have you asked that relief long back? It would have been granted by this time. Open that provision and ask permission, sir. The writ petition is filed seeking the following prayer. It is filed by the son of the convict who is lodged in Central Prison, Dharwad, and who is undergoing the life imprisonment for offense punishable under section 302 IPC. It is stated that the petitioner's father has already undergone the actual period of 11 years, 3 months, 23 days as on 10/12/2025. It is stated that the residential house of the convict is collapsed during the rainy season. To reconstruct the said house, presence of the convict is necessary. Hence, he made the request for grant of general parole for a period of 30 days. The father of the petitioner has made a representation on 23/11/2025 with respondent number 3 for grant of general parole for the purpose of construction of the house. The respondent number 3 sought a report from respondent number 4. The respondent number 4 submitted the report to respondent number 3 on 6/12/2025. It is stated that the present petition is presenting this petition, having left with no other effective alternative remedy. It is stated that the respondent number 4 has submitted the report dated 6/12/2025 without considering the reasons assigned in the application.
and is to abide by any of the conditions imposed by this court. When counsel appearing for the petition submits that the fourth respondent has given a report and formally that would be the report and no other order would be passed by the third respondent. As such, there shall be a direction to the respondent to release the petitioner on parole. He had relied on some of the orders passed by a coordinate benches of this court, where the parole is granted basing on such a relief sought by the petitioner. Give that. Section, having heard the land counsel for the
Section
petitioner,
56.
peruse the material on record. Section 190 of
No, rule 191 also, section 56
Rule
of
190.
191.
Rule 190 of the Karnataka Prisons Rules 1974.
191 lordship.
190 of the Karnataka Prison Rules 1974 deals with release under section 55. As per the same, a prisoner who desires to get himself released temporarily under section 55 release on flaw shall submit an application in the prescribed form number 6 in triplicate to the superintendent of the prison. The superintendent shall forward the application as per rule 195A. The superintendent shall forward application of the prisoner for release on release to the concerned superintendent of police and the district magistrate with such remarks as he deems fit. And as per 6, the state government shall sanction furlough to prisoners subject to one or more of the conditions. Then 191 deals with parole. It is released under section 51. Even as per rule 191, the Inspector General of Prison may release any prisoner on ordinary parole under this rule, initially for a period of not exceeding 30 days, which may be extended for such period not exceeding 30 days at a time as the Inspector General deems fit. Further, the prisoner who desires to be released on ordinary parole shall submit an application to the superintendent, who shall forward the same along with his remarks to the Inspector General, along with nominal roll of the prisoner and such other information as may be required. The superintendent shall ascertain from the executive magistrate of the concerned taluk and the police concerned particulars of the securities before accepting them, and the genuineness or otherwise of the purpose for which the prisoner has applied for grant of ordinary parole. The executive magistrate and the police concerned shall within 15 days after the receipt of such reference forward their report to the superintendent without fail. If no adverse report is received within such time, it shall be presumed that the concerned police or the taluk executive magistrate have nothing adverse to report against the prisoner regarding the request made by the prisoner. The superintendent shall thereafter make his recommendation to the Inspector General of Prisons, who shall examine and pass suitable orders for release of prisoners. Then it is not the chief third respondent, it is the third respondent is not the authority. To the third respondent, they will make an application. After receiving the reports from the magistrate and the police, he shall send it to the Inspector General of Prisons as per the rules.
Respond number 2, Your Lordship, the Director General Prison and
But you are saying
correction.
third respondent is authority.
I told 2, Your Lordship, but he has submitted 3.
The examine and pass suitable orders for release of prisoners on such parole subject to the conditions. When it is the second respondent who has to pass the order, and after the second respondent passes an order rejecting the request of parole, then the cause of action will arise for the petitioner to approach this court, assailing the order passed by the second respondent. In this case, the third respondent has sought for a report from the fourth respondent, from the fifth respondent, and the fifth respondent report is assailed before this court. In the considered opinion of this court, this court cannot pass any orders considering a report of the fifth respondent when the authority who has to consider the case of the petitioner for sanctioning of parole is the second respondent. It is submitted by the learned counsel for the petitioner that in majority of the cases, the Director General of Prisons is not, the second respondent is not passing any orders, and only they will be given a copy of the fifth respondent whenever they are not granting parole to the prisoner. This kind of, if the respondents are following such a procedure that is contrary to the Karnataka Prison Rules 1974. Even as per the rules, a time limit is also fixed. 15 days time limit is fixed for the report to be sent from the concerned, that is the magistrate and the station house officer. If the report is not received, then the third respondent has to forward the same to the second respondent, and it will be presumed that there are no adverse reports. Why this procedure is not followed by the respondent is not, this court is not able to understand, and why the High Court under 226 should take the position of a second respondent and pass the orders. In the considered opinion of this court, such writ petitions are not maintainable before this court. Accordingly, this court is passing the following order. Whenever an application is filed by the convict, the respondents shall strictly follow the procedure contemplated under 191 of the Karnataka Prison Rules 1974, and either ways an order shall be passed by the second. As per this, it says Inspector General of Prisons. He made Director General of Prisons as a party. They are one and the same.
Please, Your Lordship.
Huh?
The Director General.
It says, rule says Inspector General of Prisons.
Your Lordship.
They are one and the same.
Subsequently, it is department is changed.
The Director General of Prisons / Inspector General of Prisons shall pass an order in accordance with the rules. The copy of this order shall be, the Registrar General is directed to communicate copy of this order to the first respondent. Accordingly disposed of. If the petitioner is aggrieved by any of the order that is passed by the concerned, he is at liberty to approach this court.
Yeah, within 15 days, Lord, as per the rules itself. Within 15 days,
Within 15 days for what? Within 15 days for the report. After that, he should do it. The rule says so. That's what I recorded. Yes, next.
Number 61. I have a party. That's the same one, Lord.
Same.
The facts would change, I think.
Please.
Just look at the facts, same order. Only, no, stop getting confused. Give that. The petition is filed with the following prayer. The petitioner is the wife of the convict who is lodged in Central Prison, Dharwad, who is undergoing the sentence of life imprisonment for offences punishable under Section 6 of the POCSO Act. It is stated that the convict has already undergone the actual period of 12 years, 10 months, 6 days as on 11/12/2025. The father of the convict is suffering with old age ailments. Currently is on bed rest. Hence, presence of the convict is necessary to take care of his father. In this regard, the petitioner, the husband of the petitioner, had made a representation on 26/11/2025. The third respondent sought a report from the respondent number 4 on 2/12/2025. He stated that till today, respondent number 4 did not submit the report to respondent number 3. Hence, no order is passed by the respondent. Hence, the present writ petition is filed. As per Rule 191, so and so, if no report is received from the magistrate and the station house officer, it is deemed that there is no adverse report. In the light of the same, the respondent ought to have considered the case of the petitioner in accordance with the law. That is, whether he is entitled for parole or not. The respondent cannot keep the matter, without considering the said representation, only on the ground that no report is received, is contrary to the rule. Hence, the writ petition is disposed of, directing the respondent number 3, two and 3 to consider the representation dated 26/11/2025 within a period of 3 weeks from the date of receipt of the copy of the order. This next.
Number 62. I have a part. That's the same.
What about this?
So consider representation. Same order. No,
Same order.
Same. No, it passed second order lots. As per second order.
In this case, extract the prayer. The petitioner is the mother of the convict, who is convicted and undergoing the sentence of life imprisonment for the offences under section 302, 307, 326, 504. And he has already undergone 7 years, 6 months, 6 days as on 13/12/2025. The mother is suffering from severe lower back pain, and due to which she is unable to walk and sit. Currently, she is on bed rest. Therefore, the presence of the convict is necessary. He made a representation to the third respondent for grant of general parole for the purpose of taking care of his father. What is this? You say the petitioner is the mother of the convicted, and who is not feeling well? She is not feeling well, and you say that for taking care of his father, he should be granted for parole. For taking care of the mother. And in that regard, he gave a representation on 29/11/2025. Until today, in turn, the third respondent has called for a report from respondent number 3. Until today, respondent number 3 has not given any report. Same order, like the remaining. Disposed
Number
of.
63.
My lord, I'm on VC. I'm appearing for the petitioners, my lord. This is a case, my lord, where a government order, my lord, directing closure of Janaushadhi Kendra was passed. Coordinate benches, my lord, have quashed the government order. My colleague, my lord, physically present, is handing over the same in the memo.
Your Lordship, AAG will appear, Your Lordship. AAG will appear in these matters, Your Lordship. On the last occasion also, he has made a submission.
What is this matter?
Janaushadhi Kendra, Your Lordship, where the medical shops were opened in the premises of, it is a central government scheme, Your Lordship.
No, according to you, this is not covered with judgment. When will he
that-
come?
It is
Kindly
covered.
pass, Your Lordship.
Ask him to come.
Please, Your Lordship.
Pass over. AAG will come, it seems.
63 and
Great.
65, same.
Yes.
Great, yes, ma'am.
65, same, madam. Serial number
65 as
63 and
well.
65.
63 and 5.
65.
Both matters. Yes, 64.
Serial number 64. So for petitioner, first of all, my lord, my name Shivraj Bellaki. It's wrongly written as Balloli. Corrected in the cause list. Shivraj Bellaki, my lord, should be printed. Instead,
He is
instead
appearing.
Balloli is printed.
Oh, wrongly printed.
Wrongly printed.
Shivraj is Baloli. The so and so, the registry shall correct the name of the counsel for the petitioner. Yes.
Lord, I have challenged Annexure A, my lord, it's a order by the Karnataka Appellate Tribunal. Lord, I filed an application seeking for dispensation of deposit of 25% of the award amount. It's a statutory deposit. Lord, on the ground, my lord, that I was not liable for the entire amount which has been awarded. Your Lordship sees, but the facts of the case are that R2 Bank, my lord, sought for recovery of amount against respondent number 6 and 9, who are the borrowers. But I purchased some of the properties from one of the guarantor.
Some of the property means what is the extent of the property?
Properties, my lord, it's at Annexure F, my lords.
Yes.
Your Lordship sees, page number 80. These are in cents, my lord, certain properties. But as per their own case, Lord, my vendor, my lord, was liable only to the extent of 50,000 rupees. That your Lordship will get at, but their petition, my lord, at page number 45.
Going into that, let's see the order impugned. Where is it?
Please.
So that the court will understand.
Annexure F, my lord.
Page number.
Page number 71. But the wrong order is passed, making me liable for entire debt of about 4 crores 68 lakhs. Lord, as admittedly, my lord, my vendor, my lord, had offered collateral with respect to this property to the extent of 50,000 rupees, 50 lakh rupees loan.
Lordship, as provision says, Your Lordship, a statutory deposit is to be made, Your Lordship. It is clearly stated, page number 25, Your Lordship. If at all he is not liable, it will be adjusted in final order, Your Lordship, what the court has already considered, Your Lordship, tribunal, Your Lordship.
Lord,
Page number 25.
4 crores 68
Statutory
lakhs, my
amount
lord,
he has to deposit, Your Lordship.
File this translated copy of the order.
Pardon?
File the
Please,
translated
please.
copy. This is matter.
Lord, meanwhile,
Take
notice may
notice.
kindly.
Notice.
This can be issued.
Notice the respondent. You take notice for whom?
Please, Your Lordship.
One
For
and three,
respondent number 1 and 3, Your Lordship.
1 and 3, SCTP takes notice, but the other respondent?
Respondent 2 and respondent 4 to 10, my lords. Notice has to go.
Respondent number 2 and 4 to 10 issue notice. Please, next.
Next week. Serial number 65, urgent serial number 66. Naveen Chatra. 66.
Your Worship, the defendant has filed a present writ petition, Your Worship. Your Worship, the respondent here has filed an application under 13 1 and 2, Your Worship, before the trial court.
Filed application under?
Application under 13 1 and 2. So seeking the present petitioner from not to interfere with the peaceful possession of the property. The trial court has allowed the application. Your
For the
Worship.
defendant in the suit.
Please, Your Worship. Against that, Your Worship, the present petitioner has filed an appeal before the lower appellate court, which is came to be dismissed.
First, let's see the appellate court's order.
Your Worship, at page number 23, Your Worship. Your Worship, the lower appellate court has held that the petitioner is in possession of the property.
Come to paragraph, page number 19, reasoning part.
Your Worship, Your Worship, para number?
Paragraph 11, in page number 19.
Please, Your Worship. Your Worship, on going through the above pleadings and documents furnished by both the parties such as RTC insurance, paid receipts, 2 photos along with CD certificate, receipts, copy of the seal deed, it is found that social property stands in the name of joint name of the plaintiff and one Chandrappa son of Piringoda. Further, the property bearing RS number 218 is standing in the name of defendant. Admittedly, photos furnished by the dependent clearly shows that he is in possession of property. Your Lordship, there is a clear finding.
Please read complete.
Is possession property by cultivating it. The dependent categorically contended that the plaintiffs have mentioned the wrong boundaries. To the suit property, the plaintiff has mentioned towards western side of the property, dependent is exist. But the dependent stated that towards eastern side of the property there exist. Government was as mentioned in the sale deed. Worship, at the time of filing the suit, Your Lordship, the plaintiff has mentioned the boundaries wrongly. Your Lordship, may kindly, may Lordship take to plaintiff, Your Lordship. Towards western side is mentioned, there is the property of the plaintiff.
If you read the order, we will
Please.
understand what it is.
Please. As observation made by the learned trial court, the dispute pertaining to the boundaries of the suit property has to be decided only after full-fledged trial and by appointing a court commissioner to verify the report the same. Though the defendant stated that in the never interpreted the position of the plaintiffs, but the filing of this suit prima facie shows the interference of the defendant. Such being situation, if the defendant is not restrained by the ad interim temporary injunction, will cause irreparable loss and injury to the plaintiffs, which cannot be compensated in any mode, and very filing of the suit will become infructuous. Accordingly, the trial court rightly came to the conclusion that restraining the defendant from causing interference with the peaceful possession and enjoyment of the plaintiffs over the suit property. Hence, no interference is required in contention of the trial court. Accordingly, I answer the point number 1 in the negative. I take Lordship, the boundaries mentioned in the plaintiff, Lordship. At page number, Lordship, 35. Lordship, towards western side, it's mentioned Prativadi is number 218 property. But Your Lordship, I have purchased property in the year 2017, wherein it clearly shows that Your Lordship, towards eastern side, the road exists.
Notice.
I request that.
Two courts have held against you. Where is the question of interim order now? Notice. Petition is permitted to take out hand summons on the counsel appearing with the respondent and shall file a memo to that effect. Once a memo is filed, list the matter. Yes.
Number 67, region I.
When the notice issued by the Tahsildar, my lord, under section old act 107 of the CRPC, now the 126 of the BNSS.
Twice notice dated 30/10/2025.
Please.
Issued by respondent number
2.
Yes. What is the notice given by him?
My lord, the notice issued for the forfeiture of the bond executed by the petitioner in the old case, my lord. Under section 130 of the BNS, old cases passed the order. On the basis of that, they try to forfeit that bond, my lord. That for that the so-called notice is issued. In this coordinate.
If what is issued under the old act cannot be under the, just because the provision and the nomenclature is changed, they can't do it.
No. The coordinate bench has passed the order in this connected matter. The direction is given to give explanation before the Tahsildar.
Lordship, Annexure A, notice was issued and directed to appear. 21/11/2025, date was given, Your Lordship.
It is about the externment. This order earlier is.
No, not externment. This is under section 126.
But not since that, what you have passed on is the about externment.
Not this.
Give it to him. You want this order? You want the same order?
Same connected notice. 3 are.
Please come. The writ petition is filed, seeking the following prayer. The petitioner submits that when a similar writ petition is filed, a coordinate bench of this court in WP number 109153 of 2025 dated 8th December 2025 has passed the following order. Paragraph number 2, 3, and 4. He submits that the similar order may be passed. Accordingly, the writ petition is disposed of in the light of the order dated so and so. The petitioner
is at liberty to submit his reply, and the Tehsildar is directed to consider the same and pass necessary orders in accordance with law, bearing in mind the observation made in the course of the order. If the reply is submitted within 2 weeks from the date of receipt of the copy of the order, the Tehsildar shall pass necessary orders within 4 weeks thereafter, accordingly disposed of.
Another
Yes.
corrected matter is not posted today, my lord.
List that matter also
Please.
on Monday. Yes, 68.
68. Arunal Nilopan. Cash. Ikiri.
Respond number 1 KV terminal. I seek 1 week time for.
Lords, petitioner is the plaintiff before trial court. His application seeking temporary.
What do you want 1 week?
Well, lords, I need to produce some documents which I have already produced in the.
You
lower
have an
court.
interim order?
Pardon? No, I do not have interim order. My
Next week,
application
I'll-
seeking interim order.
This is a matter on Wednesday.
Lords, notice may be, because only caveat respond number
One.
Other respondents are there. How many respondents?
There are
5.
6 respondents.
Notice to the other respondents. Respondents number, you appear for.
Respond number 1, my lord.
You appear for 1.
1, my lord.
What are the, how many are number? 2 to 2?
2 to 6.
6, my lord.
2 to 6 issue notice to, or you will take out hand summons.
Please, ma'am.
The land council, the petition is permitted to take out hand summons on the council appearing for the respondents and respondent 2 to 6. And shall file a memo to that effect. Once a memo is filed, list the matter. Yes, next.
To be
Last
served
month.
on,
Number 69.
Yes, next.
So number 69. This is Jnana Swami.
Any date may be,
Once you file the memo, it will come.
please.
Yes,
Jnana Swami.
no
69.
representation after 3 weeks. Yes,
3 weeks.
70.
Seal number 70. Rohit L. Shilwant.
Please, lords, writ of mandamus, my lords, directing the respondents not to interfere day-to-day business of the petitioner, my lord.
As
What
the
judgment, my lords, have taken?
government has passed the order, your lordship, metropolitan cities, they can open till 1 o'clock in the night, your lordship.
Notification also.
Notification.
Government has already passed an order.
Notification is the, they have passed the, issued the notification also, your lordship,
Where
which
is
is
it?
also produced
It
along.
is at page number
So
39.
what is that they are asking now?
Open the shop till 1 p.m., 1 a.m. my lords.
As the order is already passed.
Why should there be a mandamus for that?
Lord, because the respondent number 3 is coming to the business of the petitioner and interfering.
What is the business?
Lords, it's a hotel
Hotel.
business.
No, why should the courts interfere in that? No, there, if they have.
Government has-
What, as per the GO, as per that government order,
Notification.
till what time you can open the.
1 o'clock, my lords.
Huh?
1 o'clock.
Till night 1 o'clock. your lordship.
No,
Then
there is
why
a
are you
notification.
interfering contrary to your own?
If at all, your lordship, only one submission, if at all we have interfered, let them show that notification and they can getting order from this honorable.
Why should you do it? There should
No,
be a
Your
reason for doing it.
No, your lordship, will-
What did you say? Let's see. Have you filed any piece of paper or anything to show that there is interference from them?
My lords, on record, it is nothing, my lords, but they come to the shop of the petitioner and they direct them to close the shop, my lords. And it's clearly covered judgment, my lords. I have produced that annexure E to it, annexure E to E2, my lords.
Problem is we are attending to the peripheral things. Why they are doing it is a question. Just like that, there is some order, some connected matter we pass. So High Court is not for that purpose, for every, to all the hotels to come. Why the police are doing is a question.
We have produced the notification to the concerned police.
Why don't you get instructions? Why don't you get instruction? What's happening? No, this is what happens. All connected matters, giving orders in all the writ petitions, ultimately problem will not be solved. Only what is done is we pass the orders and for each, then court has to pass orders for each hotel in the entire region.
Your
Find
lordship,
out,
as per
get
my
instructions.
instructions, your lordship.
Get specific instructions, what is happening.
Please, your lordship.
Yes. The SCGP takes notice on behalf of the respondents, so and so. She shall get specific instructions. This is matter on 29th.
29. Seal number 70, 71 urgent, seal number 72.
Recreation
Top of
club.
building.
Yes.
Particular.
72.
Connected matter, my lord. This is with respect to that recreational club, my lord. Police interference by the police, my lord.
Same matter like the earlier one.
No.
These are the clubs, Your Lordship, where they have taken the license and running the clubs, Your Lordship. And always there are in the petitions itself, Your Lordship, they have produced some copies on the order passed by this honorable court. They have laid the conditions. There are some conditions, Your Lordship, wherein police can go and verify what is happening. Those on that conditions is already passed by this honorable court. On that basis, we used to visit that recreation
Lord,
clubs, Your Lordship. Now they are seeking that direction, not to.
May, my lord. Lord, what happened is batch of matters are disposed now. Kindly see, my lord, the annexure from annexure D. There are more than 15 matters are disposed of this kind, my lord. Now, this is also similar type. Now, what happens is, my lord, every time a new officer comes, he visits the premises. We do not have any problem for visitation, my lord. The problem is they cut the video recording and they take out the DVRs from that. That's the reason now in this,
What they do?
the CCTV cameras, my lord. They cut the connections and they take out the DVR from the premises. Now that's the reason I have specifically made a prayer, that is prayer number B in this. Now if at all they want to seize my audio or video recording, CCTV, my lord, that has to be in accordance with law. That is the only condition if my lord puts it in the order. Kindly see, my lord, prayer number B.
Directing the respondents to enable to carry out the recreation activities in pursuance of the order in WP number. That prayer, why should we grant now?
No, what they do?
Order, do it in the light of that order.
My lord?
There is an order in WP number 102209.
Yes.
Signed by whom?
That is, pardon, my lord, the number of
other
there in the writ petition.
In which, my lord?
Other recreation
Here,
clubs.
look at the prayer.
Yes, yes. Petitioner was the party in that. Kindly come to annexure A.
So, as far as this relief is concerned, no further orders needs to be passed. Already there is an order in your favor. So, if they have done anything in violation of that, you have a remedy elsewhere. Then come to prayer number B. Writ of mandamus directing the respondent number 2 to 4 not to remove the
CCTV cameras along with DVR
installed in the premises of the petitioner.
Lord,
Why the respondents are doing it?
No, Your Lordship, they will not, Your Lordship. As per the direction.
I can't say they will not do. Do you have instructions?
My lord, I will explain why they are doing this, my lord. Now, what they do is they simply do not come and visit our properties. They will do many things. That's the reason videos will be recorded. They want to cut that and they will take that DVRs out. That's the reason, my lord, under 105 of BNSS, my lord, there is a specific provision. If they are seizing my, audio or video gadget, there is a procedure followed. And I am requesting. Yes, that's it.
As far as number 1 is concerned, already you have an order. This court will not pass any orders.
My lord, even after having that order.
Then one more writ petition further. Then where is the end for this? When once there is an order, you have an order. And that order has to be implemented. If they are not implementing, they will face the consequences.
Now, what happens is, I tried filing contempt in one of the writ petitions, but kindly come to annexure A, my lord. What they say is, it is of 2015. Now, the officer was different. Now a new officer comes. Every time
So this direction is to the officer, not to the police.
Police officer.
Not to the department. To every person.
Everybody is party there.
No, that's not that. If that
In
is
continuation of the previous order, my lord, prayer number B may be granted. That's it, my lord.
Please come.
But in the connected petition, fresh order has to be passed.
Let me complete this one. The present writ petition is filed, seeking the following prayer. It is a case of the writ petitioner that it was a party in WP number 102209 of 2015, which came to be disposed of by order dated
12th March 2015. Annexure A, page number 8.
By order dated
12th March 2015, page number 8. 8808.
Which was disposed of by order dated 12th March 2015.
and several directions were issued to the respondent. In spite of the same, the respondent are not adhering to the same, to the said order, and they're interfering with the petition's business. It is submitted that the petitioner has installed the CCTV cameras inside and outside the petition premises.
Lord, at page number 16, I have annexed the bill also of the CCTV.
No, where do you said that about this ground? That they are doing this activity as now you have stated that. No pleading, only prayer.
Now, my lord, for this, what happened is, after showing that order also, they are coming there.
No, you said they're doing so and so. Where did you say so in your petition? Except the prayer.
No, in the prayer, I have mentioned it, my lord.
So no pleadings are required in
No,
that regard.
pleadings are required to that extent, my lord.
Then what the court has to record now?
No, my submission may be recorded only to that extent, my lord.
You tell your submission, she will record. Because there's nothing there on your paper.
They visit the premises and they remove my CCTV without following the due process of law. That's it, my lord.
It is submitted with the grounds for the petitioner that there is a procedure for the respondent. If they require the CCTV footage or they interfere with any of the electronic gadgets that are installed in the petitioner's premises. It is submitted that whenever the new officer comes, in spite of an order by the court, they are again insisting for an order. Then the SCGP appearing for the respondent submits that as per the order passed by the as per several orders passed by this court and as per the guidelines issued by this court, they are strictly following the same, and they will adhere to the orders passed by the court. And then counsel denies the submission made by the petitioner that they're forcibly entering and removing the CCTV footage and the CCTV cameras and the recordings.
Condition number 1, your lordship, where page number 11.
Page number?
11, your lordship.
Condition number?
Condition number 1 and the condition number 6, your lordship. First condition, your lordship, the petitioner shall install within a period of 6 weeks CCTV cameras at all the places of access to its members as also at all the places.
Made available to them means not removing it. Next, the prayer that is sought by the petitioner, that is the first prayer, that to seeking a mandamus to the respondent to carry out the recreational activities in pursuant to the order dated WP number 102201 of 2015 dated 12/3/2015 is concerned. This court cannot pass such an order as already there is an order by this court, and for compliance of that order, another order cannot be passed. As far as the second order is concerned, the respondents cannot forcibly remove the CCTV cameras along with the DVRs installed in the premises of the petitioner without following the due procedure. Due procedure. Accordingly, the petition is disposed of, directing the respondents to adhere to the orders passed in WP number 102209 of 2015, and not to and without following the procedure, the respondents cannot remove the CCTV cameras along with so and so.
Great.
Yes, next matter.
I petition plus.
Yes.
Plus, Parliament directing the respondent's authority how to interfere with the Rejection Club.
Let's see your prayer. Please come to the prayer statement.
Page number 10. 10.
To permit the petitioner to open the club and to continue his right to act is as per the
That's a
bylaw,
bylaw.
not to insist upon the petitioner to obtain the license for the play of caroms, chess, rummy, etc. Karnataka Police Act on the licensing. You have instructions in this?
No, Your Lordship, but as per the order, Your Lordship, those upon those conditions, Your Lordship, by imposing those conditions,
So the
if
difficulty,
they
what
will
is
not
hap-
visit
no,
Your
What
Lordship.
is happening in all these matters is,
Please, Your
when
Lordship.
you have a notice, when the papers are served on you, you need to get specific instructions in every matter, not that because some order, some order is there, covered matter, giving orders. It is not necessary. Whether there is interference or not, that's the first question to be
Please,
ascertained
Your
by you.
Lordship.
So please ascertain from the respondents.
Please.
Yes, the High Court, CCP takes notice on behalf of respondents 1 to
All respondents.
4 and shall get specific instructions in this regard. This is matter on 5th February.
5th February.
Yes.
That's in
Number
preliminary.
73?
Plus,
Chikaragoda, Nagmur?
plus matter will list in preliminary hearing.
Huh?
Preliminary hearing will be listed in matter.
The same caption will come. Yes.
My application, my lord, for seeking for renewal of passport has been rejected on the ground of pendency of criminal case, squarely covered by the judgment of Honorable Supreme Court, my lords. On the previous occasion, I have submitted the judgment.
Yes. Why is it adjourned on the day they were not there? Yes.
So, my lords, as recently have produced the judgment of the Supreme Courts, but as per the judgment passed by the my lords, Vangala Kasturi Rangacharya Supreme Court judgment, this distinguished by the judgment by the divisional bench. This judgment also in the divisional bench passed by the Kalguri bench, my lords, where the as per the my lords 6(2)(f) of the Passport Acts, in this case, my lords, he was convicted by the trial court and upheld by the High Court. Subsequently, appeal is pending with the Supreme Court, and that judgment is correct, my lords, Vangala, because as per 6(2)(f) of the my lords.
Who are we
Please,
to say
please.
whether the judgment of the Supreme Court?
No, my lords, they are distinguished by the this honorable court in Kini judgment of Kalburgi.
How can we see a division bench judgment of this court when a Supreme
No,
Court?
my lords. That is, I go to that judgment, my lord, recent judgment. No, I have not got it. Now he has produced it.
This is matter left tomorrow.
Please, my lords.
Yes.
One copy.
Seal number 674, the Somapur.
Yes.
I'm for petitioner, my lord. The petitioner is the defendant and the respondent is the plaintiff in this OS suit number 140 of 2003 on the file of Learned's third additional civil judge and JMFC Bellary. This is a suit for declaration and injunction, my lord. And the plaintiff claims ownership of the over the suit property, and the defendant denies the same. And during the pendency of the suit, my lord, the plaintiff has filed two IAs, IA number 3 and IA number 6. IA number 3 under order 3 rule 2 seeking permission to allow the plaintiff to appoint her husband as a GPA holder, and IA number 6 under order 6 rule 17 for seeking amendment. After hearing both the parties, my lord, IA number 3 and IA number 6 both were allowed, and therefore being aggrieved by this order, the petitioner is here before this filed writ petition. My lord, as I mentioned earlier, the IA number 3, she contended that due to her ill health, she has she wants to seek permission from the court to appoint her husband as the GPA holder. But
Come to paragraph number 10.
My lord?
Come to paragraph number 10 and read.
That after hearing both the parties, the trial court was pleased to allow the application IA number 6 also.
It's an OS of 2003.
Oh, sorry. Yes, my lord. This is IA number 6. it is relevant to refer the ratio laid down by the Honorable High Court of Karnataka between Srimati.
Notice to the respondent. Petitioner is permitted to take out hand summons on the counsel referee to the respondent. I shall file a memo to that effect. Yes.
Seal number 75. Was case.
Yes.
But I'm only seeking extension of parole, my lords. The coordinate bench of this honorable court at Annexure D, my lords, was pleased to grant an Annexure C, my lords, page number 81, for parole of 60 days, my lords. Since the father of the convict,
How can there be a writ of mandamus for this?
since the representation what then filed, my lords, was not considered, my
They
lords.
should consider it. They should pass an order.
Since it was not passed then, my lords, like previously, my lords, since he was on parole, my lords, for 60 days, that date was set to be expired yesterday, my lords. So he has surrendered before, but the health of the father of the convict, my lords, is still not in a good state. So there is a liberty reserved by the coordinate bench of this honorable court, my lords.
When you're seeking something,
Please, my
there should
lords.
be that whatever right of the party shall be emanating from some rule,
Please, my lords.
from somewhere. Where what is that? No, you can come to the High Court on an order that is passed by the concern, whoever it is, that the Director General of Prisons or whatever it is.
Please, my
Now,
lords.
how come you can straight away come to this court stating that you extend the parole by 30 days to the petitioner?
Since, my lords, since there is a liberty reserved by the coordinate bench of this honorable court, my lords, and the matter then was seized before this honorable court, my lords. So the extension of the parole is again seizes before this honorable court, my lords. That is what my
Granted by whom?
parole was granted by this honorable court, coordinate bench of this honorable court, my lords. Page number 81, my lords. May I request your lordship to kindly peruse the page number 81.
What are the under which section is convicted?
Under
302. For 302 offense.
302 offense, my lords.
What is the reason for granting parole?
Since the father of the convict, my lords, was suffering and he's in a very bad state, my lords, that there is chronic illness, my lords. So the parole was sought by the wife of the convict, my lords, who is a present petitioner.
For extending a parole.
Please,
there
my
should be
lords.
While granting a parole, we need to seek for the report from the magistrate of concerned police.
Please, my lords.
That too in offences like 302, rape, POCSO offences, parole, just like that we cannot grant.
For a moment, my lords, page number
What is the
86.
material before this court about the health condition of your father?
Page number 87, my lords. Medical certificate to this effect has been
87.
appended, my lords. The typed copy is forthcoming.
By
in
whom?
The Taluk health officer, my lords.
Taluk?
Health officer. The primary health officers of each Taluk, my lords. Since they are availing medication through government medical services, my lords.
What is that? What is his ailment?
The typed copy is forthcoming in 88, my lords. It is hemiparesis with diaphysia, ma'am.
He is confined and bedridden since
Is-
2 years.
Yes, my lord. So there is nobody to take care, my lords. The coordinate bench, my lords, of this honorable court, my lords, at page number 86, my lords, point number 3, the petitioner is at liberty to seek extension of parole, which shall be considered looking at the conduct of the convict while he is out on parole, my lords. So this, with this liberty, my lords,
So who will tell the court what is his conduct?
my lords, the jail authorities, that the respondent authorities have to make a statement in this regard, my lords.
Again,
Since-
report your lordship from the jail authority whether the conditions laid down by this honorable court saying that he has to visit every 15 days, your lordship, whether and the conduct of the prisoner who has to.
The papers are served on you.
Lordship, this is
on 12th of January 2025, my lords.
First time matter is come up before this.
Second
honorable
time, my
court.
lords. First time the notice was issued in the previous state, my lords.
Respondent 1 and 2. Let CGP takes notice, shall get specific instructions whether the conditions imposed by the court while granting parole were followed by the petitioner or not. Yes.
One more submission, Your Lordship. If he has surrendered to the jail authority, was supposed to file one more application for parole, Your Lordship. Then again inquiry is to be conducted and.
That's what he's relying on a coordinate bench of order saying that he can ask this court for that. He has an order in his favor. Yes,
May I request a date, my lords?
this is a matter on 3rd of February.
Please, my lords.
Yes.
Seal number 76.
But I filed a caveat on behalf of respond number 5 and 8. My name is not shown. On 6/1/26, I have filed,
Served on you,
We have already served the copy, Your Lordship.
I filed a caveat.
submitted that so and so, filed caveat on behalf of so and so.
5 and 8.
Respondent, list the name of, print the name of so and so. Yes, list this matter day after tomorrow.
Yeah.
Let's call the passover, the 2:30, 3:50 or.
19 serial.
3:30, yeah.
Serial number 19. All Krishna Shah.
Before the petitioner.
That synopsis here.
In this, I just given the synopsis.
Yes.
Along with that, I give one Supreme Court citation for your lordship's reference because many facts are from the Supreme Court. Because it may arise as to from where I'm getting these facts.
Yes.
So this is 88 Supreme Court, my lord. Most of the facts are culled out in this because we need to understand what it is.
My lord, with your lordship's permission, my lord, can I make one submission, my lord, regarding that morning, that alternate remedy submission? There is a full bench judgment of this honorable court, my lord, where it is clarified that the provisions of section 136(2) is subject to 136(3), my lord, where it further says the deputy commissioner shall exercise revisional jurisdiction. Based on that full bench judgment of this honorable court, my lord, subsequently all the matters are routinely being sent to the Joint Director of Land
Where is
Records.
that judgment?
My lord, it is.
Have you seen that?
No, madam, which one he's citing, I'm not aware, but let him tell me and I will make it. Which is the full bench decision? I don't know.
ILR 2012 Karnataka 4571.
LR?
The center soft.
2012 Karnataka 4571.
I've shared it with him.
Shared.
Yes.
Because even otherwise, my lord, I
My
do
lord,
not.
there is a minority view. It's a full bench judgment. Minority view and the majority view. Both views, my lord, say that.
Where did you get that?
Your lordships
That,
may kindly go to the last paragraph, my lord. That is the majority view. My lord, paragraph 20. On the penultimate page.
That is Muruga Rajendra's case.
20, yes.
Yes, my lord. The observations of the division bench in the case of Muruga Rajendra and that either an appeal is maintainable under section 136(2) of the Act or revision is maintainable under 136(3) of the Act against the original order cannot be accepted, having regard to the restrictive nature of the revisional jurisdiction. The aggrieved party against the order passed under section 129 of the Act by the original revenue court would not normally invoke the revisional jurisdiction directly, particularly when the appellate jurisdiction is available for the aggrieved party to be invoked under section 136(2) of the Act. Therefore, if section 136 of the Act is read in its entirety, it becomes clear that the revision lies under section 136(3) of the Act against the order passed by the Assistant Commissioner under 136(2). Further, my lord, the view taken, the order made under section 136(2) of the Land Revenue Act by the Assistant Commissioner in an appeal preferred against the order made under subsection 4 of the entry certified under subsection 6 of 129 is subject to revision by the Deputy Commissioner under section 136(3). Further, my lord, operative portion, VD order dated so and so. At Supra, it is held that the law laid down by this court in Muruga Rajendra Mahaswami's case is not correct. Further, the law laid down in Mallegowda's case that after the stage of appeal under section 136 of the Land Revenue Act, who is a person who is aggrieved of the order made by the appellate authority has to necessarily approach the civil court, and there is no remedy of revision against the order by the appellate court is also not correct. So and your lordships may kindly come to the very beginning of the judgment, my lord, that why this matter was referred to the larger bench.
Yes.
My lord, the order first by one of the judges, my lord, out of three, it says in view of the order dated, the first paragraph, my lord, in view of the order dated 31/5/2012 made in WP so and so by the learned single judge, the Honorable Chief Justice by the special order dated so and so has referred the following question to be answered by the larger bench. My lord, the question reads like this: whether orders made under subsection 136(2) of the Karnataka Land Revenue Act by the Assistant Commissioner in appeals preferred against the order made under subsection 4 of the entry certified under subsection 1 of 129, the Land Revenue Act, are subject to revision by the Deputy Commissioner. My lord, this is the particular question that was referred to the full bench, and it is answered, my lord, that it is answered in the affirmative that it is subject to the revision mentioned under 136(3) of the Act. My lord, morning, my lord, I could not, because of the vehemence, my lord, of my learned friend, I could not place this judgment immediately. But my lord, after that, my lord, after that, my lord, this honorable
Have
court.
the judgment?
Yes, madam.
You have the copy of this?
I will give a reply, my lord. I'll immediately give a reply. I know what he's speaking of, because Muruga Rajendra was, my lord, by his Lordship Justice Ramajoyce. The word final used in 136(2), he says, because it is final, you cannot go in revision. Not that I have to go in revision. It is not an alternative remedy. Revision is not an application, and another division bench has held that.
My lord, based on this judgment, my lord, matters are routinely sent back by this honorable court to the appropriate authority.
It could ILR 2008.
And this is what is being followed, my lord, even. That you want me to read here?
This is the notification which says who is the concerned authority. Now it is before the joint director of land records. So Deputy Commissioner is the designated under the powers delegated.
Yes.
And my lord, under the Land Revenue Act, there is a notification, my lord, which is issued, which is dated 20th May 2006.
Yes.
Lord, it is serial number 24. If your lordship is having the same book, my lord, then it is page 523.
523.
Please. Actor. Lord, may I pass on the government advocate's copy?
Yes.
Lord, the heading of the notification, my lord, in exercise of the powers conferred by subsection 1 of section 195 of the Karnataka Land Revenue Act, and in partial modification of the notification dated so and so, and notification so and so, the government of Karnataka hereby delegates the power specified in column 2 of the table below, which are conferred on the officers specified in column 3 of the officers specified in column number 4 thereof. Lord, here in the serial number 3, power to pass orders under subsection 3 of 136 of the Karnataka Land Revenue Act. The Deputy Commissioner, my lord, was the original authority in column 3, and now it is designated, my lord, under column 4, Joint Director of Land Record. That is why, my lord, I made a submission that as against the orders passed by the Deputy Director, the appellate authority would be, my lord, the Joint Director of Land Records. And column number, serial number 12, my lord, in column 1.
Yes.
This is, my lord, for 136(2). The Assistant Commissioner mentioned in the Act, my lord, is actually now delegated, and now the Technical Assistant to the Deputy Commissioner and ex officio Deputy Director of Land Records. So he's the Deputy Director of Land Records, my lord, commonly known as DDLR, and now, my lord, JDLR. And the impugned order, my lord, Annexure A, is passed by the Deputy Director of Land Records. So subject to, my lord, section 136(3), has to go before the, and thereafter, my lord, there are several disputed questions, my lord, here of fact, which would have to be gone into if the matter is taken up on merits. My lord, I am ready on merits also.
Yes. Yes.
Yes. Your Lordship may kindly see what was there before, what I saw just now before the full bench is whether the decision rendered by the bench of His Lordship Justice Ramajoyce and Justice Ramakrishna, if I'm not mistaken, my lord, in Muruga Rajendra's case is correct or not. It is not that writ is not maintainable if a revision is available. Revision is not an alternative efficacious remedy. I'm coming to that by a bench decision and held by the Supreme Court that you would do because of revision.
Before going to the fact whether it is an efficacious remedy or not, whether there is a remedy or not
No,
is the first question.
it is only a revision because your Lordship may kindly 136.
Under the Act.
Under the Act, your Lordship 136(2), your Lordship may kindly come. What was in doubt was that it's not that it is mandatory that I have to go in a revision. No. Then, my lord, efficacy of Article 226 is lost because after appeal, which becomes final, kindly see 136(2). 136(3). And I'll read 136(3). Let us come to this, my lord. Now, first and foremost, my lord, certain delegations have been made in chapter 5. We are now reading chapter 11. But first sentence, provisions of chapter 5 shall not apply to the decisions or order under this chapter. So any notifications, any decisions under chapter 5 will not apply. Number 1. Any person affected by an order made under subsection 4 or entry certified under subsection 6 of 129 may within a period of 60 days from the date of communication of the order or the knowledge of entry certificate appeal to such officer as may be prescribed by the state government. No officer is designated. Doesn't matter. In this way, decision shall be final.
Next, let's read.
Next, and what on the division bench which was reference was made was because the word final is used, you can't go in revision. If you want to, the choice is yours. You can either go in revision or not necessarily. Now, 3, the deputy commissioner made on his own motion, that is suo motu, or an application of a party, call for and examine any record made under section 127 and 129, 136(2) is not included, and pass orders as he may deem fit. So directly I can go without filing an appeal to the divisional authority under 136(3) against the order annexure B challenged. I need not have had to file an appeal. Or I can file an appeal, my lord, under 136(2). Once I have filed an appeal under 136(2), that order becomes final. Means there is no question of further appeal, my lord. There is no further appeal, nor can it be challenged in any collateral proceedings like suits, execution. It becomes final. Now, 136(3) revision, the word 136(2) was not there. There was a confusion. So the bench said either you go in appeal or in revision. There's been ILR 1918. That was the reference to Muruga Rajendra's. That was the field mate was holding the field for a long time. Either you file an appeal or you file a revision. Once you file an appeal, you can't file a revision because there is no revision against 136(3). That was it. Now, my lord, the full bench says no. It is subject to revision, means it's not mandatory that I have to file a revision. No, 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 no. That means then you are, this is Article 226, you are cutting it down. That's why, my lord, the division bench now clearly distinguished certain fact. Now let us assume that there is a revision, and the revision also can be.
That's the clarity I want. Now, as per the act, whether if the act provides for a revision,
it provides.
whether that revision is an effective remedy for you.
No, it is not an effective.
No, effective remedy for you or not.
Yes.
In spite of an alternative remedy.
Yes.
Whether you can come before the court is what the.
Yes, that's what I'm going to. That's what I'm going to argue, my lord.
So you accept on the first.
Yes.
What he submits.
Yes.
That there is a revision.
There is a, my lord, that I can't dispute. That is in the act on the face. Whether the citation of the division bench is correct or not, we are not on that, my lord. I am not going on that because I have filed an appeal. So whether I have to file a revision before filing a writ is the question.
That's what. No.
That is not concluded by the full bench.
Filing this statutory remedies that are available
Yes,
under
my
the
lord.
act, you have come before this court.
Yes.
So what are those exceptional reasons that this court has to consider?
Yes, exactly. Now, number one, I'm going to come to it. One of the reasons, my lord, as held by the Honorable Supreme Court, if the original order, Annexure B, because even in this case, admittedly, was passed without notice to me. I've not heard in the matter. On that alone is enough for me to file a writ under Article 226, irrespective of whether there is alternative remedy.
Violation of principles of natural
justice. My lord, admittedly, Annexure B is not. I've not heard in the matter. They can't dispute. Let him dispute before I go.
This is the translated copy of Annexure.
Annexure A, the impugned order. This is synopsis. I given in the morning number annexure.
No, it's here.
Now the second question will arise. Very well. Annexure B, you were not heard in the matter. It is contrary to principles of natural justice. You have filed an appeal, and therefore, can you still agitate that Annexure B was? It may arise. That question may arise. That is also answered, my lord. Even in spite of an appeal, if I demonstrate before the writ court that the original order is without notice to me, without hearing me, yet I can file a writ petition. Article 226 is not a bar. All these are discussed, my lord, in the division bench decision, which are, because let me make one thing clear. Let him clarify. Nowhere they say writ is not maintainable in the full bench. They're only clarifying the reference.
No, because there was no occasion.
That's fine. Therefore, let him finish.
I am not on that point. I mean, the morning I submitted, there is an alternate remedy, efficacious alternate remedy, because several disputed facts.
That issue is.
And in the morning, my lord, it was submitted that there is no alternate remedy. I wanted to clarify only on that issue.
Yes, no, I
Lord,
understood.
Despite that,
if he's accepting that I can argue on merit, then I will not go into it. Otherwise, I'll go.
my lord, it is not for me to accept it. It is for your lordships to, my lord.
Very well. Then let him not interrupt, my lord. Let me finish.
I am not interrupting, my lord. In the morning, my lord, there was a submission made that there is no alternate.
Even now, I'm making that submission, my lord. Revision.
Now admitting that there is an alternate remedy it is not.
No.
That's how I clarified that. Court has clarified it now.
Yes.
So what you're submitting, that there is a remedy of revision as per the act. According to him, that revision, that remedy is not an effective remedy.
Not.
So now both sides argument as of now is correct. So let him submit.
Let me make my submission, and I can't wish away revision 136(3) from that.
That we will decide.
That is for your lordship to decide. Now let me make one thing clear, my lord. Let my learner
go to this synopsis to understand what is the background of the case.
Facts of the case, my lord. Yes. Let me come through that, my lord. Now, my lord. Now your lordship may kindly see the synopsis. My lords, what happened was, in 1913, I've also given the Supreme Court decision for certain facts, my lord, which I'm going to refer to the Supreme Court decision because that is where they were involved in the dispute. I'm not involved in the dispute. And the order passed in their case where I'm not a party is used against me to delete my name. That's the crux of the matter. I'm going on the basis of a Supreme Court decision in my favor, saying you're all trustees. I'll just come to the synopsis. My lord, in 1935, that is, my lord, what was United Basil Mission Church in India Trust Association was constituted, my lord, under the Indian Companies Act 1913. My lord, they were to deal with, as trustees of 3 ecclesiastical churches. My lord, these are churches used, that expression, my lord, is from Switzerland, is Basil Church. Why this expression is, my lord, it's governed by the bishop. How procedure, therefore they use the word ecclesiastical. Now kindly see, my lord, there I have given in the synopsis, there were 3 districts. South Canara, Bombay, Karnataka, Malabar. We are now under Bombay, Karnataka area. That is what I was saying. Before reorganization of states 11156, we were part of Bombay, Karnataka. And BPTL Act was applicable till recently, till 1997, when my lord, it was repealed under Hindu Religious and Charitable Endowments Act by Karnataka under section 78. BPTL Act was repealed. Then, without anyone's knowledge, the government, my lord, reenacted the repealed act. I have called it in question before this writ petition. You cannot do it, and it has been stayed. So, for all practical purposes, my lord, as on the day, because I myself argued and got a stay of as unconstitutional. Now, your lordship, where do I get this information about these three districts? Kindly come to paragraph 5 of the Supreme Court decision, which I just now gave to your lordships. Because let there not be any doubts, my lord, as to from where I'm citing, what I'm citing now.
Who is the petitioner? Is the United Version within
Yes.
India Trust?
There are three these things, my lord.
And who are the respondents?
Where, my lord? The respondents are a different this thing. It is not us. That is the reason I want to point out. Your lordship may kindly see the petitioners therein.
Deputy Director of this Church of South India Trust Association.
Yes, that's when did Church of, he's appearing for Church of South India.
Understood.
I came into existence in 37. He came into existence in 1941, which your lord still get, my lord, from the Supreme Court decision, my lord. I will come to that. That is a para 4.
I think we'll just complete the synopsis and go back to the. We'll just read
So
the synopsis.
into those three districts, I wanted para 5, your lordship, to know. Because from where I got that information about 3 districts, because what is applicable to other 2 districts is not applicable to us. Kindly see para 5, let me read that, and then let me come to the synopsis. After that, I will not take your lordship.
Yes.
Because these are the facts, my lord.
Yes.
Para 4, let me just read para 4 and 5, that's enough.
Para 4 of the judgment.
4, yes, Supreme Court decision. In 1905, a number of congregational churches, your lordships get that? Under London Missionary Society, united with congregational churches and previous churches in South India, and such union came to be called South India United Church. Subsequently, the South India United Church, Anglican Church in South India, came to be united in brought into existence in the name of Church of South India for short in 1941.
Yes.
So, my lord, when I came into existence, these people were not in existence. Church of itself came into existence in 1941. I was incorporated in 1935. Let me come. Next, kindly come to para 3. After the creation of CSI, there had been a move to move that churches in 3 districts of South should join in CSI. Indeed, in 1943, Malabar District Church, in my synopsis I pointed out, of UBC joined CSI with approval of Synod, that is Malad authority. Further, it appears, this is not correct, we never joined. That is what is the thing. It appears that Bombay Karnataka unit of UAB also joined in CSA, but that is not the subject matter of dispute. When we have not joined Malad, and that is what the Supreme Court says. Next, the only unit UMBC that remained in South Canara and Coorg unit. Now, kindly similar. So, this South Canara and Coorg unit has been fighting litigation amongst themselves till Supreme Court, where we are not parties. In that, their status quarter, they have obtained inter se. On that basis, they want to delete my name, my lord. That is in 2012. Supreme Court has passed an order in my favor in 2020. And my name has been entered because of 2020 order. They go to 2012 after losing everywhere. I'll come to that. So, by South Canara and Coorg decided to join CSA, being agreed with that resolution, and to get rid of the same, respondents instituted a suit. So, my lord, that South Canara and Coorg is fighting the suit with them continuously. I am not a party to that. It's only that. That's why I'm pointing out. Then, my lord, the question came: if merger is upheld, my lord, whether property is held. Now, supposing I had merged, whether my properties goes to CSI on merger. That's answered in para 25.
Para
25. That's why I'm just skipping everything unnecessary. Only relevant for para 25. Para 25, 26. And then I will not read this again, my lord. It is vehemently urged on behalf of respondent. That is, my lord, who is the respondent? Not me. Coorg and Mangalore. The property held in trust by United Basil Mission Church in India Trust Association, here is referred to as UBMC Trust Association of South Canara and Coorg, will be diverted to CSI. So the property of Coorg and this thing will be diverted to this respondent, CSI. That is their apprehension. And as such, diversion will be complete breach of trust, and court should not allow such breach taking place by merger of UBMC South Canara and Coorg in CSI. Next, para 26. In case of the respondent in the plaintiff, that the properties of UMBMC have been vested in Evangelical Missionary Society Basel in UMBC Trust by a declaration of trust. It appears that by a deed dated 18th September 1934, Evangelical Missionary Society in Basel declared itself as a trustee, seized or entitled of lands and premises mentioned in the schedule to this deed, holding same interest inter alia for the benefit of members of the church founded by the society in the district of South Canara, Bombay, Karnataka, Malabar, so and so. So the society appointed by management and then next page. Next page, Malak.
Yes.
Indeed, it has been noticed that in the plain, the respondent also admits that property belonging to society and society hold the same as trustees for the benefit of UBC. In case of merger, now this is what I'm saying, Malak. This is the finding of the Supreme Court, which has become final. Even assuming there was a merger, in case of merger, there cannot be any diversion of properties.
Yes.
Held in trust by the society and managed by the UBMC Trust Association, the properties will remain the properties of the society,
Yes.
which holds them only for the purpose as mentioned in the said deed. In other words, even though there is a merger, properties or income thereof will be utilized only for the benefit of the members of South Canara and Coorg. My lord, this is the proposition of law, my lord, which is given out. So, there they said, regarding merger of the society with Church of South India, even if you merge, the properties you cannot claim. Now, my lord, let us come to my synopsis, my lord, Lordship may kindly see. In my case, my lord, we were from Bombay, Karnataka area. What happened? If nothing had happened, we also would have merged.
Yes.
The crux of the point is this. In Bombay, Karnataka area, Bombay Public Trust Act came into force in 1950. So every public, like your lordships were mentioning in another matter in the morning, every public trust or society has to be registered under Bombay Public Trust. So we were registered under Bombay Public Trust. Now synopsis, your lordship may kindly see. On 31/5/1952, an application was filed under Section 18 of Bombay Public Trust Act. Because once we are registered, my lord, if the Act, Bombay Public Trust Act did not permit merger, unlike Coorg and unlike Malabar, we come under Bombay Public. So there is under the Act there is a bar for merger. That is why till today the Supreme Court has upheld our contention even in 2020 because it was. Now kindly see, that is, my lord, produced along with the page number, my lord, for Dharwad and Bijapur, annexure A1, page 17 to 29 of the rejoinder. Let me not take the lordship, but I have meant the application to register. We were registered, my lord, on 20/12/1954. That is annexure 2, page 30 to 31, my lord, under the Bombay Public Trust Act. Once we were registered under the Bombay Public Trust Act, my lord, we are called as Bombay Karnataka Society. And we are governed by Bombay Public Trust Act strictly. Now, your lordship may kindly see, on 28th, my lord, the registration certificate was given. In 1973, an application was filed on their behalf, my lord, to enter their name also in the public register. PTR, and for entering their names of 15%, including that of CSI. Now, CSI is R4 before, your lordship. So they said, in that Bombay Public Trust Act, along with them, enter our names.
This to replace, so the name of this trust to be replaced at Church of South India.
I'm sorry, ma'am.
No, this, what is this application 1970?
Application they filed in PTR sheet.
No, that is you filed, an application filed by the.
After that they filed, we were registered.
No, look at the synopsis 3.
An application was filed by R.S. Bandera attorney, he became their attorney.
No, UBM-CITA.
UBM-CITA to replace UBM-CITA to Church of South India, means our name should be replaced as Church of South India.
Who has filed this application?
One Bangera on their behalf, who was claiming to be one of their own person.
Oh, please come back. Bangera is
Yes,
your
he had filed
attorney.
initially on our behalf, then he filed on their behalf, he turned and he became their part. Now, your lordship may kindly
31
see.
5 1952.
Yes, it was
R.S.
filed by
Bangera, attorney of UBM CIT.
the Bombay, our power of attorney holder filed on
Has
our
filed
behalf.
on your behalf.
Then
No,
we
please,
got
sir.
registered. Then what happens? He splits sides. He goes to their side, to CSI, and he says you enter CSI name. That is rejected, and our name is continued. That is, my lord. That's what I'm saying. A15 90 19 page 1949 943 rejoinder. We have produced the entire order of the assistant commissioner. He says only you cannot enter the name of CSI.
So the transfer of property to you is so and so it's contrary to the provisions of the act.
Yes, and he refused to do it.
So this Bangera is the managing trustee or
Yeah,
is an attorney?
my lord, he was a power of attorney, but managing trustee on their behalf. So he changed sides and he makes an application on behalf of CSI. And this order is passed in 1973 because they say under the Bombay Public Trust Act, CSI.
25,973 is the assistant charity commissioner's order.
Yes, that is annexure 15, page 940, 943.
Then
He
after that-
refuses to enter the name of R4 in the PTR. And my lord, only our name continues still today. What happened against that order, my lord? Against that order, they never challenged that particular order. It attained finality. Then, my lord, what they did, 1984, kindly come to the next. That order became final, my lord, but in any case, 1984, fourth respondent CSI preferred a revision under 78 to be before the charity commissioner, Bombay, my lord, before the Bombay challenging the order dated 20/12/54, where our names were entered in the register as trust. Because it is a public trust, I have to enter. Bombay Public Trust Act said every public trust you have to register yourself. It was registered, we have registered ourselves. My lord, they challenged. Then, my lord, the charity commissioner on 7/1/87, my lord, he said that your 70A petition is not maintainable because, my lord, against the assistant charity commissioner's order, you could not go in 70 under Bombay. Anyway, what they did is, my lord, they filed miscellaneous petition 56 of 1987 before the additional district judge public, challenging that very order dated 7/1/1987, passed in RP number 9 of 84 by the commissioner, charity commissioner. They filed, saying that charity commissioner's order is wrong, our name has to be entered. My lord, this miscellaneous petition was rejected, and the court held that the annexure D 144 to 158, it is clear that despite having met a legal death under Indian Companies Act, that original company, my lord, it did not survive Companies Act because we registered under this thing, but it is still under BPTL Act and can independently function as a trust. So we are independently functioning as a trust till today, subject to provisions of the Bombay Public Trust Act. And it ought to have been registered and also accordingly under the said act and dismissed. Their miscellaneous application 561 of 87 was dismissed, my lord, against which they file an MFA before this honorable court. That is MFA 3458 of 1995. In this MFA, it's very interesting to note, my lord, when the matter was being heard, they come and appear, no, we have no rights. They concede, and that's what the MFA court has held, Annex 3, page 159 to 162. Relevant portion, I can point out to your lordship, but these are the pages. The division bench of this honorable court were placing on record the submission made by counsel for CSI. It is their own counsel who filed an appeal, says we have no right, and it was dismissed. The honorable court was pleased to observe it, however, open to parties to seek whatever.
What they said was the appeal is not maintainable before the court.
There, before the charity commissioner.
MFA, no, MFA.
MFA, no, MFA, he says we have no right. I'll take your lordship to the relevant portion of the order now. We'll go to the relevant portion. Degree portion. Page number 159 of the writ petition. Annexure, not he says we have no right. He says.
159.
Yes, 1 minute. 159 in the order, the relevant portion is 161. The laptop right. Subsequently, it's however submitted on para 2, 161. Lordships get that, madam? Subsequently, it's however submitted on behalf of the appellant by the learned senior counsel that in view of the decision rendered by
paragraph number
Para 2, 161. Read petition.
No, I think this order is of the original suit 161.
No, my lord. Read petition. Your lordship seeing the rejoinder. Read petition on this side, on the in that 161.
Yes.
Yeah. Now I have made a submission. They say they have no rights in their favor, my lord. Now kindly see para 2. In the MFA. So, my lord, this is all regarding my registration as an independent trust under Bombay Public Trust Act, which is under challenge. Subsequently, it was, however, submitted on behalf of the appellant by the learned senior counsel that in view of the decision.
That's what this is, that it is not maintainable.
No,
But they're not saying that, in this para, they're not saying that.
No, they are saying, let me read. I read. And also in view of the fact that no rights are accrued to the parties. Kindly see that, my lord. Have I clarified myself, my lord? That no rights are accrued to the parties. In the instant appeal, the instant appeal may not be maintainable. Not because appeal is maintainable. Not that MFA is not maintainable. MFA is the remedy against the principal district judge's order.
What is this Madhav Shankar Pandit's case?
Some citation, my lord, which they have reported, which he himself quotes. The senior counsel himself quotes. There is no necessary. It is what is like a self-goal. He quotes and says, and also in view of the fact, apart from the citation, and also, let me read that again. Forget the citation, my lord. And also in view of the fact, no rights are accrued to the parties. The instant appeal may not be maintainable. Hence, the same may be dismissed or not maintainable. In any case, my lord, once appeal is dismissed, the original orders are confirmed. What are the original orders that you cannot be entered under the Bombay Public Trust Act? Why it cannot be entered? Because there is no provision for merger under Bombay Public Trust Act. Unlike Goa, Coorg, and Malbagh, their Bombay Public Trust Act was not applicable. That's why I started off my argument saying Belgaum, this area came under Bombay presidency. Bombay area, and used to be called as Bombay Karnataka, and therefore Bombay Public Trust Act was applicable only to us. So therefore, you cannot merge an existing society with another society under the Bombay Public Trust Act because there is a legal bar, and that is what it stands as. I'm making my submission with your lordship. That law remains. I'll come to it. So therefore, my lord, am I clear that they said that they have no rights in the matter, and that too by a division bench? Then the appeal is accordingly dismissed as not, my lord, whether it is not maintainable or merits, appeal is dismissed. The original orders are confirmed. There is no question of merger and changing. And however, open to the parties to seek whatever interim relief they are entitled to under law before civil court where the suit OS3. So they said, if you want to go before the civil court, there is some suit pending OS3 of 94. They never went. They never implemented. That suit is also dismissed.
Yes.
So there rests the matter. That is Roman number 1. My registration and independent existence apart from that. And the Honorable District Court also has held that despite that original company having it, we have an independent existence under the Bombay Public Trust as registered society, as a registered trust. Now let us come back to the synopsis. Any other doubt, I am ready to clarify. Yes. So this is how. Now this, since note, there is no further challenge to the above proceedings, challenge registration of the petitioner trust have attained finality. So point number 1, yes. My registration has become final. That is, the petitioner's registration is final. R4 has got nothing to do with me. Next, my lord, let us come, my lord, to the main crux of the matter. I was a trust.
So let's complete this synopsis further.
That is all. My registration is complete, number 1. Now let us come to the second topic.
What is this, a petition under section 47?
I'm coming to that now. I'm coming to that now. What is that? I've given a heading. Dispute in appointment of managing trustees to petitioner trust. That is me. We had 9 trustees. I'll just make a summary. Of the 9, 6 died. 5 died and 2 went abroad. Someone has to manage the trust. So we made an application. 8 of us made an application under section 47 of the Bombay Public Trust Act to appoint us as trustees of the petitioner trust. Now this is where the crux of the matter, second leg of the litigation. I'll try to make it as short as. So when this happened, my lord, miscellaneous petition, and how can I make an application? I have to go to the district judge under Bombay Public Trust Act, and I have to make an application under BPTL Act. I made it, it was numbered as BPT, miscellaneous petition 18 of 1990.
Yes.
My lord, I made it. On 14/7, during the pendency of my application to be appointed as trustees, 8 of us, some confusion is there in our order sheet, they want to complicate, but during that, they file an application, implead me as a party.
In that miscellaneous.
Yes, implead me as a party, I'm interested, I want to become a trustee too. My lord, now, on 14/7, they made an application that is annexure A5 along with my rejoinder. All these, my lord, application under 27. So IA number, it was numbered as 27. Order 1, Rule 10 is by mistake registered as public trust and proceedings to delete the trust from his pending before High Court. It is stated that BPTL has been repealed with 152/2003. Though it was repealed, my lord, now I have got a stay and it is that repeal is continuing. Reenactment of repeal under General Clause Act was made. It was illegal. I filed a writ and the stay order is in. The proceedings automatically stand abated. The Supreme Court in Civil Appeal number 84 of 75 has held merger of UBMC with CSI is legal and valid. That's what I produced before your lordship. That doesn't concern us. Then UBM no longer in existence. On 24/7, miscellaneous petition 8 filed by objection. Then on 19/8, that miscellaneous petition filed by us was allowed. And we were 8 of us were appointed as trustees. On the same day, his IA number 27 came to be rejected. Next. They filed miscellaneous against order passed miscellaneous. They filed MFA 6682 of 2004.
Yes.
First, they filed WP, my lord. That's on 38/2004. Your lordships get that on top. Writ petition.
Yes, sir.
Challenging the order on IA number 27.
Yes, I have gone through all this.
Then next, my lord, they filed an MFA.
Yes. That is also dismissed.
That is, then, no, 1 minute. The writ petition filed by them was dismissed and it became final. His Lordship Justice Bopana's order, my lord.
Yes.
Annexure L, page 2, 2003.
Yes.
So, my lord, as far as trustees are concerned, we were appointed as trustees. Now, what happens, my lord? They filed a review before that district court and all that. It didn't happen. Then, let me come directly to the mutation entry proceedings. Is now.
What are the? I mean, on which proceedings this petition is filed? I mean, this appeal is filed.
That appeal, let me just come to the last, your lordship, just 1 minute. Facts relating to civil appeal number 4813.
Yes.
No, my lord, I pointed out that everywhere they lost, they had no right. And also, I gave you have given your lordship the citation regarding poor gang. They had some dispute amongst themselves. There, my lord, civil appeal number 4813 of 2000 has been filed by the Cour and the members, my lord, in a scheme suit. Because by that time, what happened, my lord, since there was a repeal, 1 minute, not just 1 minute. Since there was a repeal, they filed a scheme suit under section 92 CPC amongst themselves. For me, scheme suit doesn't apply because I'm under BPT. So that was OS 7 of 1991 was filed amongst them. The scheme suit was allowed or rejected. They went in rejected, and then they went in appeal. That is annexure A9, page 142, 141, my lord, for settling a scheme. I produced the plaint. It's got nothing to do with, I'm not a party. It doesn't concern me at all. I'm from Belgaum. I'm from Bombay, Karnataka. That is cool. Then that matter, my lord, went up to the Honorable Supreme Court, and my lord, the federal court dismissed the suit and all that. My lord, RFA was dismissed. Then my lord, RFA was allowed, and all, then that matter came up before Supreme Court. Annexure M on 10/5/2012 against the judgment of the division bench of this honorable court. Your lordships get that, Mother? On 10/5/2012. Now, kindly see the order passed by the Honorable Supreme Court in their suit, to which I am not a party. Kindly see, Mother. At annexure M, page 211, your lordships will get along with my rejoinder. Writ petition. The lordships got that one? Page 211. Annexure M. It was a scheme suit. Kindly see page 211. I produced the plaint also, my lord. Scheme suit was rejected, allowed by the High Court, my lord, in RFA, against which they come up. They went up in SLP. But again, at the risk of repetition, we are not parties. We have got nothing to do with it. We are not concerned with them at all. We are totally different. As I pointed out, we are the third. Here, my lord, 211, my lord, Church of South India, R4 filed an SLP against the High Court judgment. In that case, wherein my lord, scheme was allowed. It's only scheme suit, 92 scheme. Here an interim order was passed on 10/5/2012. This is the interim order passed there. In the meanwhile, parties are directed to maintain status quo in concerning the subject matter of the dispute. What is the subject matter of dispute? Doesn't concern me. My property is my. This order is being misused, saying there is a stay, therefore your name cannot be entered as a trustee. My name being entered as a trustee in place of deceased trustee is only an academic role. It is not determination of any list. Now this officer wants to delete it on this. I'm coming to this. This was further modified, my lord, with another order in their own case. Interim order dated that your lordships will get at 213. Interim order dated 10/5 shall continue till disposal of the appeal. How does it concern me? It doesn't concern me at all. What concerns me now, your lordship may kindly come back with the synopsis, my lord. Synopsis, number 2. Mutation entry, let us come to know.
Yes.
There were certain mutation entries made. Page number 7 of the synopsis, your lordship may kindly come.
Mutation entries, synopsis, page number 9.
Yes, madam. Kindly come to page number 7. Madam. My lord, my appointment of trustee, as I said, my lord, if I had a writ petition was dismissed, kindly come to page 7 in the end.
Yes.
My lord, Supreme Court order ಕೊಡ್ರಿ confirm ಮಾಡಿರೋದು My lord, on against the dismissal of the writ petition, some of them went before the Honorable Supreme Court that my name should not be entered as trustees. That your lordship will see annexure H, page 25/7/2019. The Honorable Supreme Court passes an order, my lord, at, no, kindly see the date. That interim order was 2012. This is 2017 in my matter. That is not in my matter. Kindly see the order annexure H passed by the Honorable Supreme Court.
Page number.
Page number.
Yes.
187, my lord, your lordship will get.
Yes.
Your lordship got that, my lord. So in this, they challenge the entries made for entering the trustees. Now let me read that order, my lord. Let me read first para and all the cite, my lord, 6 of the General Clause Act and repeal and all that. Kindly come to para 2 of the Supreme Court order. Your lordships get that, my lord. In the present case, an application filed by respondents 1 to 8, that is what we are before your lordships, for appointment as trustees. The application filed by 1 to 8 for appointment of trustees was before the date of repeal. They have been appointed as trustees. Now let me pause here. They say they dispute that we have not been appointed as trustees because in on order sheet some note we have to appoint trustees. We ourselves filed an application. Our application is allowed. Your challenge is rejected. Supreme Court accepts that we are appointed as trustees. And despite that, this officer wants to pass. No, kindly. They have been appointed as trustees by District Judge Dharwad. And on that ground, the 7 trustees of the trusteeship, 2 were currently residing abroad and 5 had died. That's what I made a submission to your lordship. Out of 7, 5 had died, 2 were, and therefore new trustees are appointed. As a result, it was urgently necessary to appoint trustees as to safeguard the properties of the trust. The order of the district judge indicates that prior to the appointment, proceedings was duly advertised. The appellants did not file any objections. They're all one and the same. CSM has not accompanied their own member scheme. They did not even file objections. With view to the High Court upholding the appointment, so subject to any order that may be passed by competent court, we see no reason to differ with the view of the High Court upholding response one. That is, where the MFA was in my favor and the RF.
Yes, yes.
So, this order was passed on 25th July 2019. Then again, they filed one more review. They filed a review before the Honorable Supreme Court.
Also dismissed.
That is also dismissed.
Yes.
Now, my lord, in view of this dismissal, we gave an application to enter our name as trustee.
Please come to the
Synopsis, my lord. Now, kindly come to mutation entry proceedings.
Yes.
My lord, based on that, a Supreme Court decision on 24/11/2020, your lordships will get at page number 9 of the synopsis, last but one line.
Yes.
Based on the Supreme Court decision, my lord, not on our own whimsical or anything, we gave an application to enter the name of the two trustees in place of the old trustees.
Yes.
This is not made under 128 or 129 of the Land Grabbing Act because there is no dispute or leave. This is only an administrative act under section 132 where court orders are there. Have to produce the court order. That's all, and the revenue authorities are bound to follow court orders.
Yes.
So that full bench decision 128, 129, all those things will not arise, my lord. Then, respondent number 4 submitted an application before ADA to delete the name of the petitioner trust. Now, my lord, he comes, he has lost in the Supreme Court. He has lost everywhere. Kindly see on 26/5 they make an application, my lord, to delete my name entered previously according to the Supreme Court. And the officer, without notice to me, without hearing me, behind my back, deletes my names. And on what ground, my lord? In 2010, in some matter, in the suit of Goa thing, there is a status quo order. Therefore, that status quo will prevail. Your names are deleted, my names are deleted, without hearing me.
I understood that.
Against which I filed the appeal, my lord.
Yes.
Appellate authority may kindly see, my lord, goes into various things. And this order was communicated to me on 16/6/2023.
Who is the third respondent?
Annexure W, page 238. That order is Annexure B1, B2, page 66 onwards. No order, it deleted my name directly. ADLR. Directly without notice to me, taking law into his own hands. My lord, they think, my lord, they can pass any orders, my lord. And previous entry is passed, my lord, based on the Supreme Court order, my lord. Kindly see Annexure N, Annexure B, page 65. They note the Supreme Court order and write my name, my lord. Kindly come to page 65, Annexure B, B1, B2, B3.
Please come to this order dated 24/8/2023.
24/8/2023.
8/2023.
Yes, my lord. That is Annexure A, impugned order.
Oh, let's see this order.
Yes, yes, that is the order under which we are under challenge.
Yes, let's see that.
Yes. Now kindly see, my lord, I'll take your lordship through that order. In appeal. My lord, his reasoning starts with, if I may say, all facts, suit property, preamble. Kindly see his order, page 2 onwards, suit property. Then preamble. Then he writes all whatever is the arguments, he just copies, not his reasoning. His reasoning, your lordships will find. Straight away come to paragraph number 16. Now look at this, my lord. Supreme Court says that 1 to 8 are the trustees. Look at what he writes. The records indicate that order from principal district judge miscellaneous petition under
No,
did not specify
Where
the
are you reading?
Huh?
Where are you reading?
Internal page 22, para 16. That's the only reasoning he starts. Till then, all stories. Para 16.
Yes.
My lord, I laid emphasis on the Supreme Court order that 1 to 8 are the trustees. Their names are correctly to be entered. Now see para 16. This is what this ADLR writes, as if he's sitting over judgment in Supreme Court order. The records indicated that order from principal district judge Dharwad, who asked him to look into all these records, man? He's not an appellate court or district court order. 8 section 4 did not specify the name. Well, contrary to what the Supreme Court says, High Court says, entries are made, name current appellants as trustees of the, nor did it detail the suit properties. My lord, when my name of my society is entered and you have lost the challenge, if trustees die,
No, please, let's not, I understood that.
yes,
Come
yes.
to
Then come to
paragraph
17.
17.
A
No, the
suit,
court says, the court issued an it says a suit concerning the suit properties was filed in the Supreme Court between United Basel Mission Church and CS. This is.
Correct, that is the Goa. That's what I produced the SLP also, not us. South Canara and Goa, not me.
That's what you are not a party.
No. I'm not concerned with that. He goes on that. That's what I've been harping, my lord. He goes on that SLP. I'll show. I produced the
Court says
SLP.
that court has issued an injunction and an interim order dated 10/5.
I read out, my lord, in their suit.
This order, you are not a party.
No. I'm not
Yes.
party. I'm not concerned. So based on this, he says court issued injunction and interim order which remains in effect. The order directed parties to who? I'm not a party. And my thing is, my order as a trustee is 2020. This is 2012. Kindly see the date of the order he refers to, my lord. 10/5/2012. Our appointment as trustees upheld by the Honorable Supreme Court is 2020. Some 8-year-old order, and on this basis, my lord,
Let us look at the Supreme Court order of 2012 again. Where is it?
2012 order, your lordship, may kindly see.
Page number?
211. Good. Annexure here. Not only that, after this honorable court has granted stay order in this case, he passes one more order, my lord. Staying the original order because your lordship granted stay. Kindly take it. Annexure M 211, your lordship may kindly see. This is against what? This is against the allowing of RFA by the Honorable High Court, against which SLP is filed.
No. Let's understand this order. It says, in the meantime, parties are directed to maintain status quo in all respects concerning the subject matter of the dispute. Where is the petition, this Supreme Court, what is the petition that is filed before the Supreme Court?
Against the dismissal of RFA by the division bench of the Honorable High Court, Annexure L. Annexure L.
That is unconnected with you.
No, not connected with me. That's what I'm saying. That's why I'm produced all the records. And he also notes. Despite that, in a high-handed manner, he does all this.
Let us see that RFA order, page number.
Yeah, Annexure, page 203, Annexure L.
400 and?
No, wait a minute. I'll give you Justice Kumar. I'll take your order. Kumar order. 1 minute, Mother. I'll take your order. That is at page A13, page 621 to 919.
621.
Yes. To 919. That is regarding South Canara and Coorg.
1 minute.
Regular first appeal. I am not a party in the cost state, your lordships will see. I am nowhere a party. Bombay Karnataka Trust. It is among themselves for a scheme suit. Internal suit, it is a scheme suit. Then, your lordships will see that.
Yes.
All of them are only against it. Just to read that order.
Suit is filed for the, it's a scheme.
So kindly see para 2 of that RFA order, my lord. Para 2 of the RFA order. Scheme suit, my lord.
The scheme suit is dismissed.
Yes, now they allow it.
Against that, the RA is.
Yes, now kindly see RFA. Kindly see, my lord. RA is also dismissed. Concurrent finding, but RFA they reverse it. Kindly come to para 2, my lord, at page number 640. Who has filed? What is the matter? Para 2. Lordships got me? At page 640.
Yes.
Para 2, suit is filed under section 92 CPC. That's what I was making a submission for settling a scheme for proper. But where is the settling scheme for me? I am under BPTL Act. It doesn't concern me. Due to and management of properties of the United Basil Mission Church, South Canara and Coorg. Kindly note that, my lord.
Yes.
It's for South Canara and Coorg in respect of plaintiff so and so for the purpose of are referred to so and so. So, my lord, this again para 3. The United Basil Mission Church in India, district of South Canara and Coorg, for short here in is fully evolved evangelistic Protestant church so and so so and so. And then they allow the RFA and they allow the scheme to be settled. That is challenged in SLP. And that to 2012.
Where is the judgment in the scheme suit? Suit.
Suit that was dismissed, my lord. I'll give, my lord. Scheme suit dismissed again. A plaint to produce, my notice. We have produced even the plaint also.
Where is the plaint?
I'll give, my lord. Plaint is also produced. Plaint A9. 140, my lord.
140
of 1991.
140 of this rejoinder.
In rejoinder. Because there we have to produce everything we have produced, my lord. And I've given that heading in the synopsis to your lordship. For 1 minute, my lord, see the heading in the synopsis, page 11. Page 11. Facts relating to civil appeal 4813. I may culled it out separately. So your lordship shall not have confusion at all. Now this, RFA so and so, kindly see the suit plaint I have produced for settling the scheme. That annexure A9. Church, I mean, they are the parties, my lord. It's against them, inter se. They were arrayed
Please come to the schedule of the properties.
Schedule.
225.
Schedule 225, my lord. 220. Page 225 onwards is the schedule. Where is schedule they have given? About what? It is only the relief your lordship may kindly see is a scheme suit. Kindly see page 219 is their prayer.
Come to 239.
239
of this rejoinder.
239. Yes. Registration of sub-district Dharwad. That is Bombay Karnataka area. It is not theirs. It is Bombay Karnataka area. Dharwad is in Bombay Karnataka area. It is not there.
So they have mentioned the properties that are belonging to.
They might have mentioned this registration of sub-district Dharwad.
It is there. They have mentioned, isn't it?
But it doesn't pertain to them at all, my lord. Line Bazaar and so and so.
All this Gadag.
All that they have put everything.
All the properties that are pertaining or that are claimed by this society.
He is only A to C. They don't come. Dharwad doesn't come. That's the mistake. And what is the relief, my lord? Kindly see. Scheme. That's all. This is Dharwad doesn't come under their jurisdiction, my lord. It's under Bombay Karnataka area. Kindly see the 209, my lord. What is their prayer? What is the subject matter of the dispute? These are not two properties. 219.
In the plain, what do they say about these properties?
They don't say anything. They just say scheduled properties. That's all. They don't make a mention.
So in the entire plain, there is no mention about the property.
Neither am I a party. My properties, I should be a party.
If he claims that these are the properties belonging to the church,
then I should be made a party. All records stand in my name from 1940. For these properties from 1940, my name stands. And he is a defendant. He is aggrieved by the scheme suit. Plaintiffs are somebody else, not him. Kindly see who are the plaintiffs, my lord. He is not a plaintiff, he is only a defendant. Kindly see the plaintiff. Some members who are plaintiffs, 140, your lordship, he is not a plaintiff.
Yes.
Somebody else, my lord, if that is the case, if he was there, then in all honesty, in my XLP, where my name was entered as trustee, why he did not bring all this notice of the Supreme Court? No, I need to be trustee because these are all my properties. Now, once Supreme Court says I am trustee for which property? For my property, which stands from 1940.
Where is the trustee that is registered and the
Similar, that is under the PTR, it will be registered. No, there is no separate this thing. Under section 52 of Bombay Public Trust Act, he registers all the properties, my lord.
Where
And
is it?
from 1940 onwards, your lordship, my lord, that is an order passed by the Assistant Commissioner registering all our names as trustees of all
You
the
are the trustees. What are the properties of the
properties,
trust?
my lord, entire Bombay Public Karnataka area, whatever we had. PTR sheet, well, in the PTR sheet, that time they would have entered. That's why they wanted to implead. The application for impleading is rejected.
No.
Well, PTR sheet, my lord, we cannot, we do not have the PTR sheet at this
No,
moment.
there is a trust. Trust has some properties.
Yes,
What are the properties of the trust?
My lord, that will be in the
No,
PTR sheet, my lord.
Unless and until you say what are the properties of the trust, you cannot say that the.
My lord, they are got, my lord, your lordship, can see. They have got nothing to do with Bombay Public Trust or Bombay Public Area or where I have been registered. My name is now entered from 1940. Kindly come to my synopsis, my lord.
There is no dispute about the fact there is a trust registered.
Not only that, my name is there from 1940. Kindly come
What
to
are the properties of the trust is the crux of the issue.
The 1940 thing is, we'll have to take out, my lord. 1940, your lordship, may kindly see mutation entry proceedings. That is at page number 9.
No, not your synopsis.
In the synopsis, I'll come to that one.
Huh?
Page,
Not synopsis.
page
What is the
60.
document?
My lord, it will be registered under the Bombay Public Trust Register by the Assistant Commissioner in 1954 concerning entire Bombay Karnataka area. Dharwad is a part of Bombay Karnataka area. So whatever property. Page B, annexure B onwards, my lord. Page 60, all the properties are mentioned.
Petition.
Yes.
Page number?
Yes. 60. All the properties are mentioned, my lord. Take it. For page 60 onwards, my lord, all our names are shown as in our names by after being registered as Bombay. Yes, my lord. Yes. A ruled card, annexure B. There, my lord, all these properties are mentioned in our name. It's in Kannada, we'll have to do this thing, but these are the things we are undisputedly, my lord. All the properties are mentioned in our name, in a wide annexure B. That is, my lord, changes which were made.
Yes.
Right from 1940, kindly see, my lord, I have even stated, my lord. And if my properties were there, where I am being, you've gone to the Supreme Court, all of you have lost, all of us are sitting as trustees. Based on that, on a 2012 order, he deletes my name without hearing me. The original order is no order at all.
Yes.
That's what, my lord, I was making a submission. So, that, my lord, they entered their names. Kindly come to page 9, my lord. That's another important fact.
Page number?
Synopsis, page 9. That was also under challenge, my lord. They withdrew the writ petition. This will answer your lordship's question, my lord. On 19/3/1940, name of our name is reflected in the CTS record in respect of all the petition properties. In the writ petition, we are given the properties, all those properties. Next, after 4.5 decades, the name of respondent number 4 came to be mutated in the record. Their name, they got it entered, my lord, behind our back. The Assistant Commissioner Dharwad allowed our appeal and restored, that is annexure Z. We have produced page 251 to 260 and deleted them. Against which they filed a writ petition. And they withdrew the writ petition. Kindly see, my lord, annexure A8. The respondent number 4 withdrew the petition. WPF 14631 of 87. The challenge, wherein again my name was entered for all. They file a writ, they withdraw the writ. One. Even otherwise, my lord, when we are appointed as trustees for Bombay Public Karnataka and their area, all the properties in 2020, you have lost everywhere. Your writ petitions are dismissed. MFS are dismissed. Writ petition challenging mutation entry in my name is dismissed. Writ petition you file, you withdraw. So the only way you can do is misuse the revenue officers to pass such entries in. Now, let me, your lordships have stayed the order. There is a detailed order granting stay by this court after discussing 2 years ago, not today. is raising alternative remedy today. In 1st February 2004, this matter is admitted. After such a long time question. There, my lord, what has been, in 2004, writ petition has been admitted and matter is going on. Now what the officer does, High Court has granted stay of my order, no? I will grant stay of the original entry again. Again. When matter is being heard before your lordship.
And that is question.
No, we have just recently we got it. We got it. Look at his thing. He passes a stay of the original order, which is already stayed by your lordship. Somehow or the other, they want to misuse their offices. Kindly see, this is the order is passed recently, day before yesterday, 31/12/2005. I'll give a translation to this order. Means, is there no respect for court orders? My lord, I am in possession. I'll file it along with a memo. So this is how he says, because High Court has stay, I will again grant stay. So isn't it an utter contempt? We could not do it because we got the copy just yesterday, my lord, and we were preparing for the matter, so we could. I'm sorry about it, but this is what he has passed. The very same officer. He says, my lord, Sadara Prakara, I can't read because your lordship still. So and so, my lord, and the very same number, he grants stay. ಒಂದು ವೇಳೆ ಮುದ್ದತನ್ನು ಮುಂದೆ ಅದನ್ನು ತಿಳುವಳಿಕೆಗೊಳ್ಳಲು ಉಭಯ ಪಕ್ಷಗಾರರಿಗೆ ಸೂಚಿಸಿದೆ.
We'll ask him. I understood the submission. Yes.
Alternative remedy, my lord, will not come because of all these facts wherein, my lord, disrespect to court orders, where the question of alternative, and that too, before whom should I go? Before this very officer.
There is petitioner, my lord, is titled as United Basel Mission Churches in India Trust Association into bracket Bombay, Karnataka. My lord, according to the writ petition, paragraph 2, it is registered, my lord, only in 1954. My learned friend also, my lord, made a submission that it is registered in 1954. My lord, there is another body also called as United Basel Mission Churches in India Trust Association. In the bracket, my lord, there is nothing. This is the original body which is registered in 1934. Now, whenever, my lord, it suits, petitioner claims that it is the original body registered in 1934. When there is litigation, my lord, which has been initiated by this original United, I call it, my lord, as UBM CETA for shorter, easier purposes. Original CETA, which is litigating before the Supreme Court, and the matter is seized by the Supreme Court. There, my lord, he says, I am not a party. But for other purposes, my lord, for the purpose of registration and wherever the entries, revenue entries are made, revenue entries are not made in the petitioner's name ever. They were always made, my lord, in the name of the original UBM CETA, against which, my lord, the fourth respondent, Church of South India, is litigating forever. My lord, the Church of South India says that all the properties have now properties of the fourth respondent. However, my lord, the UBM CETA says that the merger will not allow you to take control of all the properties. My lord, I am grateful to your lordships. Your lordship straight away pointed out to page number 248 of the rejoinder, where these properties are also mentioned in the schedule of that suit, my lord, which is filed by original UBM CETA, not by the petitioner. Now, matter, my lord, that matter ended in the High Court, my lord, it ended against me. So that matter has reached Supreme Court. Supreme Court says, Lord, your lordships, this was read out to your lordships. Supreme Court very clearly says, in the meanwhile, parties are directed to maintain status quo in all respects concerning the subject matter in dispute.
So according to you, in that UBM CETA is a party.
Yes, my lord, that
but
is
not this Karnataka.
The Bombay, Karnataka. And my submission.
No, let us go to this registration.
And my lord, your lordships may kindly see in 1940, where he claims the entries are made in his favor, there was no Bombay, Karnataka. That has come only after independence. Certain areas got reorganized, and then Bombay, Karnataka came into existence. Before in 1940, there was no Bombay, Karnataka. My lord, for easier understanding, my lord, I have culled out some of the annexures from the writ petition, and only those, my lord, would be relevant, because all others, my lord, are wholly irrelevant for the purpose of this case. My lord, the case is like this. The mutation entries.
They are relying on some registration, just now he has pointed out.
Yes.
About
1954.
the properties. No, how it is registered? What is the name of it? We'll see.
1954.
Registered, but that was dissolved. That is observed by this honorable High Court. Let me just come. Unnecessarily again he is started. Kindly see, my lord. It was,
No, please
in
come
synopsis,
to-
let me see.
No,
Your
no,
Lordship may
before
kindly-
that, let's go to this annexure B.
Yes, kindly come to synopsis, ma'am. It was registered as United Basil Mission Church in Trust Association in 1935. That time all were one throughout India. All the three was one in 1935. That was registered under Companies Act 1913. That is dissolved. It's no longer in existence. The question of him saying that, so they had three ecclesiastical districts: South Kanrakpur, Bombay, Karnataka, Malabar, which I pointed out from the Supreme Court decision. There were three. Then we registered ourselves because Bombay Public Trust Act became applicable only to Bombay Karnataka area, not to other districts. We were bound to register under section 18 of Bombay Public Trust Act. So we registered as a separate body under Bombay Public Trust Act, which they challenged and lost. I pointed out all the things
So
where.
let's see that registration and any order pertaining to that. Any proceedings pertaining to that challenge.
Yes.
Where is
Sir, my
that?
lord, kindly, let me take your lordship again. Kindly come to my synopsis. We were registered. That was challenged, my lord. First in
I
1973.
want to see the order. Where is the order?
I'm coming to that. First, they made an application which came to be rejected. Order is annexure A15 on 25/9/2023. They said we cannot transfer in your name. That is what I'm saying. Annexure A15, page 940, my lord, and your lordships will get that in my synopsis, page 3. I'll take your lordships through the order also. Page 3, A15, page 940 to 943. Kindly note that. Saying that further held entering name of CSI as trust in PTR is not at all legal valid. Refuse to accept.
No, let us see. Page 17 to 29 in your rejoinder.
Huh?
Page 17 to 29
Page 17 to
in your rejoinder.
Yes, madam. Very well. 17 to 29 in the rejoinder. Page 17. Page 17. That is our application, my lord.
So let's see what it says.
Yes. Take it. I submit the following: say trustees, name of the thing, then all the name of the trustees, then my lord, all the nil details, immovable properties containing how many churches, what.
Even assuming that, for argument's sake, that this trust and the other trust which you are referring to is not one and the same, but this registration and other things you have questioned, and it has attained finality. Whatever that their registration is upheld, and whatever your objections are were rejected.
No, when, my lord, there is the original UBM CETA is claiming the properties. Your lordships read that plaint also, page 240 of the rejoinder.
Who is representing that original UBM CETA?
My lord, the matter is in the Supreme Court and they are not made parties. My lord, that is not a submission, my lord. And if he has finished, my lord, I will begin. Otherwise, my lord, because this original UBM CETA, my lord, is a company registered under the Companies Act. I have pointed out to your lordships. My lord, petitioner is a trust registered under the Bombay Public Trust Act.
So this aspect finds place in the Supreme Court judgment.
My lord, Supreme Court, he's not a party.
Not this old matter, old judgment of the Supreme Court.
Old judgment of the Supreme Court, my lord.
That I am not a party. It's only amongst them.
No, he pointed out somewhere about this being
that is that I had pointed out initially, my lord. We are assumed that it is so interpreted, which is not the Supreme Court decision. Annexure A14. I'll take your lordship. Before that, could I take your lordship? So 1 second, that company is no longer in existence. Page 156 of the rejoinder. Rejoinder reads. Miscellaneous petition, 156 of the writ petition.
And my lord, if the Supreme Court's status quo is coming in the way, he has to go to the Supreme Court, get that clarification. My lord, as against the status quo order of the Supreme Court, my lord, the revenue authorities cannot, my lord, enter the names of the present petitioner.
no, the revenue entries in the name of the petitioner
Never in the name of the petitioner, my lord, it is in the name of the original UBM CETA. My lord, that is the confusion, my lord, that is being created now only for the purpose of this. When, my lord, when did petitioner get title over these properties? My lord, that was, the question was posed, it was not answered. My lord, original UBM CETA has filed a suit. It is mentioned it in the schedule on page 240.
The scheme suit is by.
Yes, my lord, by the original UBM CETA. He said, I don't know who they are. My lord, in the body of the plaint, very first paragraph, it is mentioned, it is by the trust.
Public, that's filed by public.
My lord,
in
it is
Goa.
filed by the
Their
trust.
suits
My
are
lord,
all dismissed.
my lord, this
Kindly
is,
see page, your lordship, kindly see page 156 of the writ petition.
my lord, your lordships may go back to the plaint.
minute.
The second paragraph in the
156,
plaint.
what he's saying will be answered there, 156 of the, and with it in his own matter.
My lord, if-
156, my lord, in the middle, it is clear. In the middle, my lord, about in the middle, it is clear. Your lordships get that, my lord, that UBMCIT, despite having met the legal death, it was dissolved. And what is talking about them till today, my lord? Under the Indian Companies Act, is still alive under BPT Act.
Please come to this. Come to paragraph, page 156 of the rejoinder.
In his own petition.
my lord, that is not my petition.
Look at page 156.
And even 151, your lordship, his own contention, your lordship may see, my lord.
No, let him answer
Yes.
that, so that things will be
Very
clarified.
well.
156 of the rejoinder.
156 of the
Writ petition.
writ petition.
One minute.
That miscellaneous number 56 of 87 order.
Please. Page numbers have been.
Page number 1, internal page 13 of the order.
156.
156.
Writ petition. That is why in 1988 Supreme Court they say, my lord, Supreme Court says, this is what it Supreme Court says.
Let
my
him,
lord.
let him read that.
Yes, yes.
Do you get it? 156?
Yes, ma'am, yes,
It is clear that UBM CETA, despite it having met a legal death
Very good.
under the Indian Companies Act,
Yes.
is still alive under the BPT Act and can independently function as a trust to the provisions of the BPT Act, and it ought to have registered. It ought to have been registered and also registered accordingly under the such act.
And,
So this, there is a finding on this, that it is registered.
and
under
MFA confirms it. MFA says it, we are registered in MFA.
Let him come.
Very well.
So that will, yes.
My lord, your lordships may kindly come to the plaint, my lord, on one page, page 141 of the rejoinder. Page 140.
No, because this miscellaneous petition is filed by you, Church of South Indian Trust Association.
Yes,
So this is an order in your case.
yes, ma'am.
Yes. So now you cannot, so now I think you can't submit that to UBM CETA and this trust is not one and the same.
No, because, my lord, matter UBM CETA is litigating before the Supreme Court. My lord, that is the annexure M,
Page number?
page number 211 and 212
Huh?
of the writ petition, 211 and 12.
Where do you find them as parties?
My lord, the cause title is, because it is an interim order, my lord, it is in short, but this, my lord, is between the Church of South India versus the original UBM CETA. And that is why, my lord, if he disputes this, my lord, then I'm sorry, my lord, he has not,
Do you
he's
have
not
the
been.
petition copy?
Well, I can secure that.
RFA just now I pointed out, my lord. It's out of RFA of the division bench. What he's saying is incorrect. It's against RFA judgment. Kindly see, my lord.
My lord, if it is RFA judgment, kindly go to the plaint, my lord, which
Even the plaint also I have produced. I'll show the plaint.
page 142.
It's unnecessarily, kindly come to RFA.
142.
Church of South India Trust
Yes.
Association.
Yes, my lord.
Yes. Where is that UBMCI and all? It's
My
not
lord,
there.
your lordship
All
may-
wrong side submissions is making.
My lord, I did not interfere when he was arguing.
For
I
making
expect some,
incorrect submission.
my lord, some decorum, my lord, may I expect from my learned friend. My lord, come to page 40.
If you interfere, you'll not be able to complete his
My lord,
argument.
come to page 148.
Sir, you can submit it.
Page
And if
148,
there's-
my lord. Page
What is
148.
this Church of South India Trust Association?
My lord, that is the fourth respondent. My lord, come to page 40,
This is your,
Page-
then where do you get the name of the respondent?
page 148.
140?
148, my lord, the first paragraph of the plaint. The United Basel Mission Church of India, that is UBM CETA, that is the original. Page 148 of the rejoinder, my lord, I'm sorry. The plaint,
No, that's true. No, you went to the Supreme Court against an order that is. passed by
against this,
RA.
RFA.
That
RFA.
RFA order,
RFA order is also produced. my lord.
Pointing out.
620.
Lord, there only the names are mentioned. If your lordships could see the plaint, how they have described, the plaintiffs have described themselves. Let's
Let's see the plain.
148, my lord.
Yes.
Rejoinder.
Let's, 140.
148, after the cause title. The United Basel Mission Church in India. Lord, this is the original of District South Canara and Coorg, which will hereinafter be referred to as
No,
UBMC.
What it is stated in the, that's not the concern. Who are the parties in the suit?
My lord,
OS number
my
7.
lord, your lordships will get it further. The plaintiffs are interested in the trust properties belonging to UBMC of South Canara and Coorg and administered by defendant 32. In the first paragraph itself, page 148, my lord, your lordships will kindly see. The Constitution of the United Basel Mission Church in India, which is in two parts, the first part being the Constitution and the second part being the church rules of the said church. The two parts of this is printed in the Constitution in Kannada and are produced herewith being read as part of the plaint. Plaintiffs are interested in the trust properties belonging to UBMC of South Canara and Coorg and administered by defendant 32, United Basel Mission Church of
No, when you're saying United Basel Mission Church, Coorg and,
South
No.
Canara.
where from you get
My
it?
lord.
The original is not Coorg and,
No.
No, my lord, the original is only called as United Basel Mission Church in India, Trust.
and if the plaintiff is interested only in respect of that, why was,
No, in the schedule, your
he has
lord,
included the, why the other
Dharwad
properties?
properties also, which we are now concerned in the schedule. This matter is seized, my lord, by the Honorable Supreme Court, Annexure M, page number 211. Supreme Court says parties to maintain status quo with regard to entries also. And any, my lord, diversion to the order of the Supreme Court, your lordships may kindly come to this small compilation of annexures which I just handed over, my lord.
So before that, one more thing you
No,
clarified.
my lord,
With regard to their registration, with regard to their.
My lord, all that, my lord, is they're trying to deviate the case in some other direction.
Their registration, you have filed several cases, you have withdrawn. So ultimately,
My
their
lord-
registration with regard to the so-and-so is upheld.
Even if the registration is upheld, that does not,
Are you concerned with it if they have nothing to do with these properties?
yes, my lord, that is the point. That is exactly my point. My lord, your lordships may kindly come to the compilation, my lord, I will simplify everything. My lord, the first one is the part of Annexure B, which I have produced. The page number 2, my lord, is part of Annexure B. Here, dates your lordships will find. First is 19/3/1940, and it says trust deed, Hindustanadalli United Basel Mission Church, Madras Ilaka. This is the entry. Then the second one, my lord, is 24/6/1955. Takraru means objection, my lord. United Basel Mission Church of India Trust Association, Hesaru Kammi Madi. That means removing their name. The next column, the Church of South India Trust Association. My lord, this is entered in 1955 in the name of the fourth respondent. My lord, after this, the name continued. Suddenly, my lord, your lordships may kindly come to page 4.
Yes.
Page 4, this is page 71 of the writ petition, annexure B again, 24/11/2020. My lord, my name and the name of the original UBM CETA is reflected for all these decades. Here, suddenly, my lord, in 2020,
Where is your name?
my lord, the first page I read out, page number 2, the Church of South India on the right side column. My lord, the 1955 order,
Page number 2 or 1?
page number 2, my lord, of the,
Yes. Where do you get your name?
my lord, this on the right side, my lord, in the 24/6/1955 order, the first name is United Basel Mission, the original UBM CETA. The right side, my lord, is Church of South India. Lord, these alphabets are quite similar to.
Yes, that's what I'm understanding.
That is why, my lord.
Yes.
Then page 4, my lord. 2020, I'm sorry, 2020, first time petitioner got the names entered. On basis of some documents, my lord, may not be the question here today relevant. Whatever it is, they, my lord, gave the 6 names.
So all the trustees' names are entered.
Yes, first time in 2020.
Because of Supreme Court order.
I'm trying to correct it. My lord, I'm trying to correct certain submissions, my lord. Now, suddenly, my lord, in 2020.
According to you, the first time the entry
Yes.
of the petitioner.
Yes.
Is on 24/11/2020.
Yes, my lord, I stand by it. And the first time they made an application and the names were entered. My lord, this one, page number 6, your lordships may kindly see. I produced the Supreme Court order and contended that it goes against the order of the Supreme Court. Supreme Court says maintain status quo. So recording the Supreme Court's status quo order, the names, original names are restored. That is all has happened. My lord, if this is tried to be questioned, my lord, Supreme Court has to clarify, my lord.
No, from 1934, according to you, from
55.
24/6/55 till 2020, your name was continued.
Yes, my lord. First time this application is made to enter them, their names of the trustees.
Synopsis, what they say is not that.
My lord, that belongs to UBM CETA, original UBM CETA. Wherever it suits them, my lord, they rely upon the original body. Where it doesn't suit them, they say it is some other body. I'm not a party to that case.
His writ petition challenging that is dismissed. My name is entered illegally. Kindly see, my lord.
My lord, I will answer all the questions, my lord. I will answer all the questions, provided my learned friend waits for a while.
2020 first time, why it came? Because Supreme Court order made me trustee. It is not first time. Because I was appointed, 1 to 8 are appointed as trustees. We produced the Supreme Court order. My name is in 2020. He doesn't want to say about the Supreme Cort order, which have been.
My lord, I will
repeated.
answer
No, 1 minute, my lord.
all the contentions, my lord, all the contentions he has raised, I will answer. My lord, for the purpose of clarification, page number 629 of the rejoinder, the name of the original UBM CETA is reflected at serial number 25 as a respondent. 629.
This is a scheme suit.
Yes, my lord. And this is the judgment of this honorable court in RFA, which is now seized by Supreme Court. Then, my lord, your lordships may kindly come back.
That is Germany, my lord, not India.
Represented at the
Germany.
Lord, it is represented by. Then.
How can this be registered as a society in India? Somebody represented by a person from Germany.
My lord, it is represented by a chairman who is residing in Germany. My lord, your lordships may come back to this compilation, my lord, which I pointed out. My lord, then there is a miscellaneous case filed for appointment of trustees. My lord, I have produced the entire annexure. In this, my lord, kindly come to page number 12. This is an order dated 27/8/2004. My lord, petitioner so and so, number 3, 4, all of them. One Srinivas so and so requesting for their appointment as trustees to the church. Your lordships will find it on page 13. My lord, on page 12, name of the applicants, and on page 13, my lord, requesting for their appointment as trustees of the United Basil Mission Church, not of Bombay, Karnataka. Then, my lord, this matter ended in this fashion.
And this is on 38/2004.
My lord, this is miscellaneous 18 of 1990.
1990. According to
1990.
them, their trust is
1990.
registered when?
Which one, my lord?
That the Karnataka,
Bombay, 1954. 1954.
application for registration of UBM Sita, Bombay, Karnataka as public trust. That is on 20/12/1954.
Yes. 1954.
This is of 1990.
The original UBM Sita is registered, my lord, under the Companies Act in 1934. Then, my lord, your lordships may kindly come to page 17. This is the final order passed by the district court. Lord, this is annexure F in the writ petition. Your lordships may kindly go to the operative portion. My lord, paragraph 12 on page 29. The trust is constituted for the benefit of members of the Christian community. Hence, it is necessary that only Christians can be appointed as trustees to the trust. The petition was filed in 1990. Thereafter, persons who are interested have made applications and have come on record as parties to the petition. There is nothing on record to show that the present petitioners and respondents are not suitable persons or they have adverse interest against the trust. Therefore, I feel that all the requirements of section 47 of the Bombay Public Trust Act are fulfilled and it is necessary to appoint the trustees. Lord, it doesn't mean that they are appointed as trustees under section 47, my lord, for the reasons the petition under section 47 of the Public Trust Act is allowed. Does not say that these petitioners or respondents.
According to you, no, as per this, they're appointed to the to that trust.
UBM Sita, original UBM Sita. Because the cost title, my lord, your lordship.
Is represented by somebody else in the respondents, array of respondents.
My lord, this
This
miscellaneous.
order will have some sanctity.
This miscellaneous petition is by the original UBM Sita, and this petition, my lord, your lordships may kindly. Then what happened, my lord? Matter reached up this honorable court in the next annexure, page number 33. This is annexure G, my lord, page 179 in the writ petition. My lord, the division bench of this honorable court, page 37. The second paragraph, the respondents made an application under section 47 to appoint them as trustees to the vacant post. The trial court has allowed the application. My lord, the trial court allowed the application stating that they have to be appointed as trustees. They are not appointed as trustees, my lord. There was a separate procedure, my lord, which follows. Then the appellant's content, then thereafter, my lord, it says in view of the order passed, the 39, page number 39, in view of the order passed, the district court appointing respondents 1 to 8 as trustees is valid and binding. My lord, this is actually erroneous, but however, my lord, matter was taken up to the Supreme Court. Supreme Court also says the next annexure H, my lord, page 187 in the writ petition. I have called it out at page 40 here. The second paragraph. In the present case, application was filed by respondents 1 to 8, appointment as trustees. The application filed by respondents 1 to 8 as appointment of trustees was before the repeal. They have been appointed as trustees by the district judge. Lord, this went on continuing. This is the mistake which has happened. So that is so far as trustees are concerned. Lord, even if they are trustees, the property belonging to UBM Sita petitioner Bombay, Karnataka, my lord, it is not there on anywhere in record. Then the Supreme Court, my lord, the next annexure, what I have produced is.
According to you, which is the trust now, as per in this, which is the UBM Sita or this Karnataka?
Well, at Bombay, Karnataka, that trust has come into existence only in 1954.
No, who is this petitioner here?
Well, it is trying to take advantage of similarity of names by saying that it is part.
Petitioner is not, if you look at it, it is a contention of the petitioner that the Bombay, Karnataka is registered. This is what is upheld.
1954.
But that is upheld.
Yes, my lord, even if it is upheld, property is belonging to that trust. My lord, that
Original trust, if you look at the other order,
Well,
it says
that-
that it is a company.
that company is litigating before the Supreme Court, Annexure M, page 212, 211 and 12. My lord, that is the scheme suit which resulted in dismissal of the suit, reversal by the High Court. Now matter is pending before the Supreme Court. In the scheme suit, the original UBM Sita is a party. It claims the property belongs to it. And my lord, I am litigating against it. My lord, all the church properties in South India are managed by the fourth respondent, including Sri Lanka. My lord, only Dharwad cannot be given to some other body. My lord, if there is any doubt, my lord, about the veracity of the Supreme Court's interim stay on page 211, clarification, my lord, they have to obtain, saying that I am not a party or I am a party. My lord, when it suits them, they claim to be original UBM Sita. When it does not suit them, they say I am not a party to the litigation. And what has happened here, my lord, is only that the earlier names, as on the date of the Supreme Court's interim order, are ordered to be maintained. How is it erroneous, my lord?
No, according to your fourth respondent society, they are not the original, original UBM Sita. Then why are you fighting against them?
Because I am not fighting against them.
You have carried the matters in appeal. You have questioned their registration.
My lord, that was insofar as the trustees and all, even I wanted.
You have nothing to do because that is not the original UBM Sita, and whatever it is, that
My lord, even assuming that I have fought against the trusteeship, how will this property come to that trust, my lord, instead of the original trust? That is the question, my lord, I had.
No, you're only concerned with the properties and the trust. You say this trust is not the original trust. They are only taking the similarity of the names they are fighting. In that case, when you're fighting with the original trust, according to you, how are you concerned
Yes,
with
my
any of
lord,
the
I am
things?
not concerned with them or their properties, but as long as the Supreme Court has ordered maintaining status quo.
But that you fought so much of litigation against them.
No, but then the matter has reached Supreme Court in 2012 in another matter. There is an order of status quo. My lord, the other orders are 2020 in the Supreme Court. That is unconnected to the properties. That is only with regard to trusteeship.
So the status quo order is in the year 2012.
2012,
With regard to
matter is still
properties.
pending.
With regard to properties.
Yes, my lord. That
You
the
say that
page.
their entry is in the year 2020 for the first time.
Exactly. How? Well, 2012, from 2012, I have, there is a benefit of interim order. Supreme Court is protecting both the parties, original parties. Who is this third party who has come in 2020 and seeking a claim?
Where is the 2020 order of status quo? 2012 order of
Our
status quo.
page number 211, Annexure M, or writ petition. Writ petition. I have produced it here for, in my compilation also I have produced it. This is an interim order. If there is any, my lord, any doubt about this,
So this order is granted when? The first order.
first order, my lord, 10/5/2012. Petition was called on hearing today. And this matter is still pending. And the next page, my lord, in my compilation, I have produced the extension order also. My lord, anything coming in conflict with this order, I am not sure, my lord, the revenue authorities can overrule the status quo order of the Supreme Court, or this court can grant stay of Supreme Court's status quo. The next page, my lord, in my compilation, I have produced the extension order. The last page of my compilation.
Yes.
So this order, my lord, this matter is still pending. Interim order is still in force. If there is any doubt about it, my lord, that clarification has to be obtained in the Supreme Court. Not before the revenue courts or before this honorable court. And then, my lord, that original submission, that there is an alternate remedy. The words used in the full bench is The 136.2 is subject to 136.3. My lord, subject to means that it has to be subjected to the provisions of 136.3. It cannot be said optional, it is my choice and all that.
Kindly see synopsis page number 9 of mine, my lord. I don't know why he is making such incorrect submissions. Page, and I produced the order, page number 9. He made a submission from 1940. His name is there. My name came for the first time in 2020. If that is the case, if it is a fact, my lord, I will withdraw the case. It's a false statement. Now, please sit down.
Let him
Please,
show,
no, no, again.
that there is Bombay
No,
Karnataka
this is
in the bracket.
unfair on your part. You made
My
a
lord,
wrong submission.
this is the, my lord, he's
Kindly
only
come to
trying to
page
bulldoze
9,
the
my
court
lord.
or stop me from arguing.
No,
It has been
unfair.
happening from the
Let us be
afternoon. my
fair
lord.
to court.
Let him show that there is
Problem
Bombay
is like,
Karnataka.
However loud the one council is, I will still hear the other council.
My lord, page 9, your lordship.
Yes.
Very well. 1940 UBMCA was reflected, my lord.
No, he has filed some document.
Yes.
Instead of looking at your synopsis, you can refer to his document and. You
Same
can
documents, my
submit.
lord. Same documents I'm
No,
referring
let
to.
us see, let us see.
No, just kindly see one thing. Let me clarify one thing, my lord. His name, he says, is entered till 2020. Our name came to be entered first. That is not correct. He filed a writ and it is dismissed. That's why I'm requesting your lordship, kindly come to synopsis 9, which he doesn't produce. Kindly come to page 9. Kindly come to page 9. Now let me go slowly, my lord. 1940 was the first time record of rights was entered into. We came into existence in 1954. Our names were entered on 24/6/1985.
So pausing here for a minute, please come to his memo. Page number 2.
This is, my lord, Hindustanadalli United Basel Mission Madras Ilaka. We are now, what have we got to do with Madras Ilaka?
This is with respect to the scheduled property. This is with respect to the scheduled property. my lord. It is-
Madras Ilaka is the 3rd district, my lord, Malabar. My lord, it was divided after 1940, 1/11/1956 reorganization of states. Till then we were one. That's what the Supreme Court gave, my lord, 88th order. Reorganization of states was 1/11/56. Till then we could not call ourselves as Bombay Karnataka. And number 1. Number 2, BPTL Act itself came in 1950. So in 1940 we could not have registered.
So for this, all Malabar, Mangalore, and this
All belong
are
to
under
one company.
Under one.
That's what I've given in my synopsis.
So correct. All are under one.
Yes.
When is that? When they are separated from?
1954, we had to register. No. It was BPTL Act came only to Bombay Karnataka area, not to others. Others they mixed.
The Public Trust Act, I'm saying. Now, this United Basel Mission, church, whatever it is, it is covering all these regions.
As a company,
Malabar
it covered.
region, Mangalore region, and
As
this
a
one.
company, it covered. I have said that in synopsis.
So when that company, where like it is separated for this, for the other 2 places.
Well, that's why 88 Supreme Court again, my lord. Why I'm saying what happened in 1950.
Then how they are registered thereafter?
Which, my lord?
For Malabar and Mangalore.
Well, they have got in their own way as a church. That's what the Supreme Court has committed.
This is all one, isn't
No.
it?
It does not. Therefore, my lord, in 54, your lordship may kindly see for the first time, 1954, when Bombay Public Trust Act came into force, our name was entered, which he challenged, saying, enter my name. They rejected. It came up in miscellaneous. It came up in MFA. That's what I'm saying. Let me come to synopsis number page 1 itself, my lord. Your lordship may kindly see. Kindly come to page. I'm also saying in 1935, when there was no reorganization, everything was one. Kindly come to my synopsis, page 2. 1935 to 1939. Bombay Public Trust Act came.
You're all under one umbrella.
That was the company, it is dissolved. It's no longer there. It is dissolved. It doesn't exist. That's why I read out that it's natural, died a death under the Companies Act, and we are separate. The observation of the court, I read out to your lordship. I'll read out again. What he's saying is some Switzerland company is made. It's not the chairman's name and address. That's the Swiss company, because this Basel was a Swiss company when it came to India. Just 1 minute, my lord. Kindly see. 1954, under Bombay Public Trust Act, we registered ourselves separately for Bombay.
Who are you?
Oh, the society registered under the Societies
Where
Act.
is the society?
Under 1954 Bombay Public Trust Act. That's what is Annexure A2. A2. We are registered as a separate society under Section 18 of PPTL Act because we had to mandatorily do it.
You have to do it. First of all, so and so persons were part of that society, earlier society. Earlier company.
Yes.
Now in view of this act, you have to register as a public trust.
No, separate.
So separately you have to register. So who are the earlier people? Who are these people?
No, these
Who is the
people,
DAB?
that's why, my lord, these people came into existence in 1941. 1988 Supreme Court had given, my lord, in 1941 they came into existence. Church of South India. They were now they made a congregation of their own. Now, your lordship, 2 minutes, let me just finish, my lord. We registered ourselves under Section 18 of Bombay Public Trust Act, giving all the Bombay Karnataka area properties, my lord, under 1950 Act, because 1956 also there was a bifurcation. That application, my lord, they made an application to enter their names along with our names for all the properties, which came to be rejected, by the Assistant Charity Commissioner. Against
Why can't this society, being aware of this 2012 petition that is pending before the Supreme
We
Court?
have got nothing to do with that.
No, you have nothing but your properties are
No,
part
no,
of
no,
it.
no, my lord. That is a totally unconcerned, my lord, because though they have mentioned it,
Rightly, wrongly.
after that,
No, rightly, wrongly, your properties are part of the scheme suit.
my lord, your
That may be, let's say that it is wrong. Let us assume that it is wrong.
I get that.
But Honorable Supreme Court said, in respect of those properties, there has to be a status quo.
Parties are directed.
So how come the revenue authorities can overcome that?
My lord, it's not question of overcoming that at all. What Supreme Court said is, parties are regarding the subject matter of the property was, my lord, the appointment of a scheme, not properties. Therefore, kindly come to page 9 of my synopsis. Kindly come to page 9 of my synopsis. Kindly come to page 9 of my synopsis.
Definitely, it is not as simple as it is submitted in the senior counsel.
It is very simple, my lord. Straightforward it is.
My lord, Supreme Court says.
1 minute, again, let me please.
Maintain status quo in all
Coming
respects.
to that maintain status quo, 1 minute. If that was the case in 2018 before the Supreme Court, why you did not say that there were properties involved? Why you did not say, why did Supreme Court dismiss your SLP and held that I am the trustee for all these properties? My lord, it's a simple question is that. 1940 and 1985, my lord, after 4.5 decades, they challenged this. Why did you challenge if your name was there from 1940? He challenges it in 1985. His name is added. Let me again. He wants to interfere. His name is added on 24/8/1987. My lord, we filed an appeal, and his name was deleted. Kindly see Annexure 2, Annexure Z, and they said you have no right because under Bombay Public Trust Act you cannot claim to have merged with the trust. There is no provision. That is why, my lord, Annexure Z came to be passed against him, for which he filed WP number 14631 of 87.
I remember all the
Then, my lord, it was dismissed, and my lord, the order of Assistant Commissioner became final. Then, my lord, when we were appointed as trustees for the property, the Honorable Supreme Court's order, your lordship may kindly see, said that we are the trustees. Based on that, we made an application in 2020, not because our names were not there, to change the names of the trustees, not to enter first time. Our names were already entered, which was confirmed. Our names were entered on, my lord, 24/8/19.
The other judgment which is relying on.
My lord, our names were entered for the first time on 24/8/1987. That continues, that became final. Names of the trustees shown there were dead. New trustees had to be appointed, therefore new trustees were appointed, their names have been entered. It is not that we had some dispute was there, or there is a determination of any list. Dead persons' names are removed, persons whom Supreme Court appointed as trustees are entered. That's all. There is no question of any other determination, because mutation entry dated 24/8/1987, he filed writ petition, it was dismissed, it became final. So it's only a mutation entry proceedings, that's all. That too, my lord, it is administrative. It is under section 132 of the Karnataka Land Revenue Act. When there is a court, 132 of the Karnataka Land Revenue Act, once there is a court order or decree, you have to pass orders accordingly. There is no question of giving notice, hearing. That's how our names were entered in 2020. Not that his name was deleted, my name was entered. No. My name was entered in 87, WP filed, WP dismissed. That's it.
Both
both of you give your written arguments.
Yes, my lord. Once last.
And he has filed a declaration suit in 1993 and dismissed. That is at page number 16. OSC has filed declaration suit. That is also dismissed.
Please give a
Yes, page 16, synopsis, page
written
16.
submissions.
Yes.
Written submissions.
Ah,
to the
well,
case on
that
record.
he have filed OS 719 of 1993, dismissed. Very,
My lord, Annexure B, my lord, is the mutation entries starting from 1940. My learned friend has produced it as Annexure B. For the first time, my lord, it in 2020, petitioner's name into bracket, Bombay, Karnataka is mentioned only for the very first time. Till then, my lord, it is the original UBM CETA. My lord, if there is any doubt on both of us, my lord, the government advocate will verify from the fact that Annexure B contains original UBM CETA's name till 2020. My lord, the dispute was with me and the original UBM CETA, not with the petitioner. Petitioner, my lord, suddenly for the first time in 2020, my lord, let him also show how these properties, Dharwad properties, have come from original UBM CETA to this trust. There is no record.
we'll file a written submission.
Please, both of you file.
Very well.
Heard, reserved.
Heard, reserve.
Can I make a move, my lord? I have to go to the airport.
Yes.
Highly obliged, my lord.
Call the next case.
Seal number 77, list 1. Nilopan. Nilopan. Nilopan.
List is
77, list 1.
This is matter next week.
Next,
78.
78. J. Shetty. Self-as partner.
Kindly have it tomorrow.
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 It's
77, my
70.
lord.
Huh?
27 is also some urgency.
You appear for the petition. Yes. Tomorrow may not be possible. Day after tomorrow is that MFA matters are coming.
Monday,
Monday.
please.
No, not Monday is holiday, Tuesday. 78 also Tuesday. 79.
Please, ma'am. I'm from 79. The matter is a writ of mandamus directing the respondent to register the FIR matters.
Your Lordship, 2512 they have filed. 2512, your Lordship, we have inquiries, we have to preliminary inquiry.
Still
all
they have
we are
not
supposed to-
registered the FIR also.
So we will not even give a breathing time to the police also. The moment you give the complaint, come to the court and similar order, there should be a direction to the police.
15 days the time has been given.
First of all, what is the role of this court in directing the police? You have your own remedies.
Yes.
Go file a private complaint, go before the higher authorities, give them a representation. At least you should do it before coming to the court.
We have given the representation also.
Not to the police, to the higher ups. Why he is not doing it?
To the higher officer also, I have given.
Kind of similar orders and passing in every case, interfering with the activities of everybody is not right.
To SP also, we have given the letter also.
Consider the complaint and direct respondent to register.
Yes,
How can we say you register the complaint?
It is a.
They have to conduct inquiry. They should find out
Yes,
whether it is right or wrong.
Yes,
The
Similar
present
matter,
petition is passing the following prayer. I will not pass any similar orders. When it is a grievance of the petitioner that the FIR is not registered. If the police are not registering the FIR, the remedy available to the petitioner is to file a private complaint before the magistrate and also or to give a representation to the higher ups showing the inaction on the part of the police. He has given a complaint on 25/12/2025 and files a petition on 9/1/2026. A mandamus cannot be issued to the police to register the FIR. It is for the police to inquire into the same. And if it makes out a cognizable offense, then only the police will register the complaint. In that view of the matter, the directions as sought by the petitioner, this court cannot grant. However, the police are directed to consider the complaint dated 25/12/2025 in accordance with law. Yes.
Seal number 80. Deshankarji Dharwad, 80.
Please, my lords. Petitioner is the husband, my lords, age 60 years.
wife, my lords, of the lapse of 30 years, my lords, she has filed a maintenance petition
How
on
much
the
is granted by the court?
interim maintenance of 8,000 is granted, my lords.
What is your income?
My lords, no income, my lords.
What do
no-
you do?
Actually, I'm not doing anything, my lords. I have several problems, health problems and everything, my lords.
Something you have to pay to the wife. Why not?
But my lords, they are not complied to show my income also, my lords, and they have deserted me. And after lapse of 30 years, two children, my lords.
Have you contested the matter?
Please.
Have you contested?
Yes, miss, I'm contesting for interim maintenance, my lords. 8,000 they have awarded.
What I'm saying,
Yes.
for the interim maintenance, did you tell the court that you don't have any income?
Yes. No, but my lords, I have filed my objections also, my lords.
But you didn't appear before the court?
I have appeared, my lords. I have
Let's see the order.
Please.
What did the court say?
Annexure E, my lords, at page number 32.
Page number?
Page number 32 is the order, my lords, annexure E. My lords, relevant para will come at page number 40, my lords. And the daughters are married, my lords. Now they are married also.
Who performed the marriage of the daughters?
My lords, they are, including me, we have performed, my lords. But they deny everything.
The respondent has not filed a statement of assets and liabilities. So if you don't file the assets and liabilities, then an adverse inference has to be drawn. Why did you not file? If you are, whatever you're saying is a
Yes,
genuine and a correct statement.
But
File your statement of assets and liabilities.
I have filed my objections, my lords, for this.
As
Yes.
for the judgment of the apex court in Rajneesh versus Neha,
Yes.
there has to be statement of assets and liabilities, or else the court can draw an adverse inference.
Please,
If you want stay, half of the amount, or else I'll not grant stay.
please, I'll deposit.
The writ petition is filed, questioning the order passed in I number 3, whereby the court had granted maintenance of an amount of rupees 8,000 per month. When counsel for the petitioner submits that the petitioner is aged about 60 years, and from the last 30 years, they are residing separately. And now the application is filed seeking maintenance. The court, without considering all the objections that were filed, had granted an amount of rupees 8,000. Considering the submission, they shall be stay on the condition that the petitioner shall deposit an amount of rupees 4,000 by 5th of every succeeding month, and the arrears also at 4,000 shall be paid within a period of 12 weeks from today. And the petitioner shall take out hand summons on the counsel appearing for the respondent before the trial court, and shall file a memo to that effect by 10th of February. Either the petitioner fails to pay the amount as indicated above, or he fails to file the memo, on either of the conditions, the stay granted by this court stands vacated. Yes, next.
Please.
Number 81, Al Hussain Shaliban, M.A. Patan.
In the first week of February. Yes, 82.
Serial number 82.
Day after tomorrow, my lords.
Not possible this week. If you want, it's only in the February first week.
No, my lords. He was here, my lords, just now, my colleague.
You are not the counsel.
No, it's my colleague.
Tomorrow. Yes, 83.
Day after tomorrow.
Day after tomorrow is MFA day.
Please.
Yes, 83.
Serial number 83. 83 adjourned. Serial number 84. Girish Shalwan.
Petitioner is the defendant, my lords. Suit is for possession, my lords. Defendant's application for court commissioner is rejected, my lords. Rejected on the ground that there is another suit, and the PT sheet was referred in that suit, my lords, and it is correct. And the property.
Yes, file caveat. Anil Kale.
Anil Kale.
In the name of Mr. Anil Kale, petitioner is the land counsel. The petitioner will serve the copy on the counsel for the respondent. List it on Friday. Yes, 85.
Seeking for stay, my lords. Seeking for stay.
Friday.
Friday in preliminary hearing. In preliminary hearing, my lords.
What is that?
In preliminary hearing, my lords, on Friday.
Yes, 85.
SP Habballi, 85. SP Habballi.
What is this writ petition? You have the copy?
Please, Your Lordship. They are seeking for compensation, Your Lordship, as illegally they have, police have detained the petitioner. As 107 proceedings are initiated by the magistrate, your lordship, Taluk
Notice
magistrate.
the so and so. One,
One and-
respondent number one.
Please, 1 and 2 also, your lordship, police.
Oh, second is the police.
Please.
One and, but he is, it's in a personal capacity. How can you take notice for him?
But in
One,
bottom, your lordship, police.
ex-CGP takes notice.
Please.
Issue notice to respondent number two. This is matter after service of notice.
Seal number 86. Shant Bhatapati.
My lord, tomorrow, my lord. Tomorrow, my lord.
Yes, tomorrow,
Please.
87. All these matters will repeat again, 87.
87.
My lords, interim application was filed before the trial court for production of document from the possession of the bank, my lords, that is plaintiff. The same is came to be rejected without considering the objection, without numbering the IA also, on very same day. The IA is at page number 28, my lords. And the matter is being posted on day-to-day basis, my lords. I am seeking interim stay of the proceedings.
Now let's see why the stay just like that. Please read the order.
Order is at page number 46.
Read it.
This case is filed by the plaintiff for recovery of the amount of rupees 7,80,000 for 39 rupees, along with the interest from the defendant number 1 and 2. The plaintiff has stated that defendant number 1 has borrowed PMGP loan and executed documents regarding the same. Therefore, when the loan is availed under PMEGP scheme by the defendant number 1 and 2 jointly, and the PW1 has already produced the detail of PMEGP loan account number and the court and to the court, and the same is marked as exhibit P28. There is no necessity for this court to issue direction to the plaintiff to produce the detailed saving account number so and so. In addition to the same, there will not be any
What is the
transaction.
purpose of this?
My lords, they have taken margin money from my saving bank account. My lords, that is my case. And they have issued DD, and at paragraph number 3 of the plaint, they say that they have issued DD to the defendant number 2. I am defendant number 1 in this case. And he has remained ex parte and he has not came before the court. And I don't know what is the status of DD. I'm asking the transaction details of the DD, and they have directly sent it to the defendant number 2 and defendant number 2. That is at page number, paragraph number 3 of the plaint, my lords. Relevant portion, my lords.
Issue notice to the respondents. Issue notice in the next state of hearing.
Much obliged.
Yes.
Number 88. Appanur Nagaraj.
Please, this is a writ of mandamus, lordship, directing the respondents not to insist upon the license
Recreation
from the
club.
petitioner. Recreation.
Earlier matter, your lordship, recreation club. I'll get instructions whether they are interfering or obstructing the petitioners or not.
Directing the respondent. License, yes, get instructions.
Please, your lordship.
This matter on 29th.
29.
Yes,
Please.
90.
Seal number 89. Shuprasad Shantan Gold. 89.
We will see. This is matter on 30th.
30th.
Yes.
Seal number 90. Yes, party.
Challenging the decree passed by the Waqf Tribunal.
Interim order is there in this.
Yes, my lord, sir.
Yes, this is matter in the on 19th of February. Interim order earlier granted is extended. Is
Not
91.
extended. Seal number 91. Sharadam Patil.
Next week minutes.
Huh?
Next week minutes.
Why the memo is moved?
Minutes
for this
side,
matter?
other side is not there, minutes. Ladkan sir is not.
No, what is urgency for the memo?
No, minutes. What has happened, minutes? So, what matter, minutes? There are two properties, minutes involved in this matter.
Whatever it is, no, what is urgency for a 2018 matter in
Now-
2025?
Yes,
to
now
be-
minutes, one land minutes in survey number 426 is concerned minutes, it's one agriculture land minutes. Now in view of the order minutes, not, they are trying to alienate the suit property minutes. There is a burial ground, Muslim burial ground is.
Tomorrow, 92.
Please, oblige.
One. Seal number 92. 92. FU party.
Yes, this in the month, this on, in the month of March, interim order.
March.
If it interim order is there, extend. Yes, next.
Seal number 93 adjourned. Seal number 94. K. Anand Kumar.
Petitioner. The petitioner challenging the judgment and decree, my lord, passed by the trial court by annexure C, my lord.
Not kind permission. Proxy
Compromise
council, my
petition.
lord. Kindly have it on Monday or Tuesday, my lord. Proxy council, my lord.
This is
In-
on,
On submission.
on 3rd, we will hear on 3rd.
All annexure Kannada, my
February.
lord. 2 weeks time I filed the.
Yes, 2 weeks.
2 weeks.
May I request for a
There
date?
may
my
be
lord?
extension, my lord.
Interim order. Seal number 95.
Interim order is there.
There, please.
Any date may be fixed, my lord.
We'll list this matter on 24th of February.
Please.
24th. Seal number 95, DS Sankti. DS Sankti.
Please, my lord. In this case, I have deposited 25,000 as per the directions of this honorable court, my lord. There was a delay because meanwhile the case was referred to mediation. There is a hope by the petitioner she may join with the company of the petitioner. Meanwhile, she refused to join. And as per the directions, I have deposited 25,000. The interim maintenance is fixed 3,000 each, 12,000 since the petitioner is a conductor. Age-old father is there and he is suffering from disease. Total amount is
You have
60.
whatever it is, you have, what is the order? Subject to the condition, the petitioner would deposit 25,000 before this court on or before 17 to 20.
Yes, there is, it is true. I have not deposited well in time, my lord. Now I have deposited, that may be considered because meanwhile the case is referred to mediation, my lord.
Yes, this is matter for the month of March. Interim order if any is extended till then. Yes.
Number 96. 96.
Please.
Vendu.
Please. Lords, this is a suit for specific performance, my lords.
Bihari.
I'm a plaintiff, my lord. Suit for specific performance.
The respondent.
Rajesh Bihari.
You have a stay?
No, there wasn't stay, my lords. On the last date of occasion, due to inadvertence, it was not extended. Please.
Yes, 97.
Great.
97. 97.
Petition filed by wife of the enhancement of interim maintenance.
14%.
14%.
You have an interim order in your favor?
Please.
You have an interim order in your favor?
No interim order. Interim maintenance manati.
Who moved this one? This memo?
I filed memo for it.
This is matter on 18th of February. No
18th
representation for the respondent.
Please.
Yes, 98.
Seal number 98. Please, Ketan Munwadi.
Writ petition is filed seeking transfer of clubbing of two suits, my lords. One from senior division to junior division. Two suits. Both suits have been filed by myself itself. May I pass on this chart, my lords?
Monday or Tuesday, my lord.
Huh?
Monday or Tuesday, my lord.
Why?
Council on record is not.
This is
Friday.
matter on 2nd February.
My lords, may I seek before that, my lords?
Before that may not be possible. Yes.
Please.
99.
Seal number 99. 99. Abhishek C. Patil. Avinash Bankar, SCGP. Avinash Angadi.
But then this, my lord, the NCISM has rejected, my lord, the permission of the college, my lord. Now, my lord, earlier, my lord, on the basis of the interim order, my lord, for the academic year 25-26, my lord, they were running the college. Now, my lord, they have filed an IA, not seeking, my lord, permission to write the exams.
Well, how many years is the course?
My lord, 5 years.
So we will, next 5 years, we will every year, we will permit them, we will declare the result, we will do that and this.
My lord, the first case has to be.
This matter we will hear. I will not continue these kind of.
Abhishek.
Yes, tomorrow,
My lord, on Tuesday, my lord.
Tuesday.
Obliged. Grateful.
Tuesday.
Yes, look at it.
99
If
Tuesday.
interim order is there, extend in all the matters.
Interim orders.
Yes.
27. 100. Arjun, 100. 101. I Patil.
Again, parole, your lordship, I don't have a copy, your lordship, kindly next week. Again, parole, your lordship, don't have a copy next week, your lordship.
Two matters on 11th of February. Yes, 102.
102.
Writ of mandamus, lordship, seeking for the release of the compensation amount, lord, of the land acquisition, lordship.
Yes. What are your instructions?
My lords, as a beneficiary, we have deposited the amount before the SLAO, my lords.
To pay the dues statutory on the delayed principal service.
Amount is deposited before the respondent but to your lordship.
Yes, what are your instructions?
Your lordship, will consider, your lordship, within 4 weeks, 4 weeks, my lord.
Representations at Annex E and F, my lords.
Petition is filed, seeking the following prayer, extend the prayer. Is the case of the petitioner that the properties belonging to the petitioner are acquired by the respondents. And they have failed to pay the compensation to the petitioner. Petitioner has submitted repeated representations to the respondent, and the same were not considered. He has given a written representation to the SLAO on 25/9/2025. It is submitted that in spite of the repeated representations dated 25/9/2023, the second respondent had failed to consider the same, which made the petitioner to come before this court. And counsel appearing for the second respondent submits that. Third respondent submits that. You appear for third respondent.
Third respondent.
Third respondent submits that. Third respondent is a beneficiary and they have deposited the amount is with the second respondent. Let it, HCGP appearing for the second respondent submits that. They'll consider the representation of the petitioner and will take appropriate action within a period of
4 weeks. 4 weeks.
Take it 8 weeks, but do it, please, within a period of 8 weeks, considering the submission of the respondent, the writ petition disposed of, the second respondent shall dispose of the representation, shall consider and dispose of the representation in accordance with law, dated 25/9/2025, within a period of 8 weeks from the date of receipt of the copy of the order, accordingly disposed.
Grateful.
Yes.
Rajuddin Ahmad, AGA is Rajuddin Ahmad.
Parole matter, Your Lordship.
Parole matter.
Parole matter, Your Lordship.
Same
Yes,
advocate.
no, different advocate, Your Lordship.
Tomorrow. Yes, next, 104.
104 urgent. 105. Ayuva Patil.
This is also parole?
Parole.
Yes,
Parole.
tomorrow. 106.
Your Lordship, in this 106.
106. Kulkarni Sangram.
Milord.
Sangram Kulkarni.
Yes, my lord. My lord, the impugned order is passed under section 73(9) of the GST Act, my lord. My lord, under section 75(4), if any adverse order is to be passed against any SSE, an opportunity of personal hearing is mandatory, my lord. In this case, that opportunity has not.
At the act.
Yes, ma'am. And this is a judgment where of this honorable court, my lord. My lord, section 75 subclause 4, an opportunity of hearing shall be granted where a request is received in writing from the person chargeable with tax or penalty, or where any adverse decision is contemplated against such person. So, my lord, giving an opportunity of personal hearing is a mandatory condition if an adverse order is to be passed, my
Where
lord.
is the order?
My lord, annexure K is the order, my lord.
Page number.
Page number 243. My lord, this is one of the grounds, my lord. Another important aspect is the petitioner has set up 2 solar plants, one with,
We'll see tomorrow.
my lord, interim order because
There is an.
Tomorrow as a first
in
case.
preliminary hearing, my lord,
Tomorrow as a first case.
obliged.
Yes, next. All these MFAs listed, give it one day. Next Thursday, we will add this. Huh? My lord.
Serial number
109,
20,
my lord.
serial number- I requested serial number 20, my lord.
No, no, it is not. I am referring to the first list, sir. Your matter will be called.
My lord.
Yes.
Serial number 109, my lord.
matters?
Serial number 109, my lord.
109,
your lordship. In the first list, my lord, the accident of the year 2015, my lord, he has sustained head injury and he is not in aware.
All these MFA matters I'm taking up on Thursday. Already one advance list is already uploaded.
In IA hearing it.
No, we'll hear it. We'll hear it on Thursday.
Yes, ma'am.
Yes.
My lord, serial number 63 and 65 were passed over.
1 minute. Yes. Call these matters. Express.
List 2.
Yes.
List 2 orders matter serial number 1. Jaya Gatchinvat, AGA.
I'll take necessary steps, my lords.
First.
Serial number 1. The respondent number 1 has expired. I need to take steps.
The petitioner shall take steps against deceased respondent number 1 within a period of 2 weeks, or else the appeal shall be abated, the petition is abated against the first respondent. Yes,
My lords, in next matter, my lords, I have already done the needful, my lords.
In
Wherever, my lords, the
1.1.
furnishing of process fee is concerned,
the council submits that the needful is done. 1.2,
I have done the needful, my lords.
needful is done. 1.3,
Yes, my lords, needful done.
needful is done.
Awaiting, my lords, service of notice in respect of.
If intermodal is there,
Intermodal,
extend.
intermodal.
Yes, next two.
Serial number 2.
Please, same, awaiting notice.
List after service of
Intermodal, my
notice.
lords, needs to be extended.
Intermodal earlier granted, if any, granted.
Serial number 3.
Extended. What
My lords,
about
for the
this?
petitioner, my lords, the respondents are, even though they are necessary parties, they are not contesting in the matter, my lords. I would like to, the notice may be dispensed with.
Take that.
My lords, also, since it's a 2008 matter and direction matter, there's an urgency. It may kindly be kept tomorrow for hearing, my lords. My lords, the date in the trial court also is tomorrow itself.
File seeking dispensation of notice to respond number 6 to 9, 12, 13, 15 to 19, 23, 26, 29, 31, 33, 34. The move is taken on record and notice to the respondent is dispensed with.
Yes, sir.
This matter on 2nd of February.
May I make one submission? I appear for respond
Uh,
number 10. That is, the plaintiff is before this honorable court and stay of his own suit is granted in this writ petition, my lords. And what is called in question is, my lord, an order dismissing application seeking recall of PW2. So, my lord, that can be disposed of, my lord, at a prior date.
Not possible. Next week, the court is going on matter on 6th of February.
6.
Yes, 4.
Serial number 4.
My lords, interim order may kindly be extended, my lord.
In all that it will be, nobody has to mention that.
Much obliged, my lords.
Four.
There is
Till number
a
4.
notice, my lords, is awaited.
List after service of notice. Interim order earlier granted is extended.
Interim order needs to be extended.
Yes, yes.
Great.
Serial number 5. 5. Sujit.
A week's time, a week's time to serve. a copy.
My lords, I have filed wakalat for respond number 2, my lords, in this case.
What do you want?
List after service of notice.
List after service of notice, that's what I said. 5.
That's why I'm submitting.
List the matter on 17th February. Yes,
17th
5.
February. Serial number 5.
Please, my lords, a week's
5.
time to comply, my lords.
Sujit.
A week's time is.
In the
So,
meanwhile, my lords,
respond
interim
number
order
1 has
granted.
expired, my lords, in this case.
Yes, 6.
6.
My lords, interim order may extend.
What I'm saying, don't ask, it will be extended.
Extended.
Yes, 6.
Serial number 6.
I'm appearing for the respondent. I'm appearing for the respondent number 1, my lord. Today I filed the wakalat for respondent
So
number.
and so submits that his instructions to file the wakalat. If interim order is there, extended. Yes, list it in the month of February. Yes, 7.
Serial number 7.
To comply the office order, 13/12 to them, some more time may kindly be. Because they are making arrangement to.
Maintainability of the writ petition. The petition at the request of the land council, the petition, 2 weeks time is granted. Yes, 8.
Serial number 8.
My lords, interim order extension.
Yes.
Serial number 8.
List after service of notice, interim order earlier granted is extended.
Anyone else? Serial number 9. Mrutyunjay.
This matter on 3rd of February, 8, interim order is there, extend. 10.
I have filed application for vacating
Kindly
interim order,
next
my
week.
lord. This is a Lok Adalat decree or challenged.
Lok Adalat order, your lordship, wherein my signature is not at all there, your lordship, in that order. Kindly next week, your lordship.
Sir, on 29.
Please, your lordship.
29. 10, 29.
Yes.
11. Adjourn. 12. List to 12.
Yes, the list is matter and on 12th February.
12th February.
Yes.
Preliminary hearing matter. Serial number 13. KL Patil.
Challenging the order passed by the trial court with regard to custody of the child. Both were assailing the same order, madam.
12, 13 and 13.1. List on
Day after tomorrow, madam.
5th February.
In first list, madam. And last.
All of you keep on
Hello,
giving
no, madam.
memos, this is how it will happen.
Last occasion, madam, is what listed in first list, my lords. Because of the request made by the other side, it was adjourned. And now it is listed.
We'll see.
Please.
14.
14. Sri Ashwini Lopan. 14.
Kindly be taken up on
Fresh
27th.
matter, I think let it come tomorrow.
Tomorrow.
Tomorrow in the
please.
21st.
Yes,
First
15.
list. Serial number 15. B group matter,
Listed in the month of, on 26th of February.
26th
16,
February.
interim
Seal
order
number
if any
16,
extent. 16.
Bhagyashree. Bhagyashree NB 16, NB Kanvi.
In 3, my lord, I moved the memo, my lord. It is the pertaining to interest of the gratuity amount. The balance gratuity amount is paid and interest is not paid. Hence, it's stays obtained.
Court officer, tomorrow.
Tomorrow,
Please.
21st.
Is 17.
Seal number 17.
Interim order has been
Shall we
challenged.
mark
Interim order of maintenance has been challenged in this case. The trial court proceedings are stayed, my lord.
Yes, this is the matter on 18th of February. Interim order earlier granted is extended. Yes.
Seal number 18. Kolkar.
Also
Harvey.
on 19th February. Look at
19th
it if
February,
interim order is there
extended.
extended.
ನಮ್ಮ
Seal
ವಕೀಲ
number 19. Seal number 19.
ನಮ್ಮ ವಕೀಲ ಅವರ ಅಜ್ಜಿ
Sen Rajendra.
What is he saying?
Serial number 18, sir.
Huh?
Serial number 18.
Huh.
But kindly we extend this stay order, sir.
Extended.
Please, sir.
That's 19, I appear
Seal
for
number
respondent.
19.
No, respondent.
You moved or they moved?
Milord's interim interest stay has been granted by this court.
Who moved the memo?
Petitioner.
Petitioner, I think.
Yes, the interim order, look at it, if interim order is there extended, list this matter on
Not extended.
23rd.
23rd.
Is 20th?
Obliged.
20?
Seal number 20.
My lord, in this petition land is commercially converted land, my lord. My lord, the respondent with 2 and 3 say Neeravari Nigam Limited, they sought to purchase 65 cents of land. My lord, they have not purchased, they have not acquired. They encroached to 53 cents of land in 3 years ago. They have not, 3 years ago, in 22, October 22, my lord. So far, they have not paid a single pie. It's a commercial converted land.
What are your
Well,
instructions?
There are
The first hearing itself, there is a serious concern letter written to the chief secretary. Kindly see the first
There
hearing
are,
of the order.
there are few subsequent developments pursuant to the order of this honorable previous orders. Not some, may I seek any first week of February pursuant, I'll get those orders also. Matter was referred to chief secretary in this
My
in this
lord,
case.
it's already written. My lord,
Yes, ma'am.
3 times, my lord, I'm practicing
Illa,
Bangalore. 3 times I came and left, my lord. Went back, my lord, without
They
reaching.
appear online.
No, my lord, there is some distance. Last time I could not do it.
Matter as part heard on 2nd of February.
No,
By that time.
my lord, because petitioner is suffering, my lord. He has got a huge debt and he is paying huge interest, my lord.
But
At least,
even if any order is.
in fact,
passed,
my lord,
you
there is a
expect-
direction. My lord, chief secretary has already sent a letter saying them to deposit the money, but they are not doing it, my
Where
lord.
is that letter?
Kindly see, my lord. They themselves have produced a memo. Yeah, I told really, what happened was, sorry.
Please, let me look at the chief secretary's correspondence.
They have filed a memo on 12/9/25, my lord.
59. 59.
12/9/25, they have filed a memo with along with a memo for production of documents. The first documents, my lord, is no.
What is the direction of the chief secretary?
My lord, the first, I would like. This is the first time, my lord. This is one more sad case where respondent number 3, Karnataka Neeravari Nigam Limited has made use of the land of the petitioner, but has not paid payment of compensation. This is the first sentence. But it's a lengthy order. The last
What is
sentence.
the crux of it? Please tell that.
The last one, my lord, the government of Karnataka to look into these matters and take appropriate action, since the conduct of the respondent number 3 would have a very big bearing on the reputation of the state government. But there's a serious concern expressed to the chief secretary. After this, they filed a memo. This is note, my lord. It says, after 3 paragraphs, DC has conducted the price fixation advisory meetings on 3/7/24, 19/12/24, 8 so and so date, and finally issued wide letter 25/2/25, has fixed the said land value at 61,13,760 and solatium of 100%, totaling 1,22,27,000 so and so. Kindly see. As there is no provision under the direct purchase for payment of solatium, this is the crux of this matter. They don't want to pay solatium. The provision says that. That's the subject matter requisition. I will argue the matter. Kindly see. After detailed inquiry, the following decisions were taken. MD KNNL to show cause as to why action should not be taken against him for causing the delay in this dispersal of compensation in this case, despite taking possession of the land and execution.
What is the letter dated?
It's on 9/9/25.
9/9/2025 minutes.
So 9/9/25.
9/9,
2025, my lords.
then consider the petition submits that on 9/9/2020.
They only filed this memo.
9/9/2025.
State government is.
The chief secretary
Chief Secretary.
has addressed a letter to the,
The DC, ma'am.
Huh?
Deputy Commissioner.
to the deputy, to the, which respondent he is, the second respondent. It is submitted that the petition's land is acquired and so far they have not paid the compensation in spite of the repeated, in spite
Second
of the
respondent
letter
DC,
issued
ma'am.
by in spite of an order passed, in spite of the proceedings issued by the principal, the chief secretary. The second and third respondent, the respondents 2 to 4 shall get specific instructions by Friday or else the writ petition will be allowed.
Lords.
My lord,
My lords,
so
may I
many
make
other
one
things on the
submission?
merits of the
My lords.
grounds, my lord. At least the interim, it will give some relief.
My lords, may I make one
For the
submission?
last,
Oh, but you understand, you,
at
both
least,
you want,
no, my lord, at least admitted amount if they release, my lord, subject
It
to
is
the
not.
result of the writ petition.
It is not admitted.
If they release.
It is not admitted. My lords, I'll make submission. May I seek on 2nd February?
how, when all these things are happening, why are you keeping quiet for the last 4 months? Somebody's life,
I understand, my
property.
lords. We totally understand.
Whatever it is, you can't, because you have money, you should pay some money or the other, please get instructions. What if, no, for example, if that land fetches about, I mean, let's say it's 50 rupees, pay 25 rupees as an interim measure, that for that you get instructions, Friday I'll pass orders. Or
Right.
else, looking at it, I'll pass half of the amount, I'll pass an interim
My
order.
lords, that is, for that also, my lords, may I request for 2nd February? Not more extra time. 2nd February, please.
I'll pass an order on 2nd February.
My lord,
Take-
and it is on the
I'll
top
make
of the
some-
list, my lord.
Yes,
Because
on the,
three times,
as a first case on 2nd February. Yes, next,
Top of the list.
much of it.
yes.
Seal number 21.
For the respondent,
Mediation will open.
on 29, 26/9/25, this court passed an order to file an affidavit. Till today, they have not filed affidavit, and the execution is stayed by this honorable court, my lord.
This is matter tomorrow.
Tomorrow. The first.
Yes, 22.
Seal number 22. Seal number 22.
This matter,
Patil, Madhapur.
list on 12th February.
12th
Get it interim order if any
12th.
is done.
My lords, pass out
Password matters
Pass
will
out
come
matter.
Tomorrow.
Tomorrow, ma'am.
Tomorrow in the first list, let it be like another top, another list I said, this also on the top of the list.
Please,
The
please.
password matter.
Please, my lords.
My lords, may I request, my lords, we have been given the statement of objection, the complete copy today, my lords. May I request on the next week, serial number 1, my lords, regarding the Sirsangi Trust, my lords, the copy is handed over to us, the complete copy today, my lords. So I need to seek instructions, my lords. May I request on next week,
My
my
lords,
lords?
it's regarding maintainability of the petition.
It is maintainable, my lords. The very fact is that, my lords, there is not even one single line forthcoming in the statement of objection saying that the trust is private trust, my lords. So there is,
Already I have passed an order on the last week, considering all this. So that objection is not required.
My
That
lords,
order, that number.
I've
you please
already
give them.
furnished the order.
my lords, may I request next week, my lords, not.
Why next week?
Because I
Already morning
need,
that bargain is over. Now, when the petition is not maintainable, not maintainable.
we will make submissions with regarding this one. May I request next week, my lords, any date next week, my lords.
Already it was listed yesterday, my lords.
It was not, my
second-
case was not listed yesterday, so it was listed today.
Matter on Wednesday, no further time will be granted. All those matters, passed out matters on Wednesday, no further time.
Please, my lords.
ಯಾವ Wednesday? ನಾಳೆನಾ?
ನಾಳೆ.
ನಾಳೆನಲ್ಲ?
No.
Next week ಅಂತಿದ್ರಲ್ಲ. Wednesday is tomorrow.
Tomorrow ಅಂತಿದ್ರು, Wednesday ಅಂದ್ರೆ ಮುಂದೆ ಹಾಕೋದಿಲ್ಲ.
Wednesday, ಅದೇ.
ನಾಳೆ
Confusion.
ಬರ್ತೀನಿ.
ನಾಳೆ ಅಲ್ಲ ಅಂತಿದ್ರು.
ನಾಳೆ.
Wednesday ಅಂದ್ರೆ ನಾಳೆ.
ನಿಮ್ ಕೇಸಲ್ಲಿ ಕೊಟ್ಟಿದ್ದೆ.
ಹಾ.
Court officer?
Final hearing madam.
Top of the list as the other matters.
ಹಾ, top of
Oh,
the
top of
passed
the
over.
list on the other matters ಅಂತ ಹೇಳಿದ್ರು.
ಇದ್ರ interim order ಇದೆಯಾ?
ಇಲ್ಲ ಇಲ್ಲ ಇಲ್ಲ
ಇಲ್ಲಲ್ಲ? ಇಲ್ಲ ಅಂದ್ರೆ ಇಲ್ಲೇ ಬರುತ್ತೆ.
ಇಲ್ಲ ಅಂದ್ರೆ
Interim order ಮತ್ತೆ ಚೇಂಬರ್
ಇಲ್ಲ ಇಲ್ಲ ನಾಳೆ
ಇಲ್ಲೇ ಬರುತ್ತೆ ಡೇಟ್ ಕೊಟ್ಟು.
ನಾಳೆ ಸರ್.
ನಾಳೆ ಆಮೇಲೆ ಇದು ಟಾಪ್ ಆಫ್ ಲಿಸ್ಟ್ ಅಂತ
ಭಾಳ ಅದಾವ್ರಿ.
tomorrow.
ಸರ್ 63, 66 ಪಾಸ್ ಓವರ್ ಆಗಿದ್ದು ನಾಳೆ ಟಾಪ್ ಆಫ್ ದ ಲಿಸ್ಟ್.
ಟುಮಾರೋ ಅಂತಿದ್ರು ಮತ್ತೆ ಎಲ್ಲ ಮ್ಯಾಟ್ರು ಟುಮಾರೋ ಅಂತ ನಿಮಿಷ ಎಲ್ಲ ಮ್ಯಾಟ್ರು ಟುಮಾರೋ ಅಂದಾರ ನಮ್ಮ ಮ್ಯಾಟ್ರ್ ಒಂದೇ ವೆನ್ಸ್ಡೇ ಅಂದ್ರು
ನೆಕ್ಸ್ಟ್ ವೆನ್ಸ್ಡೇ ಅಂತಿದ್ರು.
ಇಲ್ಲ ವೆನ್ಸ್ಡೇ ಅಂದ್ರೆ
ಮಾಡ್ಕೊಳ್ಳಿ.
ಇಲ್ಲ ನಡೀತಿ ಬಟ್ ಯಾಕಂದ್ರೆ ಎಲ್ಲಾ ಮ್ಯಾಟ್ರು ಬೆಳಿಗ್ಗೆ ಟುಮಾರೋ ಅಂತ ಅಂದಾರ ಇದನ್ನ ಯಾಕಷ್ಟೇ ವೆನ್ಸ್ಡೇ ಅಂತ
ಮೊದಲೇ ಹೇಳಿದಾರ್ರಿ ಈಗ ಆಮೇಲೆ ಮತ್ ನಿಮ್ ಜೊತೆ ಮಾತಾಡಿದ್ರು ಮತ್ತೆ ಅದಕ್ಕೆ ಮೊದಲು ನನ್ಗೆ ಅಂದಿದ್ರು ಪಾಸ್ವರ್ಡ್ ಮ್ಯಾಟರ್ ಅಲ್ಲ ರಿಪೀಟ್ ಅಂತಂದಿದ್ರು.
ದೇ ಸಾಟ್ ಫಾರ್ ಅಡ್ಜರ್ನ್ಮೆಂಟ್ ಫಾರ್ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಅದನ್ನ ರೆಫ್ಯೂಸ್ ಮಾಡಿದ್ರು, ಇಲ್ಲ ಅಂತ ಹೇಳಿದ್ರು, ವೆನ್ಸ್ಡೇ ಅಂತ ಅಂದ್ರು. ಹೌದಿಲ್ಲ?
ಕ್ಲಾರಿಫಿಕೇಶನ್
ಒಂದ್ ವಾರ ಕೇಳಿದ್ಕೂಲಿ ಬುಧವಾರ ಅಂತಂದ್ರು.
ಪಾಸ್ವರ್ಡ್
ಯಾವಾಗಾದ್ರೂ ನಡೆಸದ
ಕ್ಲಾರಿಫೈ ಮಾಡ್ಕೋರಿ.
ನಾಳೆ ಆಗ್ಬೇಕು ನಾಳೆ
ಕ್ಲಾರಿಫೈ ಮಾಡ್ಕೊಂಡು ಇದು ಮಾಡಿ ಕ್ಲಾರಿಫೈ ಮಾಡ್ಕೋರಿ.
ಕೇಳ್ತಾನೆ ಕೇಳ್ಬಿಟ್ಟು ಹಾಕ್ತೀನಿ. ಯಾವ್ದಿಲ್ಲ ಮೇಡಮ್ ಇದ್ದಾಗ ಅಷ್ಟ ಅದು ಇನ್ನು ಬೇಕಾದಂಗ ಮಾಡ್ರಿ ನಮ್ಗೆ ತಕರಾರು ಹಿಂಗ್ ಹಿಡಿದು ಬಿಡ್ತಾನ ಅಷ್ಟೇ.
ಕ್ಲಾರಿಫೈ ಮಾಡ್ಕೊಂಡು ಇದು ಮಾಡಿ ಸರ್ ಪರವಾಗಿಲ್ಲ.
ಏನ್ ಮಾಡೋಣ್ರಿ
ಮೇಡಮ್ ಸೀರಿಯಲ್ ನಂಬರ್ 63, 65 ಪಾಸ್ ಓವರ್ ಆಗಿದ್ದು ನಾಳೆ ತಗೊಂತೀರಾ ಟಾಪ್ ಆಫ್ ದ ಲಿಸ್ಟ್?
ಸಿಗ್ನೇಚರ್ ಮಾಡಿಸ್ತಾ ಇಲ್ಲ
ಬೆಳಿಗ್ಗೆ ಟುಮಾರೋ ಅಂತಂದ್ರು ಅಷ್ಟಾಗಿ ವೆನ್ಸ್ಡೇ ಅಂತಂದ್ರು.
ಫೋನ್ ಮಾಡಿ ಕೇಳಿ ನೆಕ್ಸ್ಟ್ ವೆನ್ಸ್ಡೇ ಅದು ವೆನ್ಸ್ಡೇ ಅಂತಾರೆ ಅಷ್ಟೇ. ಇಲ್ಲಿ ಟುಮಾರೋ ಅಂತಿದ್ರು
ಎಲ್ಲ ಮಾಡ್ರು ಟುಮಾರೋ ಅಂತಾರೆ ಬೆಳಿಗ್ಗೆ. ನಮ್ಮದೇ ಕಷ್ಟ ಬಂದಿಲ್ಲ.
ಕೋರ್ಟ್ ಆಫೀಸರ್
ಸರ್
63, 65 ನಾಳೆ ಅಲ್ಲ ಟಾಪ್ ಆಫ್ ದ ಲಿಸ್ಟ್ ಪಾಸ್ಡ್ ಓವರ್?
ಹೌದು ಸರ್.
63, 65 ಅಲ್ಲ ಟುಮಾರೋ
ಪಾಸ್ ಓವರ್ ಆಗಿತ್ತು
ನಾಳೆ
ಟಾಪ್ ಆಫ್ ದ ಲಿಸ್ಟ್ ಅಲ್ಲ? ಪಾಸ್ ಓವರ್ ಮ್ಯಾಟರ್ಸ್ ಟಾಪ್ ಆಫ್ ದ ಲಿಸ್ಟ್ ಅಂದ್ರಲ್ಲ?
ಹೌದು.
ಟುಮಾರೋ ನಾಳೆ ಬರುತ್ತೆ ಸರ್.
ಓಕೆ ಸರ್.
ಟಾಪ್ ಆಫ್ ದ ಲಿಸ್ಟ್ ಅಲ್ಲಿ.
ಓಕೆ ಸರ್, ಥ್ಯಾಂಕ್ ಯು.